Please mention the extension of interim orders only. Last week and yesterday we could not take up any application. Release, yes. To be mentioned, release, correction.
Inclusion of an application seeking modification of order.
No, come back next week. We'll dispose of some applications. No, all applications come back next week. We are too heavy on the list.
WPLRT petition.
Release, yes. On what ground?
Because there is extreme urgency.
No, sorry, refused. Yes.
Inclusion of a WPLRT, my lord.
No, we are not taking up to this week. Come back next week.
Mentioning for to be mentioned, my lord.
My lord,
Your
why?
lordship has passed an order last week.
For correction of that?
Yes, my lord.
Yes.
My lord, this matter, my lord, lordship, can you remember? Lordship, one custody matter, lordship, sent for mediation, my lord.
Yes.
Mediation, my lord. Lordship appointed Olivia Ganguly as one of the psychiatrists, along with one of the.
Yes.
Mr. Honorable Justice Subroto Talgudi, one of the mediator, my lord. My lord, now he has intimated me over a mail to all parties, my lord, for a formal extension of, because it is yet to be
It will
completed.
appear as to be mentioned. Please write to be mentioned and just.
With my lords, kindly, my lord, there is a sheer urgency, my lord. What is the urgency is, my lord? The learned single bench has today is the date fixed before the learned single bench appearing as item number 19. My lord, what has happened, my lord? My lord,
we have to dispose of some matters for
the matter was appearing in the list yesterday also, but today it is out of list, my lord.
Cannot be unless.
My lord, it has been, my lord.
Automatically does not go out of our list. Definitely not. We must have passed.
But I've annexed the list.
No, we don't know. Yes.
My lord, there is a share. Kindly, my lord, kindly accept mentioning, my lord. Any date, my lord.
Just telling repeatedly. Why are you repeating? Please don't. You're an officer of the court. Please. Listen, let us do some matters. Yes. No, refuse. Call on the list.
Item number 1 for judgment.
For respondent, my lord.
Here the ordering portion is probably longer than the judgment itself. So we are reading it out.
Yes.
Accordingly, FA number 57 of 2023 is partially allowed, thereby modifying the impugned judgment and preliminary decree dated such and such, as well as the schedule of the plaint of the aforementioned suit to the following effect. We have used section 153 to amend the plaint also, because as we indicated, the following effect. These are the changes. A, the schedule of the plaint as well as the impugned decree of the aforesaid suit is amended to the effect that in item number 1 of the schedule, premises number 138 shall be read as 138A. B, in the ordering portion of the impugned judgment, the following portion shall be deleted. That portion is regarding the accounts. Where direction of accounts was given, that portion is deleted. We have mentioned that portion in italics. Instead, the following will be incorporated. The plaintiff to get a preliminary decree for accounts against the defendant numbers 1 to 3, which will incorporate the income earned as well as the expenditure incurred by the defendant numbers 1 to 3 in respect of the suit property. In the event of failure on the part of the rest remains. In the event you fail within 60 days, then law will take its course. C, the following shall be included immediately after the first paragraph of the ordering portion of the impugned judgment and decree, that is, after the suit be and the same is decreed in preliminary form. This will be incorporated. It is because the shares were not declared. It is hereby declared that the plaintiff and the defendant number 4 respectively are entitled to 1/4 share each in the suit property. The defendant numbers 1 to 3 jointly are entitled to a half share of the suit property, which comes to 1/6 share each of the said defendants. D is the timelines for making amicable partition of the suit properties by metes and bounds and for rendering accounts will be deemed to commence from the date of this judgment. No rest to cost. We have tried to salvage as much as possible.
Yes.
So grateful.
Yes, in view of the submissions of both of you. And both sides were very cooperative. Thank you.
So grateful.
I wasn't there.
Both sides. We started by saying both of you, then we said both sides. Yes, next.
So grateful.
Much obliged.
Yes. Report achievement.
I'm not sorry to. Today is the date before the learned trial court. If this can go to the internet, then we can.
We'll go to the internet, but no decree can be drawn up so soon.
But order,
no, our orders are uploaded immediately. I mean, today itself at least.
Much obliged.
Lordship. Or item number 2, Lordship, I'm for the appellant.
Item, this is item number 2, it? Yes, there's an office report regarding the records not being placed out. That's why it has been sent by the office. We're just looking into it. It transpires from the report of the learned Chief Judge, City Civil Court at Calcutta, and the Assistant Registrar, Roman 2, first appeal section, that the records of the case are lying in this court. Full stop. Accordingly, the department is directed to trace out the records immediately and to furnish a report in that regard before the Registrar General of this court. Full stop. The learned Registrar General is Registrar General of this court after a fortnight from date. Full stop. Next para. The learned Registrar General is requested to take urgent steps to ensure that the papers, that the records of the matter are traced out at the earliest.
Item number 3.
Mr. Banerjee is on his way and the notes is with him, my lord. Kindly grant me half an hour to file.
My notes of argument, my lord.
You are for the appellant.
The appellant.
The appellant the appellants file the written notes of arguments. Full stop. However, even today the respondent is not
Kindly
prepared with
grant me
the
half an hour time to file.
written notes of arguments. Full stop. As a last chance to the respondent to file the written notes of arguments, the respondent is permitted to file such written notes during the course of the day. Full stop. It is made clear that in the event the respondent fails to file such written notes of arguments, the matter will be decided in the absence of such written notes. Full stop. Hearing is concluded and the matter is reserved for judgment.
Grateful.
Item number 4 with 5.
Item number 5.
It are written notes. Yes, Akshay Binimay and Pawan Kumar. Written note.
In the Pawan Todi appeal, Lordship, Mr. Banerjee has requested if we be permitted to rely upon one judgment. We have put them on notice in advance. It is just on the Morgan
New
Stanley
judgment
para-
at this stage.
we have Lordship.
Have you gone through those judgments? I mean,
Yes, we have.
You have to.
Morgan Stanley
So
para
Morgan
30 that the
Stanley, they
requirements
have
of the
Morgan Stanley.
They made the submissions. They are
Yes,
taking
ma'am.
that point.
You have to add anything to Morgan Stanley? Morgan Stanley should have been written otherwise or something like
But I did not say that.
No, if you want
Based on
to.
the judges, I did not say that.
Otherwise, Morgan Stanley is settled.
That's settlement. But
Morgan
I've got-
Stanley and Chadda's case, I mean, you have two sides.
It is more or less settlement, but your lordship is the appeal court, so your lordship.
Whether this will apply or not, that will. And your written notes,
Well, my
yes.
little notes in both the matters.
Mr. Thakkar, your
First chance and last chance in the course of the day, please.
uh,
This is my lord.
you are for Pawan Kumar too.
Pawan Kumar.
And you, Akshay Binay.
Only one thing, may I just point out, I've given both the notes, I've made a list of dates. If it any of your lordship's benefits, your lordship will look into it, or will not look into it.
But have you personally checked up, Mr. Rai? It is not argumentative in any manner.
No, it is not. That is
Then it's fine.
reflecting there, So if your lordship,
You can circulate.
I'll leave it, I think the notes are good enough. Or else, this is basically, for a final hearing. this list of dates.
We didn't finally hear it.
No, final hearing as in after affidavits will be correct for this. But not a problem,
We heard it for the purpose of ad interim order.
I didn't hear,
No, your lordship heard it.
No, heard it at length.
No, your lordship has heard it at a. But I'm saying this would be beneficial if it's after written objections. So, this would take the entire thing into account. That is what,
No,
Objections here or written objections in the court below.
in the court below, I'm saying that.
Correct. Here, your
Oh,
lordship
acha.
heard
That is why I said, I will not. No, that's what I'm saying, Your lordship is not hearing it.
very well.
second round of hearing in this matter.
No. The written notes of arguments filed on behalf of the appellant in FMAT 64 of 2026. And the composite notes of arguments filed by the respondents be kept on record, full stop, on the prayer of learned senior counsel appearing for the appellant in FMA 250 of 2026, the said appellant leave is granted, comma per, leave is granted to the said appellant to file its written notes of arguments during the course of the day. Hearing is concluded. The matter is referred.
Morgan Stanley will not reflect in my notes. So, my lord, will kindly hold that I have at least tried to distinguish it in the facts of the case and that it is supported by the judgment, which has been
Definitely, we have to apply that in the facts of the case, and we'll say that.
Yes, only my lord, that I have dealt with it. This much.
Sure.
Your lordship, only one will an index of the paper books will help your lordship. Then we'll file it in course of the day.
Is there a paper book, formal paper?
No, those no. But for the
Index of the
stay-
documents.
index of the documents for the.
Stay application.
Yes, please.
Then we'll file it
the-
by law. We'll file it.
Well, because that
Just the
is what I was trying to indicate in my list of dates, my lord.
So you can just your
Like, keep it
juniors
with your
can have a
lordship.
talk if there's something is
Not
common.
just an index. Only the index.
File it along with the written notes of
Okay,
Mr.
will-
Thakur. So if it comes together, it will be easier. for
That
us.
way we'll do. We'll do.
Your lordship, your lordship, I am also appearing on behalf of the respondent number 15 to
এই
17. Your
monitor
lordship.
চলছে না, আমাদের monitor
No,
চলছে।
your lordship, this matter, Mr. Arindam Banerjee is leading
One
me. Your lordship-
second, our monitor is not functioning. You don't know this matter. Obviously, this matter.
Apologies, your lordship.
Yes, Mr.
Lordship,
We couldn't even see, but we couldn't review you properly because we didn't know who you were. Yes,
your
now we
lordship,
can understand.
Mr. Banerjee is leading me in this matter. We are for respondent
Mr.
number
Dinda আছে।
15 to 17. Your lordship, we also filed the written notice of argument within the course of the day, your lordship.
Next,
And the appreciation.
you are for which party?
Respondent number 15 to 17 and item number 4.
And Mr.
Mr.
Banerjee,
Arindam Banerjee
Bengal Club. Bengal Club.
That should come.
আচ্ছা, আরেকটা line add করতে, the respondent numbers 15 to
17.
17 are also permitted to file the written notes of arguments during the course of the day.
Very
He keeps the written notes of arguments with him. Two matters he is not being able to file.
ওটা তো
Your lordship, I have just received now.
Next.
very good.
Thank you very much. 6. কি জন্য আসছে? Oh, assigned matter. This has been assigned.
Lord, I'm praying only not today, my lord.
No, we are not hearing the matter today. We are not.
If I just could request your lordship, my lord, there has been an urgency in this matter.
What is the urgency?
My lord, here, my lord, I am aggrieved by, my lord, myself, my lord, being administratively transferred to somewhere where, my lord, there is no vacancy for that particular post by the state. There, my lord, where I'm being,
There are more urgent matters in
I tell you, lordship, my lord, if
My
now
lord,
I'm
this is
released-
only a stopgap arrangement, only temporary arrangement,
that-
not permanent,
So if
my
your
lord.
lordship can, if your
Only
lordship
for the well-being of the students, my lord, in the school where he says.
very much is ready, my lord. May I just
Lord,
place this
I am
case, my lord,
Will
if I
appear
just
under the specially fixed matters because
if
assigned
I'm
matters
released,
list.
my lord, by now, my lord, if I'm released, my lord, my entire appeal will be infructuous, my lord.
My lord,
My
I
lord,
am
because I
praying,
am always apprehending the release. My lord, this is why I was just requesting, my lord. If your lordship
So we
fixes it,
cannot, hijack the other matters by keeping it.
my lord,
Putting it
follow,
on the
my
top.
lord. If your lordship kindly fixes it up day after or whenever,
No,
my lord,
we
if I
can't
just
fix
could
it
be
anyway.
protected by that
We have
particular
been
time.
accusing others. I don't know.
But if I just could, my lord, satisfy your lordship on the my lord, merit on this matter
Get
for
the
the getting
opportunity of satisfying us before we take up the matter.
my lord, for getting an interim order from your lordships. my lord.
No. If you could not get an interim order, have you
It
moved
was-
the matter ever?
My lord, no, my lord, what happens, my lord, before the honorable single bench, my lord, they filed a
Do you have a connected application here?
Yes, for injunction, for stay.
So very will direct that it to appear under the heading application. Let the applications in connection with the said with this matter, comma, which has been assigned to this court, comma, appear under the heading applications. We'll try to take up as soon as possible.
As your lordship.
First, it appear under the heading applications, then we'll see.
Great.
My lord.
Call.
Item number 7.
আগের order আছে? Says the appellant remains unrepresented repeatedly, comma, CR 1250 of 1989 as well as FMAT 3058 of 1988 are dismissed for default. Appeal টা আগে disposal হয়ে যায়নি তো? Are dismissed for default without any orders to cost. Interim order, if any, stands vacant.
Item number 8.
Same কি? Same. Number গুলো শুধু চেঞ্জ হয়ে যাবে। Same.
He appears for the
Oh.
Life Insurance Corporation, my lord.
Yes.
I have been instructed, my lord, no paper, no document is traceable in their office also.
With you.
Nothing. Not with me, because yes, there was some other learned advocate was there. There is a suit filed in the city.
If you can't find the papers of the appeal, we'll just dismiss it for default.
Nothing,
You are for the appellant.
my lord.
If you don't have the papers, the department does not have the papers, what's the use of keeping this matter as pending? If you don't have the papers, how will you be able to argue?
That is the position. My lord, I have been.
What is the appeal against that? Do you know that? You must have those records. Your appeal, you don't know what is the
My lord,
judgment.
the case is my
Not you, I mean your client.
My lord, I tell your lordship, my lord, this lady filed a money suit before the city civil court because her son, my lord, died in an accident in sea.
So you are challenging the
Decree.
compensation given to her. We would love to dismiss this appeal for you. Let her get the compensation.
My lord, your lordship, I leave it to your lordship. I have nothing to say. My lord, the policy was not accepted. My lord, within a few days,
এর
when the
রেকর্ডসটা আমাদের
proposal,
কোর্টে কোনো কি ইয়ে আছে? আচ্ছা ঠিক আছে, আমি একটা ডিরেকশন আমরা দিয়ে দিই so that the records can be traced out.
immediately after submission of proposal,
Learned counsel for the appellant corporation submits that no document pertaining to the appeal could be traced out. Appeal and the rule could be traced out in the office of the appellant. Fullstop. None appears for the respondent even today at the time of call. Fullstop. Next para. The office is directed to trace out the records of the present case and tag the same with the file. Fullstop. In the event the records cannot be traced out, comma, the office shall furnish a report in that regard within a fortnight from date before the learned registrar general. Fullstop. Next para. The learned registrar general, comma, upon getting such report, comma, is requested to ensure that the records are traced out immediately. This much. And to file a further report in that regard in court within a week thereafter, within a fortnight thereafter. Fullstop. As and when such report of the learned registrar general is furnished, comma, the matter be placed before this court under the heading to be mentioned.
my lord, only thing, my lord, learned advocate who filed the appeal, he is also no more in the world.
Next. If someone is appearing with you, just give it.
My lord,
আচ্ছা, এটা হচ্ছে ওই যেগুলো ডিসমিস করছে। Same.
Item number 12.
Same.
Item number 13.
Same.
Item number 14.
Same.
Item number 15.
অর্ডার আছে তো? Same.
Item number 16.
Your Lordship, I'm on behalf of the appellant. We seek a not today for.
An adjournment is sought on behalf of the appellants. Your application.
And we have of the respondent, one of the respondent not yet been served, and they are also.
No, we put it out of the list. Appellants, full stop, let the matter go out of the list.
Appellant also die.
Let the matter go out of the list.
Respondent also die.
If you ask for time, out of the list. Yes. Next. Give your names, ma'am. This is the second occasion when none appears for the appellants none appears for the parties at the time of call.
My lord, in that matter, Gautam Das on behalf of the appellant, he is coming.
No, then it goes out at least.
Coming? Yes.
Coming from where? His home?
No.
Outside the court or where?
Already.
Where is he? Please ask him. Where is he right now? Where is he?
He is in the room number 2, my lord. He is taking the dress and will come.
Wait. Pass over. 10টা মিটার বাদে ডাকবেন। 10টা মিটার না এই হ্যাঁ 10টা মিটার মানে এই ধরুন এটা কত হলো 17 তো 27 এর পর ডাক। নেক্সট।
Item number 18.
Lordship, I am on behalf of the appellant. Kindly grant short pass over.
Are you enjoying an interim order?
Yes, Lordship. Affidavit of
So pass over. Either you move the matter or you vacate the interim order and put it out of the place.
Lordship, kindly
No.
Lordship, kindly grant to.
Very well. Upon repeated requests, comma, learned counsel for the appellant reiterates his prayer for an adjournment, full stop. Accordingly, since the appellant is not willing to proceed with the hearing of the application, we vacate the interim order granted earlier and direct the matter to go out of the list. Next. Every day mentioning pleading with the court, mentioning, please take our matters, please take our matters, and
senior-
resolution every day, either resolution or you don't do the matter. We are very sorry. We are fed up with the bar. I am a member of the bar still, and I feel myself to have a part of this guilt. Please call on the next.
Senior is in.
No. Let your senior be wherever it is. Whoever is the senior.
19
We don't care.
appellant. There are two
Hey,
applications.
sir, please give your name. Yes, Mr. Banerjee.
There are two applications, CAN 3 and CAN 4.
Yeah.
CAN 3 is by us, my lord, the appellant. CAN 4 is by my learned senior.
What is the matter about, Mr.?
This my lord, challenging a eviction decree, my lord. Filed this appeal, my lord. Now, during the pendency of this appeal, my lord, possession was handed over. This is a petrol pump of Hindustan Petroleum Corporation. During pendency, possession was
They have handed over the possession to you.
No. I am the, my lord, I am HPCL.
I have
Possession was handed over under the orders of the court.
Eviction under what act?
This is a decree, my lord, for eviction. My lord.
I mean, premises tenancy act.
Yes, yes.
Premises tenancy- no.
Transfer.
Now, my lord, possession was handed over. Only, my lord, some, my lord, underground tanks are lying, but the possession has been handed over. Now, your lordship, my lord, directed the formalities be completed for making the appeal ready for hearing. They, my lord, mentioned the matter for an order that they have filed a, my lord, proceeding for, my lord, final decree in respect of mean profits. A miscase has been filed by them. So they prayed for, my lord, detagging of, my lord, the records so that, my lord, final decree proceeding may go on. Your lordship, my lord, December 1, 2025 permitted detagging, on the basis of which the proceeding has started. Now, my application is, my lord, modification of the order dated 1st December, my lord, to the extent, my lord, that
For retagging.
Now, for stay, my lord, of the proceeding, but I am not pressing for stay. I am only saying, like, you know, the normal, my lord, cases of partition, I am praying, you know, let the proceeding go on.
Final decree
Let
be
the final decree may not be passed. Let the proceeding be go on, and
Sir, right, we should do that.
only to that effect.
Because
my lord.
Final
in
decree,
partition decrees was if the final degree is passed, then nothing.
because execution will not be held. My lord.
No. Issue shall be
My lord,
decided.
one thing, my lord, kindly, my lord.
Appeal will proceed up to the final degree stage.
Appeal.
My lord, the
Sorry,
miscase
final
for
degree
final.
proceeding.
But only one thing, my lord, because this is now linked with my second matter. I'm sorry, my lord, I'm going to move it, but it's an application for expeditious hearing of the appeal.
This appeal. Yes.
And there are 3 persons who are 78, 80, and 81.
No, are the paper books and all ready? Or
Sorry,
we should, are the paper books ready? Everything is
Have been
ready.
filed.
They're filed.
Paper books have been filed.
Records have come out. Yes, we detect.
That is why, my lord, I was just humbly beseeching. So that, my lord, from
There are-
December 2024,
How many are above 70? 3
out of 9, my lord.
out of 9. So no.
2007 suit, my lord.
No, we look at the younger people.
My lord, I leave it to your lordship. That's why I said, my lord, I don't know whether I should. But, my lord, 2007 matter 2023 final decree, my lord.
No, this appeal is of which year?
Appeal is of 2024.
24.
And stay from
You have been
2024.
diffusing others, Mr. Rai. You should be consistent.
But I'm not getting anything, my lord. The order is only for not.
Understood. You are getting the satisfaction that the final degree mean profit proceedings will proceed.
Because if I
Can 4 is for appropriate order means
Early hearing of the appeal.
will direct it to appear in the monthly list of December 2026.
no, my lord, I told my
We can direct that if you want.
was aware.
Hoping that it will be before a different bench will curse us.
My lord, I'm just, my lord,
Mr. Rai.
it's very short point, my lord. That is why I was only on this, my lord. My lord, kindly was just 1 minute, my lord. Only 1 minute by the clock. My lord, suit where, my lord, my learned friend's client has not even opposed.
Not opposed.
My lord, they only took, they went there. Huh? My lord, the main opposition was from the sub-lessee. My lord, this is a petrol pump. So it was the licensee who was opposing. Licensee came, preferred and
What was the ground of eviction? I mean, 106 or expiry? 106. Yes, Mr. Banerjee, what is the ground of
We have taken the point of Thika, my lord. If preliminary issue was framed, that's a Thika property, my lord. We have taken those points. Proceeding is not maintainable, suit is not maintainable. Those points have been decided against me. So that is one of the points. Apart from the other point.
commercial court and Thika.
Very good. Can 3 of 2026 is an application for modification of an earlier order whereby the court directed the records of the connected mean profit proceedings, comma, regarding which a preliminary decree is also under challenge before this court, comma, to be DE-tagged from the main file to enable the final degree proceedings in respect of mean profits to continue in the trial court. For sub next para, learned counsel appearing for the appellant submits that if a final decree is actually passed in the said proceedings, comma, the present appeal, comma, to that extent, comma, shall be rendered infructuous. Full stop. Upon hearing learned counsel for the parties, comma, can 3 of 2026 is disposed of by observing that the learned trial judge shall continue with the final decree mean profit proceedings. Full stop. However, comma, no final decree of mean profits shall be drawn up without the leave of court till disposal of the present appeal. For sub next para, insofar as can 4 of 2026 is concerned, comma, learned senior counsel appearing for the petitioner submits that at least 3 of the respondent stroke petitioners are septuagenarians. Full stop. On considering such ground, comma, we direct the appeal to be listed in the monthly list of May 2026. Full stop. Next para. Can 4 of 2026 is accordingly disposed of. No others.
Monthly list.
Grateful.
May monthly list it will appear for.
I'm very grateful, man. And sorry, I genuinely don't
You
know.
be sorry. You are doing it for your client. You have every right to. Yes. Thanks.
Much
Mr.
obliged.
This is my appeal, man.
Yes, Mr. Pal.
My learned friend has filed an application under order 41/27.
Their application. Mr. Shen's application. That application is before us today. We'll pass the usual direction to be heard along with the appeal.
Lordship.
And we'll direct you to file opposition and reply.
Lordship can take up the appeal along with this application.
Yes, yes. Usual. Can 1 or can 2? What is the
One
can?
offender that is injunction application.
So, injunction has been disposed of.
No, that is pending.
That
Because
is
lordship
also
was sent to the mediation that has failed.
Oh, acha. This appeal is against what?
Against the decree of divorce. Wife is before your lordship.
So injunction has to continue session. And what is can 2? Can 2 is the order for 2027.
Can 2, my lord, most probably it was a section 5 application disposal.
No. That is the order for 20. Order for 20.
27
We have it before us.
can
Can 1 of 2024 is an application for injunction restraining the respondent husband from contracting any remarriage during pendency of the appeal.
That order was passed.
Ad interim was passed.
It was passed, yes.
Full stop. Next para. Since the appeal arises out of a decree of divorce obtained by the respondent husband, comma, unless the ad interim injunction in that regard is made absolute, comma, the appeal would run the risk of being rendered infructuous. Full stop. Accordingly, comma, considering the balance of convenience and inconvenience and probability of irreparable injury, comma, can 1 of 2024 is allowed on contest, comma, thereby restraining the respondent husband by an order of injunction from contracting any remarriage during pendency of the appeal, no arrest to cost. So next para. Can 2 of 2026 is an application under order 41 rule 27 of the Code of Civil Procedure for production of additional evidence. Full stop. By its very nature, comma, it would be appropriate if the said application is decided along with the main appeal. Full stop. Accordingly, can 2 of 2026 shall be listed for hearing along with the main appeal as and when the latter is ready for hearing. Full stop. Affidavits, if any, with regard to can 2 of 2026 shall be exchanged by the parties in the meantime. The affidavit of service filed to be kept on record, nor as to cost. Those have not been passed. Very well.
The informal paperwork may be come.
But at the instance of the respondent.
You will do it. Very well. Special messenger cost was. Very well. In any event, you are entitled to alimony from them and you realize that.
There is no question of alimony.
No question.
Both are well placed.
We are not asking for
Very well. On the prayer of learned counsel for the respondent, learned senior counsel for the respondent, comma, we direct the respondent to put in special messenger costs within a week from date for bringing the trial court records. Full stop. Next para. The respondent shall prepare and file the requisite number of informal paper books without comparing with the records within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the respondent. Full stop. For such purpose, comma, notice of appeal shall be served on the learned advocates both for the appellant and the respondent by the department. So next para. In view of the appearance of the respondent through their learned advocate, comma, service of notice is dispensed with. A notice of the appeal is dispensed with, and the appeal be treated to be ready as regards service. Stop. Para. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Next.
Grateful.
Item number 21.
Mr. Gautam Banerjee is for the applicant in this matter. He is failing in another 1 day time, my lord. He has.
No.
Today he failed to come, my lord.
You do the matter. Yes.
My lord, this relates to, my lord, the acquisition, my lord, the land.
Do you have any
loser
junior,
claim.
Mr. Chatterjee? You cannot appear without juniors. Yes, she's there. Yes, we'll take up. Yes.
My lord,
Land loser
because,
claim.
my lord, suddenly he has been fallen ill today.
No, we are not disturbed with his falling ill. We are sorry for that. But you were there in the matter. You were ready in the matter. You did the matter on the last also. Yes.
Land
But do you have any junior with you? Otherwise, he cannot appear.
No, he is the advocate on record.
Yes. What is the matter?
My lord, they came up, my lord, against our appeal by saying that we have not deposited the entire amount as per the LA judge has directed. Then, my lord, we have shown our calculation, which is at page 31B in our affidavits. And on the last occasion, my lords were pleased to direct them to exchange the calculations.
So have you exchanged the calculations?
Yes, my lord, I can show from both the calculations that, my lord, where problem. Kindly come to our affidavit, my lord, once. Affidavit in opposition
We are
filed by
taking up your page 31B.
31B.
We are taking up that and Mr.
And this
today.
one. Yes.
What is the difficulty?
Now, my lord, kindly come to the calculation, my lord, 31B, my lord, 1, 2, my lord, calculation part, one column, 131817. Here is 131818. Only just one.
1 rupee.
1 rupee change. And the, my lord, next portion is interest at the rate 12% from the date of publication till date of award, less the period of litigation, that is 28 years, 19 days. My lord, as per us, my lord, it should have been 443,728, and my lord, they have calculated 6,83,000 odd amount.
On
Now,
what
my lord,
basis?
kindly come to.
Have they disclosed any basis for that calculation? Their basis?
No. Now, my lord, kindly come to. My lord, kindly take the pen of seeing the act. My lord, section 23, 1A.
Land acquisition 23.
Yes. 1894, my lord. Section 23.
23.
My lord, subsection 1A. In addition to the market value of the land, as above, provided the court shall in every case award an amount calculated at the rate of 12% term per annum on such market value for the period commencing on and from the date of publication of the notification.
Date of
under
publication
section
of
4.
notification, there is no dispute.
Yes, there is no dispute. Subsection 1, in respect of such land to the date of award of the collector. So perhaps they calculated till the award passed by the LA judge.
Cannot be. You
So,
are right.
Because, my lord,
this is the reason the change
Yes,
is
you carry
showing.
forward.
because, my lord, lordship's directed.
Well, let me finish. My lord,
The other calculations.
yes, other
deposit-
calculations. Well,
to
let me
deposit
Let him-
entire amount.
Let him finish on.
আমি দাদা
Yes.
পুরোটা বলে দিই তারপরে আপনি
Yes, what are the other disciplines?
Well, this is one aspect. Regarding share, they last occasion they have accepted my calculation. Regarding 30% solatium, that was one timer because the learned judge has given 30% solatium per year. Well, they had accepted that also. Now, my lord, kindly come to the second aspect, that is solatium 30% at the rate of 30% on such and such amount. As per our calculation, we are giving them more, 39,545, and as per them,
This is as per
38,084.
subsection 2.
Yes,
Subsection 2 of section 23.
yes.
The language is very clear. A sum of 30% term of such.
They have accepted.
They have accepted. Now they have accepted.
What-
Now, my lord, next one.
Disputed ones.
Yes, next one is the catch. Further amount at the rate of 15% per annum on the amount.
You are reading from where?
Yeah, my lord, from
Theirs.
theirs. Okay, let me. My lord, 1, 2, 5, 7. In our calculation, it is 7. Serial number 7. 15% per annum on the amount already awarded by the LAC, means land acquisition collector, that is rupees such and such from the date of award to 23rd September 2024, that is 17 years, 2 months and 28 days. Now, our basis of this kindly come to the impugned order passed by the LA judge. Now, kindly come to the impugned order, which is at page 63 of their application or our application. Stay.
Yes.
Manoj has got the impugned order. Last penultimate, just before the last paragraph, petitioner is also entitled to get interest at the rate of 6% per annum to the amount awarded by the LAC on and from the date on which possession of the land was taken up to the period of 1 year, and at the rate of 8% after expiry of the period till the date of such payment. So whatever the learned judge, LA judge has said, directed, as per his direction, this was the calculation was made. So these are the two things, differences are there.
What do they say?
They have calculated this under 1, interest on base price, that is 12% per annum. Huge difference, about 2 lakhs difference. And this under Solatium second.
They have not challenged the
No, they have not.
Therefore, this has to be 6% and 8% after 1 year. You have calculated at that rate. They have increased the rate of interest.
Yes.
Yes, Mr. Chatterjee. Anything else, Mr. Dhar? Complete your. Yes.
We have submitted, Lordship, kindly see.
Solatium has to be one time.
Sorry,
there cannot
sir.
be a dispute.
Sorry,
You have
sir.
agreed to that.
Only, my lord, the calculation of interest.
First interest, yes.
12%.
12% they are agreeing. The first part, interest. But you have calculated till the date of the award by the LA judge. But the language of the statute is till the date of the award of the collector. So you have to go by the statute.
But Lordship, kindly see what is the order of this honorable court. To deposit entire amount. Decreed
awarded amount.
Award, my lordship, kindly see that award has been challenged by us, and thereafter this order has been passed.
Award you challenged. They have challenged. You have not challenged.
No, here they have challenged.
Achha, there.
There, my lord, we have
award they have challenged. You challenge the decision of the collector.
Collector, yes. We have challenged
Better
the decision of
reference,
the collector.
Yes.
Thereafter, we obtain an order that is page 63. And on the basis of that, we have calculated.
So therefore 30% per year.
Yes, that's why, my lord, it has been.
We'll clarify your order. It cannot be 30% per year. I mean, the state coffers will be exhausted for one person only. Unnecessarily, beyond the statute. Will then modify your order or clarify your order?
But honorable court's order is, my lord, high court's order is, my lord.
Honorable court is before you.
Yes.
It will rectify its mistake. Not so honorable as you think. Because of the mistake. So we'll rectify that. At least 30% Solatium, we passed an usual order, sort of. I mean, we'll clarify that what we meant is that in terms of the statute.
It was a mistake rather.
Yes,
perhaps.
And regarding this, no calculation, was it directed? Interest was directed to be given after the award of the date of the award of the LA collector in the impugned judgment.
No.
You have calculated up to this interest up to the date of the award of the LA collector. Was that the provision in the ordering portion?
That is section 23(1)(a).
No. In the
ordering portion.
Yes. Because we directed decretal amount to be awarded amount to be deposited means whatever.
Calculated at the rate of 12% per annum in addition to the aforesaid market value for the period commencing on and from the date of publication of
the date of the order. No. Only 30% the tribunal LA judge actually did it wrongly. 30%. I mean monthly, yearly 30%.
That has to be one timer.
Yes, but it's also interrogated at the rate of 30% per annum. Yes, on the amount in excess of the award awarded, and also further amount calculated. No, it has not been directed actually to go on paying 30%. See the language. Referring claimant is also entitled to get solatium. This at the rate is there in the statute. At the
Yes.
rate of 30% per annum. Per annum, that is PA that is wrong. That is to be constituted as 30%. That PA is, I mean, because at the rate automatically PA came.
That's why the
No, this PA will ignore. No, their calculation will accept their calculation, Mr. Chatterjee.
but losses can see only these portions, interest portions.
Interest portion is also correct. The award which they have challenged, it says up to the date of the award, and that has to be calculated in the light of the statute 23, not up to the date of this. Because 1A says date of the award of the collector. So we will clarify that this date of the award is of the collector. This is not the award. This is not the award, Mr. Chatterjee. This amount is not the award. This is under reference. It's a reference court's judgment. It's a court. It's a reference court's judgment. Award under the statute can only be the collector's award. We loosely interchange the two maybe, but this is a judgment passed by the reference court. The award was by the collector. So till date of the award is as per the statute. Everything has been done.
We challenge that order and obtain this order.
No,
That's why we
you
have
did not challenge
calculated it.
anything. It's their appeal. You have forgotten that also.
No, this is their appeal.
So
But
this
here-
is we have directed them to deposit whatever amount was directed by the LA judge. They have done that.
LA judge has not they done that. They done LA collector.
No. See?
Kindly see. What the LA judge says they have not
No, Mr.
deposited
Chatterjee,
this.
they have exactly complied. Please come to the impugned judgment. The one they have challenged, page 63 of your stay.
Page 63, my lord.
Page 63, the market value of the acquired land was fixed by the judge at 40,000. They have calculated on that at that rate only interest.
We admitted that
Very well.
same amount.
What do not admit? Everything is in terms of this.
Calculation of interest 12%.
Yes, they have done that.
Only one minute.
গন্ডগোল এটা দেখুন
You are saying something else.
দাদা এটা আপনি আমায় দিয়েছেন এটাকে সামনে রেখে দেখুন ওগুলো আগের
কোনটা? না
গুলো
না এইটা দিচ্ছে এখন এইটা দিচ্ছে
Anyway, we are deciding it. They will accept there.
কিন্তু এইটা আমরা দিয়েছি
Learned senior counsel appearing for the respondent land losers hands over a calculation as per the said respondents. First up, learned senior counsel appearing for the appellant state submits that the calculation as reflected in the chart given at page 31 within bracket B of the affidavit in opposition filed by the appellant to CAN 03 of 2025 reflects the awarded amount, comma, as in terms of the judgment of the LA court which has been impugned in this appeal. Full stop. Next para. We find from the said calculation that the land value has been taken as rupees 40,000 per katha, comma, in terms of the judgment impugned before this court. Full stop. Moreover, comma, interest has been calculated on the said value from the date of publication of the notification till the date of the award passed by the collector, less the period of litigation, that is 28 years, 19 days. Full stop. Next para, apparently, comma, the respondents proceeded with their calculations on the premise that such interest should be calculated till the date of the judgment of the LA court, comma, which is obviously contrary to subsection 1 capital A of within bracket of section 23 of the Land Acquisition Act, comma, 1894. Full stop. Even from the impugned judgment, comma, we find that the term double inverted date of the award double inverted clause has been used, comma, meaning thereby, comma, read in conjunction with the statute, comma, the date of the award of the collector. Full stop. Next para. Insofar as solatium is concerned, comma, the impugned judgment stipulates solatium at the rate of 30%. Full stop. However, comma, after the rate of interest, comma, the expression double inverted mode small p dot small a dot inverted close was used in the impugned judgment, which was an obvious error, comma, since subsection 2 of section 23 of the 1894 Act clearly stipulates a one-time sum of rupees 30% on the market value to be awarded as solicium and does not envisage any continuous payment of such amount. Full stop. Even from the impugned judgment, comma, there is no indication of the solicium being directed to be paid regularly. Full stop. Thus, comma, it is clear that the calculations made by the appellant state, comma, as reflected at page 31 within bracket B of its opposition to Can 03 of 2025, comma, is the correct awarded amount, comma, which was directed to be paid as condition of stay. Full stop. Next para. Thus, comma, we accept such calculation. Full stop. Since the said amount has been, you have deposited this amount.
Yes.
Since such amount has been deposited duly with the learned Registrar General in terms of the order of this court, comma, the stay application is still pending.
No, my lord,
Their application
initial-
now.
yes.
Their application.
their application, my lord,
Which is the application number?
Can 03 of 2025.
Accordingly, Can 03 of 2025 is dismissed on contest without any orders to cost. Full stop. We have already directed the paper books and all these things.
No.
You have not directed. Probably we did.
Preparation
At the time of stay, we
My
did.
lord, yes, there was a direction, but we have not prepared as yet.
No,
my lord.
we passed the direction. So the appellant shall comply with the directions of this court regarding preparation of paper books, etc. at the earliest.
I'll divide it to mention.
That was given in the last auction.
স্যার এলসিআর স্পেশাল মেসেঞ্জার কস জমা হয়নি মনে হয়
ডিলে হয়েছিল সেসব পরে করবো
Great point. Thank you.
Deeply honored.
ঠিক আছে আপলোড retrospective effective returnable date.
Number 20.
Yeah.
The appellant,
Yes,
my lord.
please.
My lord, appellant number 3 and respondent number 4 has been expired. And that's the two petitions has been filed.
Oh, you have filed petition.
Yes.
Okay.
Can 2 and Can 3, one for expunging the appellant because her legal years already on record, and so far as respondent 4 is concerned, my lord, his daughter Shumadi to be substituted in his place.
Can 3 is within time?
No, not within time. 265 days release there, my lord. A composite application has been filed.
Then you have to serve copy of that.
I have served, my lord.
Oh, you have served already?
Yes, sir. This is evidence service.
What is the respondent of 4? That is respondent
4, my lord.
What is the explanation given here?
My lord, they did
For
not
the delay?
inform us. They did not inform us. They, so far as death certificate is concerned, my lord, we did not get it. At a later
Affidavit of service filed, affidavits, one affidavit of service filed today be kept on record, full stop, despite service, none appears for the respondents. Full stop. Next para, Can 2 of 2025 is an application for recording the death of appellant number 3, Srimati Geeta Chandra. Full stop. We find from the averments made therein that the heirs and legal representatives of the said deceased appellant are already on record. Full stop. Accordingly, Can 2 of 2025 is allowed, comma, thereby directing the name of the appellant number 3, Srimati Geeta Chandra, to be expunged from the records. Full stop. Necessary correction to that effect, necessary amendment to that effect shall be carried out in the memorandum of the appeal. Paper books have not been prepared.
No, my lord. Yet not.
In the memorandum of the appeal by the learned advocate on record for the appellants during the course of the day. Full stop. Next para. Can 3 of 2025 is an application for substitution of the heirs and legal representatives of the deceased respondent number 4 after setting aside amendment on condonation of delay. Full stop. We find from the averments made therein, comma, that the appellants came to know about such demise long after the actual demise of the respondent number 4 and have filed the application at the earliest thereafter. Full stop. Thus, comma, there is sufficient explanation for the delay in preferring the application furnished in the application itself. Full stop. Accordingly, can 3 of 2025 is allowed, comma, thereby directing the heirs and legal representatives of the deceased respondent number 4, Sri Shukumar De, comma, as mentioned in the cause title of can 3 of 2025, comma, as heirs and legal in place and state of the said deceased, comma, as respondents in the present appeal, after setting aside abatement and on condonation of delay in filing the application. Full stop. The office shall carry out the necessary corrections to the records, comma, including the memorandum of appeal, comma, in that regard within a fortnight from date. No orders to cost. The first one, because it's merely expunging, you will carry on. And the second one, the office will carry.
মানে kindly extend 1 day time because on
Acha,
record not
during the course of the day na kore, by tomorrow.
Lordship, deeply obvious.
আচ্ছা, তা এক কাজ করুন, হ্যাঁ, ডিপার্টমেন্টই করে দিন ওটা উইদিন আ ফোর্টনাইট, দুটোই উইদিন আ ফোর্টনাইট। ইউ ডোন্ট হ্যাভ টু ডু এনিথিং দ্য ডিপার্টমেন্ট।
Deeply obvious.
Yes, my lord, I am for the
Yes,
appellant,
sir,
my lord.
what is the matter?
My lord, your lordships are hearing the application for injunction. Already there is an interim order passed on 28th of January 26.
You directed them to file.
Yes, yes. And on the last occasion, they said that we have got certain papers to use to defeat my case, but no affidavit in opposition till date.
Till date, no copy also has been served.
Nothing, nothing.
We'll dispose of that.
Yes.
Now, just give us a brief background, Mr. Rai. We forgot.
My lord, we have been dispossessed from the suit premises.
So this is against eviction decree?
No, no, no. Dismissal of the suit for restoration of possession, declaration and restoration of possession.
What sort of injunction was passed? No third party interest.
And not to change the nature character. Kindly come to para 5 of the order.
The injunction prayer we are seeing is changing nature, character and condition.
Yes. Para 5 of the order passed by your lordship on 28th of January.
Very good. Look into that.
From selling, transferring, alienating, encumbering.
Right. We'll pass the similar.
Yes.
None appears for the respondent at the time of call. Full stop. We are apprised by learned counsel for the appellants that no copy of any affidavit in opposition has been served by the respondent on the learned advocate for the appellants as per our previous direction. Full stop. Also, comma, no such affidavit in opposition is filed in court till date. Full stop. Accordingly, we take up the application for hearing ex parte without further affidavit. Full stop. On the averments made in the application, comma, we find a sufficiently strong prima facie case for hearing of the appeal on merits having been made out. Full stop. Also, comma, the balance of convenience is in favor of grant of injunction, and the appellants may suffer irreparable injury in the event the injunction as sought for is refused, comma, keeping in view that the appeal has been preferred against the dismissal of the appellant's suit for recovery of possession. And
declaration and recovery.
Declaration of title.
Yes, as a tenant.
As a declaration of tenancy rights and recovery of possession. And if any third party interest is created and or the nature and character of the property, suit property is altered in the meantime, comma, the appeal might be rendered infructuous. For next para, in such view of the matter, comma, can 1 of 26 is disposed of by restraining the respondent and or her men and agents from by an order of injunction from selling, transferring, alienating and or encumbering the suit property in favor of third parties in any manner whatsoever, and stroke or changing the nature, character and condition of the suit property, comma, both till disposal of the appeal. Push up, paper book directions were not given.
Yes, yes, given.
Already.
Yeah, given.
Yes, right.
Only thing, my lord, may I pray from your lordships, my lord, since I have been backed by the photographs that in spite of the order of
file a contempt
as well, lordship, the officer in charge may kindly be directed to see that the order passed by your lordship
litigants love to face contempt in our court.
Yes, yes.
So we are getting so many contempt applications. So as we also love to deal with contempt. Let's file a contempt. We'll see to it. Yes.
Grateful, my lord.
Are becoming statistics gradually.
Yes, yes.
Yes. Say no. Yeah. Yes, Mr. Rai.
This is an application, last application, your lordship was pleased to reject order of stay, which is pending.
And this has already been effected on your pair we had adjourned on the last page. So they have been served.
So one thing, my lord, is suit for defamation suit, so money degree. It is suit decreed against that order 9 rule 13 filed, along with section 5. That was rejected. Against that, this appeal has been filed.
Money decree was passed against you. So then we'll have to secure.
That is
why you asked for adjournment.
That is why last occasion. One thing, my lord, may I pray before your lordship, security of my lord, whether
guarantee,
bank guarantee like that, my lord, if it is for, because my lord, attested 3 lakhs rupees, my lord, it is, I'll secure, it is not that I'll secure, bank guarantee or FD I can deposit.
What do you do, your client?
Retired person. My lord, this is a fight between two persons.
Defamation.
Defamation, my lord, an allegation was made.
No, defamation has been decreed against you.
Decreed against me, ex parte.
How did you defame him?
Nothing. My lord will inform
What
judge.
do they say?
They said that I have made a false complaint before the police.
It's in the nature of a malicious prosecution also.
That is malicious. Against that, it was acquitted. Against the revision application is pending. Be as it may.
How 3 lakh?
3 lakhs. 3 lakhs.
Defamation money is put money. Not that the loan nature. Defamation bank guarantee. Will permit you to furnish security to the satisfaction of the learned registrar general.
As your lordship pleases.
You go and
Yes.
take a bottle of oil and go to the learned registrar general. The learned counsel for the appellant seeks a stay of the impugned decree whereby the application filed by the appellant under Order 9 Rule 13 of the Code of Civil Procedure was dismissed. There was a Section 5 also.
Section 5 dismissed.
Consequential, continue the sentence, consequential to the connected condemnation application being turned down. Full stop. Next para. Upon considering the submission of learned counsel for the appellant, we find a sufficient prima facie case for hearing the appeal on merits having been made out. Full stop. Next para. However, since the impugned decree affirms a money decree, arising out of a suit for defamation, this court is of the opinion that the decretal amount ought to be secured by the appellant for grant of stay. Full stop. Next para. However, since the claim of the plaintiff respondent is not in the nature of remuneration for work done or recovery of loan, but on the ground of defamation, this court is of the opinion that it would suffice that the decretal amount is secured by the appellant by whatever mode, commensurate with the satisfaction of the learned registrar general of this court. Accordingly, this is can 2 of 2024 is allowed, thereby granting stay of operation of the impugned judgment and decree till disposal. Judgment and
decree,
not decree. 913 is
execution case
appellable order.
Execution case B.
Execution of order. Appellable order.
Yes.
Judgment and order, impugned judgment and order till disposal of the appeal, subject to the appellant securing the decretal amount of rupees 3 lakh is the exact.
3 lakhs. Page 60 your lordship fight.
You are saying that is sufficient. Of rupees 3 lakh to the satisfaction of the learned registrar general of this court within a fortnight.
I'll approach with the registrar general by today or tomorrow as soon as I get the server copy. Now, my lord, after that, if there is a direction for server compliance, my lord, if it is not done within
4 weeks from date.
Yes,
within 4 weeks from date. Full stop. The appellant shall approach the registrar, directly or through his counsel, the learned registrar general at the earliest to ensure compliance of the above direction. Full stop. In default of furnishing such security as indicated by the learned registrar general, within 4 weeks from date, the order of stay shall stand automatically vacated without further reference to the court. So you have tied it up with the registrar general forming an opinion. If you
Yes.
don't comply, then.
Yes, yes.
But broadly 4 weeks. If it isn't done within that period, if you
I
can just cancel and have it.
Lordship for
You did not file an application.
other directions for
Oh, those are not there. Very. The trial court record shall be brought by special messenger at the cost of the appellant, comma, to be deposited within a fortnight from date. The appellant shall deposit postal cost, requisites, and written up notice form for service of notice of the appeal on the respondent, also within a fortnight. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing.
Grateful to your Lordship.
Item number 25.
Yes.
This is my appeal.
Yes, please.
Lordship, the backdrop of the case, my lord, I am a tenant. I file a suit against the land, against the bank. Bank certainly comes and threatens me that they will evict me. Now, I am a tenant.
What service you directed
Yes,
to serve?
Yes, it has been served.
You have checked up, it has been served?
Yes, it has been served.
Very well. So sorry, please,
Yes,
please
ma'am.
carry on. The bank?
Now, there is also direction by your Lordship to file a supplementary. We prayed for a time to file supplementary affidavit because we have not annexed all the documents.
But this then you have to serve a copy.
Yes, that has been also served.
Oh, that.
Yes, ma'am.
And
Now, my lord, I am a tenant. I have been threatened.
the copy.
Yes, ma'am.
No, it would help us. Why remove that? Yes. Thanks. Yes, sorry. Yes.
I am a tenant, my lord. Suddenly, bank comes and says that we will evict you because the property is already mortgaged. We inquired, we file a suit against the bank and the landlord, saying that, my lord, to regularize my tenancy, my lord, for suit for declaration. That has been rejected on the ground of primarily.
What has been rejected?
The
Injunction?
injunction order. Interim order granted, thereafter heard, finally rejected on the ground that we have failed to provide some documents. We have given document rent receipts till 2020. We have filed a suit in 2021. So, but we have also filed the business trade license of 2021. That has not been considered. We came before your Lordship. Lordship was pleased to stay the or impugned order.
Not stay the impugned order, grant you injunction must be.
Yes, my lord. Stay the impugned order, grant the injunction order, my lord.
There cannot be any stay of refusal of injunction.
Yes, my lord.
Must have granted injunction.
Granted the injunction order till the disposal of this scam. Now, there are certain documents we have not filed before your Lordship. That's why we filed a supplementary affidavit.
But these were before the trial court.
Yes, these are before the trial court.
Have you stated anywhere?
Yes, my lord. Lordship has directed in the last order only that what we failed to file before your Lordship, which were there in the trial court, that has been filed before your Lordship.
Let us see the impugned order once.
Yes.
What is the date of the order? There are several orders.
Yes, no. Date of the order is 13th March 2024.
You're a pre-mortgage tenant.
Pre-mortgage tenant. My mortgage in I was a tenant in 2001.
Affidavit of service filed today be kept on record along with the supplementary affidavit filed today as per the previous leave granted by the court. Full stop. We find from the application, we find however, the present appeal has been preferred against an order dismissing the plaintiff stroke appellant's application for temporary injunction on the ground that the appellant failed to produce sufficient current documents to establish its possession and tenancy in respect of the property. Full stop. Next para. However, comma, even from the impugned order, comma, it is reflected that documents of possession as well as tenancy immediately prior to the prior to the filing of the suit and the date of the impugned order were furnished before the trial court by the appellant. Full stop. Next para. The law of evidence includes a presumption of continuance of legal relationships in the nature of landlord-tenant, licensor, licensee, etc. in the event the existence of such juror relationship at a previous point of time is established, comma, unless such presumption is rebutted by cogent evidence by the party asserting the severance of such juror relationship. Full stop. In the present case, comma, in the absence of any such rebuttal evidence, even at a prima facie level, comma, this court is of the opinion, this court is of the prima facie opinion that the learned trial judge erred in law in refusing to grant injunction as sought by the appellant. Full stop. Next para. Accordingly, comma, now, from the affidavit of service filed today, comma, we find that service has been effected on the respondents. Full stop. However, comma, the respondents choose to abstain at the time of hearing today. Full stop. Hence, comma, the application is taken up ex parte. Full stop. Next para. In the light of the above observations and the annexures to the supplementary affidavit filed today, comma, which comma, we are apprised, comma, were before the trial court as well, comma, this court is sufficiently satisfied that there is a strong prima facie case made out by the appellant in favor of grant of injunction. Full stop. Accordingly, can 2 of 2024 is allowed, comma, thereby restraining the defendants, respondents, stroke opposite parties and their men and agents from disturbing the peaceful possession of the plaintiff, stroke appellant, stroke petitioner in respect of the suit property, being one room bearing number 4 capital A, comma, situated on the 4th floor at premises number 2, comma, Clive Ghat Street, comma, Kolkata 7,01,000 without due process of law. They can do it with due process.
Yes.
Without due process of law till disposal of the appeal. Full stop. No orders to cost. In view, are all the papers annexed here?
Yes,
You
no, all
file
the
informal paper, which are not calling for the records. And we will make it clear that the suit will proceed.
Yes, ma'am.
In view of the limited nature of the appeal, comma, we direct the appellant to prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from date. Full stop. The trial court records are dispensed with. Full stop. Next para. The appellant shall put in due requisites, postal cost and written up notice form for service of notice of the appeal on the respondents, comma, within a fortnight from date. It is made clear that the pendency of the present appeal shall not deter the learned trial judge from proceeding with the suit from which the present appeal arises. Liberty to mention the appeal as and when the same is ready, comma, for enlistment. Ready for hearing. Ready for hearing. Next.
Item number 26.
But I am for the defendant appellant on the last occasion.
Yes, you have deposited the amount.
Yes, ma'am. This is the charge.
Yes, there is also report. Yes.
The point in this matter is, my lord,
money degree.
Money degree, but
degree
point
matter.
is, my lord, only limitation. That the proceeding is barred by limitation.
Oh,
according to Article 14. My lord, in the plaint, my lord, they have stated that as per their accounts, Khata, on 18th of August 2001, total amount due was such and such. Therefore, the limitations will start from the date of delivery of the article. But that must be prior to this.
Limitation Act. Sorry, please continue.
Therefore, it must be delivery of article prior to 18th of August 2001.
This is for price of goods delivered.
Yes. Paddy. Both are, my lord, paddy merchants. I have got the paddy from my learned friend's client. Now, according to their statement in the plaint, that as per the Khata on 18th of August 2001, total amount due from defendant is such and such. Therefore, date is delivery of paddy must be prior to 18th of August 2001. They have filed the suit in 2005. Therefore, clear it is barred by limitation. This point is required to be, my lord, taken into consideration.
Which article, Mr. Mahato?
14.
14. Yes.
My lord have also recorded that on the first day.
Is it their case, Mr. Mahato, that there was any fixed period of credit? No.
No.
Nothing of that. Yes, Mr. Podar, let us dispose of the appeal by allowing it.
14, Article 14 will not be applicable in this case.
Why?
Because my lordship is correct that delivery of the goods, it is not only single occasion. There was a transaction, commercial transaction, delivery of paddy going on. My lord, all on a sudden, my lord, some amount was fallen due. And my lord, the defendant is, my lord, not willing to pay the same. Merchant Association intervened. And on the intervention of Merchant Association, he, my lord, agreed to pay the balance amount by installment. Last of such installment was paid on 16th April 2002. So, instead of Article 14 of the Limitation Act 1963, 22 will be attracted in this case. 22, 23. Because when he stopped payment of installment, but cause of action arises from thereon. My plaint case is also that. I have also averred in my plaint in cause of the plaintiff copy to thee. And there was no order 7 rule 11. Well, kindly see the cause of action plaint. 16.4.
Banker, hands of his banker. কি দিয়েছেন
একটা লাগবে না
এটা কি দিয়েছেন
প্লেন তুমি তো প্লেনটা দিবি
আপনি দিলেন আমার কি
সেটা বলছি ওটা জাজমেন্টই তো বলেছি জাজমেন্টে বলেছেন তোমার অ্যাপ্লিকেশন আছে মানে ওটা প্যারাইজ হচ্ছে গুডস ডেলিভারির জন্য কিন্তু সেকশন
Mr. Poddar,
yes.
Article 22 applies if the genesis of this, the basis of this claim is an agreement. In your case, agreement was not the basis of the claim. Agreement was when the dues were already there and the dues arise from the delivery of goods. So the cause of action is primarily the delivery of the goods. There, because of the purpose, 22 will not be applicable, 18 will be 14 will be applicable. But Mr. Poddar, probably you will get the benefit of section 20 of the Limitation Act, the effect of acknowledgement or payment by another person.
Yes.
So this is not a case where 22 would come, 14 will apply. Even in spite of 14, you get the umbrella protection of section 20, where it is stated that the expression agently, now in the case, not this, sorry, this is, no, subsequent, yes. Sorry, 18. Section 18. Effect of acknowledgement in writing.
Yes, acknowledgement started payment. And
yes, so therefore, if there is an acknowledgement in writing, then we can consider.
And moment he started payment, acknowledging the date, which is more fully described in the plaint itself, he admitted. And my lord, payment was monthly payment. And on 16/4, he last paid.
No, what does that? The 711 was rejected.
No. Men suit has been declared.
Admitted, all admitted.
Suit has been declared.
Your ground is limitation.
Court has not well discussed it.
Sir, Mahato, how do you get over section 18? We agree. You are right for Article 14, not 22. 18. You must have.
My lord, what I am praying before,
you must have discussed this.
What I am praying before,
what is his answer to
my lord,
this?
what I am praying for, my lord, since this point is involved, my lord, section 18 or.
We are dismissing the appeal right now.
No, my lord, kindly fix a date, my lord, so that I can come back.
No, come back.
A short date.
You are ready in the matter. We have heard you.
But today I am not ready in all that sense.
You made the arguments on the appeal. Appeal is on the short point.
I was a short point, therefore, my lord, I was praying that it may be, otherwise, my lord, if it is directed that the paperwork will be prepared, it will be listed. it will never be heard, my lord, at this.
Very well.
But in the
Therefore, my lord,
meantime,
I was
there
trying.
an agreement from his side.
We'll dispense with everything. We'll just proceed on the basis of this plaint because your point is limitation.
Yes.
And we'll go by the written statement is Mr. Mahato. Do you have copies of both of you? Have copies of plaint and written statement?
Yes.
Plaint evidence also do you have?
Yes, we have.
So you prepare very short paper books. We'll take it up after 1 week. We'll keep it under the application heading along with the.
No problem.
No problem. Obviously, no problem for you. It's a problem for him.
My lord, he acknowledged everything. My lord, which will be.
Now you get wiser. Section 18 did not cross your mind also. Anyway, an arguable question has been raised in the appeal. First up, the appeal is against a decree, against a money decree. First up, the short point involved is whether the suit was barred by limitation. First up, prima facie, we find an arguable question having been raised as to the interplay between Articles 14 and 22 of the schedule to the Limitation Act being applicable to the present case, read with Section 18 of the said Act. Full stop. Apparently, the plaint claim of money was based on goods delivered by way of paddy by the plaintiff respondent to the defendant appellant. Full stop. Next para, if counted from the date when allegedly the plaintiff detected from his khata, singly noted moddhe, that there were dues to the tune of August 18, 2001, the suit, instituted in 2005, would be time barred. Full stop. However, in the plaint itself, it has been pleaded by the plaintiff stroke respondent that pursuant to the claim of the plaintiff in that regard, the parties entered into a compromise on the intervention of well-wishers, and a written agreement was drawn up between the parties. Full stop. Next para. Thus, the respondent claims that the provisions of Article 22 of the Limitation Act should be applicable as opposed to Article 14. Full stop. Next para. This court is of the prima facie opinion, however, that the genesis of the claim is not an agreement as contemplated in Article 22, but delivery of goods, it is Article 14 of the Limitation Act which should be applicable. Full stop. However, prima facie, the plaintiff would be entitled to the benefit of Section 18 of the Limitation Act in view of the acknowledgement in writing, pursuant to which the defendant appellant went on making payment of installments, within the limitation period from the last of which the suit was filed. First up, the appeal can be heard out on the above short question without calling for the trial court records. Full stop. Accordingly, calling for the records is dispensed with. Full stop. In view of the appearance of the plaintiff stroke respondent through his learned advocate, service of notice of the appeal is also dispensed with, and the appeal be treated to be ready as regards service. The learned counsel for the you have all the papers, so you prepare the paper books. You won't spend that much money also. So you're getting miser day by day. You're donating like anything.
If your lordship direct, I have.
Why should we direct? Of your own, you should. It's your.
Well, I'll prepare. I'll prepare. No problem.
No, Mr. Mathur. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within a fortnight from date. In the event any relevant document is not available with the appellant, the appellant will be at liberty to approach the respondent's counsel for furnishing such papers. Full stop. Next para. The appeal along with the application shall be taken up for hearing together on March 30, 2026, when the matter shall be listed under the same heading, but with the understanding that the appeal also will be taken up for hearing along with the application. Include the plaint and everything, Mr. Mahato, please. Yes.
He was directed to deposit full amount, my lord, as per your lordship direction.
You have not deposited.
I have handed over the challan, man.
No,
no copy to us.
In view of the deposit of the conditional payment having been made by the appellant, The interim order will continue to disposal of the application. If you dispose of the application, the appeal won't be heard. Next. গল্প করার সুযোগ নিয়ে পরেরটা ডেকে দিন। Yes. Yes, Ms. Gupta. What is that?
My lord, I filed this supplementary affidavit. Kindly excuse me for this pitch of my voice.
No difficult. Your injunction application.
Lordship. Lordship.
Supplementary affidavit, you have given a copy to him.
Lordship, this was a matter where they took the possession of the showroom, garage, and they are.
You are up against an eviction decree.
Yes, Lordship.
Premises Tenancy Act, we forgot.
Lordship.
Achha. What is your ground in the appeal?
Lordship, the decree is failing in many respects. Is perverse because no documents, relevant documents were considered. Admittedly, I have more than 500 rent receipts, which were not considered by the trial court. And Lordship, they come out with a totally vague document first time in the suit, saying that it was a license agreement that is not notarized, that is not
Court proceeded on the premise that it's a license.
license, but that is not signed by my client. Only name in capital letters is written. We object to that. That was set aside.
But
Not
your
considered.
eviction has been taken by them in the
Yes,
meantime,
Lordship.
in execution. So
But
we
my-
can ask them not to create any third party interest.
As well as Lordship, on the last occasion, Lordship have been pleased to direct them to maintain the nature and character of the suit property as on the date of decree. They are making certain changes, and they are that I cannot say here, but they have kept my goods. Iron.
Both if we change the nature character,
Nature and character, my lord, so far as it was a garage, my lord. After taking possession of the same, my lord, the shutter, which was there for a long time, that was changed. My lord, interior portion, plaster and whitewashing, etc., painting, that was done, my lord. Nature and character, whatever she is contending is absolutely incorrect.
We'll record that and say that nature and character won't be changed by utility disposal. No third party interest.
And no third party interest, but nature and character. We are not going to create any.
Unless nature changes the character, you won't change the nature and character. Let nature do it, not you. So
Yes,
nature may change the character. We
it
don't have any
is-
control. But you may not change the nature and character.
And my lord,
But
it is in college street, so area, so it
policy,
may
so
change.
nature and character may change anytime due to
It will
any
change.
one strike, and the nature and character may be changed by.
Also,
Another thing, my lord.
and Lordship, Ken 3 is for the amendment of the appellant number 1's name. Lordship, the
Yes, my lord.
supplementary affidavit is for that
purpose, my
only.
lord, your lordship on the last occasion directed me to serve all the copies of the whatever has been taken place regarding substitution before the trial court, my lord. I have supplied the same as well as by way of an affidavit I have submitted.
They have
the
done after the last hearing, Lordship. I'm not
Please,
after that, but that created the problem. And
Amendment of the cost title means
problem was also
Uh,
there.
and
some of the names.
Because, my lord, on the basis of an order of this honorable court, the decree was changed.
Mr. Talk about let us do one thing. We'll dispose of can 2 and then here 3. Just let us pass an order. We'll just
Lordship,
lose track.
3 is for change of the name.
Yes, can 2 will dispose of and immediately here 3. Just we are passing the order. Can the present appeal arises out of an eviction decree obtained by the plaintiff's respondents against the defendant's appellants. For some next para, we are informed that in the meantime, the plaintiff's respondents have taken possession of the property from the appellants in execution of the impugned decree. Thus, learned counsel for the appellant submits that the respondents be restrained from changing the nature and character of the suit property and or from creating any third party interest in order to save the appeal from being rendered infructuous. For some next para, learned counsel for the respondent submits that cosmetic changes have been made to the property in respect of whitewash and other maintenance activities, and a collapsible shutter has been introduced at the gate of the property, which do not tantamount to change in nature and character. Next para, be that as it may, in view of a sufficiently strong arguable case having been made out, can 2 of 2026 is disposed of by restraining the respondents and or their main agents from changing the nature and character of the suit property and or selling, transferring, alienating and or creating any third party interest in respect of the suit property till disposal of the appeal. No order as to cost. Supplementary affidavit in respect of 3. Achha, very well. Supplementary affidavit and an affidavit in support of documents are respectively filed by the appellants and respondents in connection with Can 3 of 2026. Can 3 of 2026 is accordingly taken up for hearing. Yes. What do you say? Amendment, what sort of amendment you sought?
Lordship, only the name of the first appellant who expired, his son's name will be substituted in his place. Address is same, everything is same.
Who are those parties? The appellant.
Sorry,
Respondent.
the plaintiff, I mean the respondent.
Which respondent?
Number one.
So where have you mentioned in the application the names of those heirs?
Lordship, I have mentioned. Lordship, I'm just pointing out.
Watch, you have given a schedule. Yes, you have annexed it. Only Prosenjit Sen will come in.
Yeah, because the address is same, everything is same.
The
Same
others are also heirs of Vishnu Sen.
No, they are brothers.
Brother. So only Prosenjit Sen, son, will come in. Yes. You agree to that?
Yes, ma'am.
Prosenjit was incorporated. His name was incorporated in the trial court.
In the trial court as well as in
We are
the
allowing it. The court is apprised that the name of one Prosenjit Sen was substituted in the capacity of the son of the deceased plaintiff number one, Vishnu Chandra Sen, in the trial court. However, due to inadvertence, the name of the said deceased has been incorporated as respondent number one in the present appeal. Can 3 of 2026 is an application for amendment to the cause title of the memorandum of appeal to the effect that the name of late Vishnu Chandra Sen should be substituted with his son Prosenjit Sen, the latter being the sole heir and legal representative of the deceased. Accordingly, can 3 of 2026 is allowed, thereby directing expunction of the name of late Vishnu Chandra Sen, the respondent number one, and the introduction of the name of Prosenjit Sen, his sole heir and legal representative, in place and state of the said deceased. The consequential amendment to the cause title of the memorandum of appeal shall be carried out by the learned advocate and record for the appellants during the course of the day.
And Lordship, only one thing.
No rest to
It was
cost.
not because of inadvertence. They got the correction done after the appeal was filed. After
আচ্ছা
6
ডিউ টু
months.
বোনাফাইড ইনঅ্যাডভার্টেন্স একটা জায়গায় লিখেছি দেখো বোনাফাইড বদলে ডিউ টু বোনাফাইড ইনঅ্যাডভার্টেন্সটা বাদ দিয়ে however since such incorporation in the trial court records was done after the passing of the decree
After the passing of the decree.
after the
and
passing
after
of the
appeal
impugned
was-
decree তারপর যা আছে বাকি সেন্টেন্স দেখতে হবে
And Lordship,
paper
regarding-
books and all
Yes, Lordship, kindly.
will direct Good. In view of the you are for all the plaintiffs obviously in view of the appearance of the plaintiffs to the plaintiff stroke respondents to the learned advocate, service of notice of the appeal is dispensed with on the respondents and the appeal be treated to be ready as regards service. The trial court record shall be brought by special messenger at the cost of the appellants, to be deposited within a fortnight from date. The appellants shall also prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing.
Deeply grateful.
Thank you. After the we'll come back in 10 minutes and take up one passover matter, then we'll take up the other matter.
17 is passed.
Item number 17.
Yes.
Pursuant to your lordship direction, my lord, I have served, my lord.
They have received, Mr. Das?
No, my lord, kindly see the envelope, my lord.
What have they said?
Return, my lord, kindly see the torn
What
condition.
endorsement?
Well, pursuant to your lordship direction.
What endorsement pursuant to our direction?
My
We
lord,
did not direct the endorsement.
insufficient address, but the
But it has been opened. You haven't opened it?
No. My
Sure.
Yes, my lord.
খুলে দেখে ফেরত দিন।
My lord, this is the my lord in respect of can 2 application, my lord. In respect of can 1 duly served, my lord.
Same
Delivered.
address.
Yeah, my
We
lord.
will take it to be good service.
My lord.
Delivered reliable. What is can 1?
My lord, can 1 is my lord application for stay.
Acha.
Can 2 is section 5, my lord.
Acha. They have refused the section 5.
My lord, 40 days, my lord, delay, my lord.
What is the
Can 2.
reason for the delay?
My lord, paragraph 3, 4, 5, 7, and 8, my lord.
These are not reasons. What is the reason for the delay?
My lord,
Paragraphs
the-
are not reasons.
My lord,
You tell us.
instructed to the my lord clerk to apply for the certified copy, my lord. He filed the my lord certified copy after 88 days, my lord.
Clerk is still with you?
My lord, lower court, in lower court.
He is still with his advocate? Good. Affidavit of service filed to be kept on record. Full-stop. Although service has been effected with regard to can 1 of 2023 at the very address where a copy of can 2 of 2023 was sent, comma, in respect of the latter, comma, the envelope has returned with the endorsement insufficient address. Full-stop. However, comma, we note that the top of the envelope has been torn open. Full-stop. It is evident that since service has been refused at the same address where it has been served earlier, comma, the respondent is deliberately avoiding service. Full stop. Accordingly, we construe good service to have been effected both with regard to can 1 of 2023 and can 2 of 2023. Full stop. Next para, can 2 of 2023 is an application for condonation of the delay. Stamp report ta dekhe niyo.
40 days, my lord. Pursuant to the detection of the my lord stamp reporter.
40 আছে? Stamp report you have checked that. 40 of about 40 days. Full stop. In the application, comma, we find sufficient explanation having been furnished for such delay, comma, inasmuch as there was some delay on the part of the clerk of the learned advocate who was conducting the case for the appellant in the trial court in applying for and obtaining the certified copy, comma, despite the appellant having apparently been diligent. Full stop. Thus, comma, can 2 of 2023 is allowed, thereby condoning the delay in preferring FAT 10 of 2023. Full stop. No orders to cost. The appeal is deemed to stand registered and admitted. Full stop. The appeal is against what?
My lord, the appeal is against the my lord order dated my lord order number 50 dated August 31st, 2022. My lord, this is a specific performance of contract, my lord.
Why order? Why not
My
decree?
lord, kindly see the impugned order, my lord.
No, you haven't obtained a degree.
Yes, my lord.
Degree you have obtained.
Yes, my lord. I have done
It was expertise.
expertise, my lord.
Expertise, expertise passed as an order. You have to mention judgment. And this is a judgment for all factor. So, what sort of interim order?
My lord,
Money decree.
my lord, actually, my lord, it is a specific performance of contract, my lord. The defendant appeared and filed the written statement, but did not choose to contest this, my lord, suit.
You are the
Then
defendant.
I am the plaintiff.
Oh,
I am
acha.
the plaintiff,
Oh, acha. You have acha. Because specific performance was refused, you have challenged that.
my lord. But the alternative form, my lord, suit has been
Damages has been.
decreed, my lord. Well, the last portion.
So this 1,50,000 was by way of what? Damages or the earnest money?
Earnest money. Total
We hope you have
consideration.
not taken up withdrawn that amount.
What about I want?
You have accepted that 1,50,000.
Yes, the defendant accepted, my lord.
You have accepted in terms of this decree. Don't take that.
No, my
Then you're
challenging that, my lord.
Yes. Don't accept that
No.
that amount if it's tendered
No,
to you.
no.
Instruct your client not to accept. Anyway, the present appeal has been preferred against the refusal of a decree of specific performance. Full stop. The plaintiff stroke appellant filed the suit for the relief of specific performance of an agreement between the parties. Full stop. However, comma, by the impugned judgment and ex parte decree, comma, alternative relief of refund of the earnest money to the tune of rupees 1,50,000 with interest has been granted by the learned trial judge. Full stop. Being thus aggrieved, comma, the appellant has preferred this appeal. Full stop. We find that a strong prima facie case has been made out for hearing the appeal on merits. Full stop. Accordingly, comma. So you want a stay of the decree?
Yes, well.
Accordingly, comma.
Stay of operation.
Can 1 of 2023 is allowed, comma, granting stay of operation of the impugned judgment and decree dated August 31, 2022, passed by the learned civil judge, senior division, comma, Chandannagar, district Hooghly, in title suit number 208 of 2019 till disposal of the appeal. The appellant shall put in due requisites, postal costs, and written up notice form for service of notice of the appeal on the respondent within a fortnight from date. Full stop. The trial court records shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a fortnight. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. প্রথমে একটা করে দিও, the affidavit of service along with postal envelope filed in court to be kept on.
Yes,
The deficit court fee was there?
Yes, filed, my lord.
Deposited?
Yes, my lord. Filed, my lord.
Sure?
Yes, my lord.
Pass out it.
Item number 8 with 20.
ও এটাই পাস ওভারটা ছিল, তাই বলছি এটাই পাস ওভারটা ছিল। Yes, 28 please. Yes, Mr. Basu.
My lord, may kindly see the last order. Your lordship was pleased to direct on 24th of February to serve the copy of the Can 1 and Can 2 insofar as FAT 76 is concerned, but I have also served 75. That was been directed to be brought on the list on by the said order.
Very good.
Both the applications, my lord, there are two Can application in both the appeals. That is one section 5 and one is stay application. The first one is item number 14.
Both have section 5s and
yes, I tell you, lordship. But so far as the FAT 76 is concerned, but that is challenging the final degree. And there is a delay of 828 days.
Final degree 825.
28 days.
What about the
I was
other
not,
is for the preliminary degree?
9 years. Yes, and that is 3,820 days. I tell you, lordship.
Forget it.
I tell you.
Forget it.
I tell you, lordship.
Three sister, one brother, 1/4 share was declared.
May I just indicate to lordship? Subject to my lord, wasting of lordship's time, precious time.
No question of wasting. Mr. Shanal, please take your seat.
The suit was filed. I am the defendant number 1. The summons was never been served. I was never a resident of the address given by the plaintiff in the plaint. I had the knowledge when a subsequent plaint was filed in the year 2024 from one of my close relatives that on the self-same cause of action concerning other property, the partition suit has been filed in between the same parties.
No, the second suit was filed by them.
Yes, by the
For
same
what?
plaint for partition for other properties of the same area. And that was, I have gathered information that was been dismissed for bad for partial partition. Because earlier suit was taken out, that was degreed, carried up in final degree. Final degree was passed.
Yes, it was also bad for partition.
Yes, partial partition.
Should have been.
And then summons, I have brought the entire order sheet.
Provided you file an appeal within time. Such a long delay, 9
But
years.
that was not within my knowledge. I have stated, my lord.
So, Mr. Basu, you are in both the appeals, both the section 5s, in these two appeals, you have cited the same date of knowledge, obviously.
Yes,
You also came to know of the preliminary degree as well as the final degree on that date.
Yes, on to 2024.
From what?
From the plaint that has been filed, which I have obtained certified copy subsequently from one of my close relative that a suit is pending before the same said court.
You have averred in these applications that it was served at summons of the previous suit was served at an address you were not residing there.
No, that I knowledge I had gathered when I obtained the certified copy of the earlier suit of 2016.
No, but that you have stated. But what prevented you from appearing in that suit? Because summons must have been served.
No, summons was never been served. And ultimately they undertook, by order sheet says that the plaintiff undertook the liability not to serve.
Where do we get that?
May I just
To us?
May I just indicate? The entire order sheet I have brought. The order sheet of
Whatever you give us, you have to give a copy to them also.
But then I have to get it xeroxed one. I've got 3 copies for
They
you.
won't know what you are in your hand.
This is the order sheet of the title sheet of 2016.
Mr. Shanal is not supposed to be a.
Copy আছে?
Will you know what will be
order
that?
sheet টা? এটা তো order sheet টা। এই order sheet একটা certified copy দিন না। মানে may I get the original to your lordship and get me the xerox copy? I'm giving. এটা my lord কে দিন, এটা ওটা। এটা order sheet, entire order sheet of 2016. মানে prior to that, may I just indicate to your lordship, if my lord may kindly takes up can 2 of FAT 76 of 2025, that is a section 5, or challenging the final degree. May I just indicate
76.
76 can 2. If my lord may kindly turns to page 13 once. 2 documents I show to your lordship prima facie.
Page 13 of can 2 of 76.
Can 2, that is the section 5 application, which is a delay of 828 days delay.
13, page 13.
Page
yes.
13. My lord may kindly see defend number 1. Shri Minal Kanti Samanto. Man, I am the appellant before your lordship. Minal Kanti Samanto is the appellant.
Defend
Page
number-
13 is the defend number 1.
13, no.
Page 13 of can 2
No.
of FAT 76 of 2020.
Can't you stay?
Yes. Can 2 is the section 5, my lord.
No.
But that has been perhaps been wrongly given in my.
So page 13 of the can 1 we are looking
Yes,
at.
can 1.
Which is the
That is section 5.
Which is the section 5. Yes.
Wrongly written as can 2 in my brief.
Mhm.
My lord may kindly see the Shri Minal Kanti Samanto. The name of the appellant is there. My lord, plaintiff
Yes,
is there.
you are Minal.
Minal Kanti Samanto, son of Ashutosh Kumar Samanto.
It's Milon or Mrinal.
Mrinal. Mrinal, sorry, my lord.
L and N have been.
Mrinal.
Anyway.
Mrinal Kanti Samanto, son of such and such, village PO such and such, and now resides at 19 Club Row, Shukher Park, PS Shukher, Calcutta 27. Calcutta 27 is Bhavanipur. There is no Shukher Park. Kindly see
Is
my.
there any Shukher Park? We don't know any Shukher Park.
But kindly see my address I've given in the.
There is a Shukher Park in Calcutta.
No.
All parts are Dukher, most probably.
All
At least for the
Dukher.
young people.
First time I have come to know that there is something Shukher. There is no Shukher in West Bengal. Now kindly see my lord. 19 Club Road, Shukher Park, PS Shukher. Police station Shukher. Shukhekor. Calcutta 27. Calcutta 27 is Bhavanipur. Now kindly see my address.
Does not exist. This address.
This does not exist. The address is my address is. Kindly see the address given in the.
Permanent address is correct. Village and PO.
Yes, that is correct. But now.
Have served there also.
No, not has been served. There is no service return.
You know, the court's direct.
But there is no service return. I showed it from the order sheet itself. To your lordship's satisfaction. Now kindly see the address I have given where I now resides. That is 19 Club Row, Shukchor Park, PS Khordha, Calcutta 7,0115. Now to corroborate those documents, I have given the EPIC card, that is voter ID card, Aadhaar card, and the bank account. Those bank account has been opened prior to the institution of the suit. Kindly see page 45, 46, and 47 of the scan.
All right.
45.
Yes.
45, your lordship may kindly comes to. Kindly see Minal Kanti Samanto, address given 19 Club Road, Shukchor, Khordha, North 24 Pargana, 7,01,015. 115. Next page, page 60, 46 is the Aadhaar card. Address given at the bottom. Son of Ashutosh Samanto, 90 Club Road, Panihati, Mufatsil, North 24 Parganas.
So let's see the order sheet.
Now kindly one document more. Kindly see page 47. This is the savings bank account which has been opened much prior to the institution of the suit. Kindly see opening date 21 September 2005. Now 2016 is the date of the institution of suit. Now kindly come to the order sheet once. Pilot may kindly see order number 2.
Date of the impugned judgment is when?
Date of the impugned judgment is of the preliminary degree.
Yes, give us both.
That your lordship will get at page 70. Page
give us the date.
Yes. May I just indicate page 23. That is 3rd of November 2016. Preliminary degree.
And final?
Final degree. Final degree date. May I just indicate?
Yes.
Final degree.
Preliminary degree has
Final
to
degree
challenge
page 36, 28 to 36.
page. Date.
Date. Matlab 14th of December 2022.
Your 76 appeal number 76 is against final.
Final degree.
Very good.
My lord, may kindly see order number 2. Matlab few orders, my lord, 10 to 12 orders I will place before lordship.
10 to 12.
10 to 12.
It was the last position.
My lord, last I will show, my lord, there was a series of direction to serve upon defendant number 1 to 4. They are the main contesting defendants. Whether they have served, that is not appearing. Firstly, there is no service return.
From the last such order, we'll get that till that date they have not served. Why place all the orders?
My lord, may kindly.
There are 100 orders. Show us the 100th one to show that till that date they had not served.
My lord, kindly see order number 16 and 25. Thereafter, I will show to your lordship. No SR found order number 41. 16, 25, 41.
Yes, order number 16 says fresh steps.
Fresh steps. Now, order number
both ways. So, therefore, it was not served either way.
Not served either way.
So,
now, kindly see order number 19.
Was the last order like that? Why are you replacing all the orders?
Lord,
this is sheer wastage of time, Mr.
But paper publication, there was a direction for paper publication. Page 25, order 25. Order 25. Kindly see, my lord. Order number 25 dated 2/2/2015. Plaintiffs and defendant number 3 and 4 filed separate hajiras.
Defendants? You?
I'm defendant number 1. Plaintiff files a petition under Order 5, Rule 21A, capital 1A, read with Section 151. The said petition is taken up for hearing. Heard the submission of the learned lawyers appearing for the plaintiff.
5, 6 and others were served. They are not your relatives.
No, they are
Must
the
be your
performers. Okay, main contesting defendant is 1 to 4. Now kindly come to the ordering portion. That the petition under Order 5, Rule 21A, capital A, read with Section 150 of the CPC is allowed ex parte. Let the summons upon defendant number 1, 2, 3, 4, 8, 9, 12 be served through paper publication. The plaintiffs are directed to submit draft of the paper publication within 3 days. Be it mentioned that the newspaper must be of the area where the defendants ordinarily resides and works with them. But so far as ordinarily resides, I reside at Khordha. The paper publication which has been made is at Midnapur local jurisdiction in Ajkal.
Which local jurisdiction?
Of Midnapur, where the shoot has been instituted. Bakura, Ajkal, that I have annexed. Now I reside according to them.
No. According to them also you reside in Calcutta.
According to them, I reside in Calcutta.
But Bakura also. Achha.
Now they have it is within their knowledge that I now reside at the
ordinary. The paper publication was made in Bakura only.
Bakura only.
Not Kolkata.
No. And secondly, my lord, may kindly see the last order which I will draw your lordship's kind attention. Order number 61. Order number 61.
Yes, 61.
My lord, it appears from the record that the notice have been served upon defendant number 5, 7, 12. Defendant number 13, 14 appeared in this case. It also appears from the record that the petition dated 20th September praying for exemption of service upon defendant number 1 to 4. 1 to 4, I am defendant number 1. 6, 8 to 12 was allowed.
Let us see order 43.
Order 40.
Order number 40.
Order 43. Order number 43. Yes, my lord.
Because it refers to that order.
Yes.
Was allowed in terms of.
That is appointment of a commissioner.
No.
Let survey past commissioner, namely Amitabh Chaudhary, be appointed as advance commissioner.
The order number 61 says
yes
that praying for exemption of service upon defendant number such and such was allowed in terms of order number 43.
Order number 43, my lord, it does not reflect so.
Yes.
It says only that the preliminary degree has been passed. Final degree may be dropped, but the commissioner may be appointed to effect final degree. Kindly see, may I place the order. Today, the record is taken up for hearing of the petition filed by the plaintiff degree holder. Had the learned lawyer for the plaintiff petitioner over the petition dated 20th September 2018, peruse the same considered, peruse the CR and SR against the defendant's judgment debtor, which appears to be returned unserved, even on successive occasion considered. At this stage, as the preliminary degree has been passed against the same defendant judgment debtor, I do not find any cogent reason to afford any further opportunity to the judgment debtor for their appearance, keeping in mind that the report of the SR. Therefore, in my view, the prayer as made by the plaintiff degree holder may be allowed. Hence, it is ordered that the petition filed by the plaintiff degree holder is allowed in terms of the prayer, and the same is disposed of on contest without cost. The plaintiff degree holder is to proceed to effectuate the preliminary degree.
So this exemption was for the final degree proceedings.
Yes.
Because you have already been served.
I have not been served.
No, that was the presumption that you have been served. That's why.
No, it comes returned unserved even on successive occasions. What is the partial endorsement?
I'm not saying that, Mr. You are not understanding what we are saying. Rather, we are not being able to make you understand. You don't require to give a further notice for a final degree proceedings. It's a continuation of the same suit. Therefore, the last order is passed on that premise. It has been said that further. But your first argument, if that is accepted, then everything goes. The further
Yes.
This is your case.
Yes,
Let us hear him. Yes, Mr. Shanal. Gross abuse of the process of court.
3 sisters and 1 brother's lordship.
Sisters, brothers were not on fraternity.
According to their lordship, submission lordship, kindly consider paragraph 11 of the lordship.
Have you got a copy of this order sheet?
Yes.
Look at the order sheet and answer us. Come to this. This peculiar order. First of all, you have to satisfy us because from the amended plaint, we find that a wrong address has been given. There is no such address in Calcutta also. Plus, they have given the right address now.
Now,
so obviously, there was no service on them.
Entire order sheet, I've just.
Entire order sheet need not be gone into. We are seeing the last position. Paper publication is the last position on summons.
Paper publication was their lordship.
Ordinarily recite that is on the basis of the plaint. Wherever it was served throughout the suit, it must have been at the addresses given by you. One address is permanent address, and you state here that they now reside at.
Now resides at.
Everything up to 19 Club Road is fine. After that, something else.
May I come back one day?
Don't come back.
Because
definitely come back with some other case.
Yes, lordship. Because lordship, there is.
Come back with some other case, Mr. Shan.
Now, lordship, kindly consider lordship because they
are allowing this section.
They have gathered knowledge from the person who is the lordship son of the defendant number lordship, the plaintiff number 2.
How do you know?
Kindly consider lordship page. The section 5 application lordship, their section 5 application.
Which para?
Page 18 lordship, page 8, paragraph 11 lordship.
Yes.
The
continuation of para 11.
Continuation, it's lordship in.
No, this is
75.
Oh.
In connection with 75 lordship. In 76.
It should be the same in 76.
Same lordship because both the appeal lordship same grounds has been taken lordship non-service.
Must be same, yes.
Lordship in 75 lordship kindly consider paragraph 11 lordship.
Yes, that your applicant states.
The applicant states that in the month of August 2024, your applicant over telephonic conversation with his
this is 76.
76 lordship.
76 para 11 of
it's lordship
section 5.
Section 5 lordship para 11 lordship.
Section 5 para 11 starts with that your applicant states that your applicant is residing permanently at the address such and such.
If it is 7.
12 is in the month of August.
In my application lordship, it is lordship.
Your application should not be different. Is it
75 can 2 lordship.
We are seeing 76, which is very well. Please read your paragraph. We will catch you. Para 12.
That your applicant states that in the month of August 2024, your applicant over a telephonic conversation with his nephew, namely Prabhat Kumar Gupta, first time came to know about the present partition suit. That is title suit number 16 of 2013. And the order passed thereon. The nephew of the applicant further informed about having another pendency of the partition suit of title suit number 124 of 2024.
So not that after getting summons of the next suit they have learned.
Now, lordship, this lordship Prabhat Kumar Gupta is the lordship son of lordship Meera Gupta, who is lordship the plaintiff number 1, lordship defendant number 1, respondent number 1.
Plaintiff is you, your side.
Yes, lordship, the respondent number 1, Meera Gupta.
So what?
So, lordship, he has always a touch with the lordship sister, knowing very well, lordship, he has full knowledge about the suit. He did not participate.
If he had so full knowledge, then why did you mention his address at as something else? You must have had also touch with him.
Now, Lordship, so far as they are, Lordship, this is, Lordship, one, and another thing, Lordship,
This
kindly
does not
consider-
improve the situation. If you had the sister and if you had touch with him, then you should have mentioned the correct address. And if you had touch with him, then it's all the more imputed, the knowledge is imputed regarding his real address. But still you proceeded on a wrong address deliberately then.
May I come back, Lordship? Because, Lordship, I have to take instruction in this regard.
No, no, what is the question of
entire order sheet,
Mr. No,
yes.
Mr. Channel, this practice is, we deprecate this practice. Whenever the court poses an inconvenient question, you want to come back with some instruction. Sorry.
No, no.
When you took the brief, you came today, you did not say that you were unprepared.
May
During
I-
hearing, we cannot adjourn every matter for the counsel to take instruction from client
No, Lordship,
when
because
posed with
I-
an inconvenient question.
have to, Lordship,
We get
go-
it clearly from you, this and with
Now,
whatever is there, we are proceeding on the records, not on the averments. The records are very clear. We'll keep on record this order sheet, and we have on record your plaint.
Now, Lordship, kindly consider the order sheet, Lordship. Then, Lordship, we have to, Lordship, file an opposition, Lordship.
No question of opposition.
Section
Sorry.
5, Lordship, there is a three.
This is a certified copy. We are taking the original certified copy. What is the question of opposition to the order sheet? We have a certified copy with
No,
us.
Lordship, regarding delay.
Delay, what will be your stand there? Disclose, indicate the stand. What will you disclose in the affidavit? No. Tell us that, we may permit you.
May I go through the order sheet, Lordship?
We'll come back tomorrow. Come back tomorrow. Go
Oh,
through
one-
this order
one
sheet.
day.
Very. FAT 75 of 2025 has been preferred against the preliminary decree passed in a partition suit of 2013, whereas FAT 76 of 2025 against the final decree passed in the self-same suit. Full stop. The preliminary decree was passed on November 3, 2016, whereas the final decree on December 14, 2022. Full stop. Common explanation for the delay in preferring both have been furnished in the connected condonation applications. Full stop. Next para. Learned counsel for the appellant places reliance on the certified copy of the order sheet of the trial court in court, and relying on the same, prima facie shows the court that the address of the defendant number 1/appellant as mentioned in the amended plaint of the said suit, filed by the plaintiff/respondents was erroneous. Full stop. Whereas the appellant resides at 19, Club Road, Sukhchor Park, Police Station Khorda, Kolkata 700115, the current address of the appellant was shown in the plaint as 19, Club Road, তারপর double inverted মধ্যে Sukeher, SUKEHER Park, P full stop S full stop hyphen Sukekor, SUKEKOR, Kolkata space hyphen 27, double inverted close. Full stop. Next para. Vide order number 25 dated February 2, 2015, the learned trial judge had recorded that since summons had not been served on the defendant numbers 1 to 4, who are the main contesting defendants, substituted service should be effected by newspaper publication in the area, double inverted, where the defendants originally reside, double inverted, reside and work, double inverted close, full stop. Although such direction was in consonance with the statute, fact remains that if the current address of the appellant was given erroneously in the plaint itself, the paper publication must have happened in the said area only, in the said area only. Full stop. Thus, we prima facie find a strong case for condonation of the delay having been made out, since summons were never served on the defendant number 1/appellant. Full stop. Even from order number 43 dated January 8, 2019, passed at the final decree proceedings of the suit, it was recorded by the learned trial judge that as the preliminary decree had already been passed against the same defendants / judgment debtors, The court did not find any cogent reason to afford further opportunity to the defendant stroke judgment debtor for their appearance, keeping in mind the report of service return. Full stop. Relying on the same comma, video order number 61 dated September 19, 2022, comma, the learned trial judge reiterated that the করবে না, learned trial judge allowed an application for exemption of service upon defendant numbers 1 to 4, 6, 8 to 12 in terms of the order dated January 8, 2019. Full stop. Hence, at this juncture, learned counsel for the plaintiff stroke respondent numbers 1 to 3, Mr. Shanal?
Yes, Lordship.
Plaintiff stroke respondent numbers 1 to 3 seeks some time from the court to take instructions on the order sheet which is handed over in court today, and a copy has been served on him. Full stop. Accordingly, let the matter stand adjourned till where we will give you till Monday. Adjourned till March 23, 2026, when the application shall next be listed under the same.
Grateful. Grateful.
Yes, Mr. Vasu, you have apparently changed our view. Subject to what Mr. Shanal says. Mr. Shanal also did not know of this. Could not have known. He would have come ready otherwise.
Normally, we Lordship do not oppose any section 5 because
No, this is a long delay. Otherwise, you are really yes. Please oppose, but you must not have been aware of this. Yes.
Great.
Thanks. Next. 30. কি রিপোর্ট এটা কি রিপোর্টে লেখা রয়েছে একটু দেখে দেন না কেন রিপোর্ট রেকগনিং সার্ভিস তাহলে এখন কিছু রিপোর্ট নেই তো Mr. Banerjee, what is it?
No, we filed the paper book. Lordships had granted us the liberty to file the supplementary paper book also.
Right.
Which was very, very short,
We were, intending to take up the appeal along with the application.
Yes, Your Lordship, that was the direction.
Please give another notice to them. We'll record an order, and if they don't come tomorrow, we'll hear you expertise.
But on the last occasion, my lord, they were present. Because they were present, Your Lordship had dispensed with its record.
Yes, we can find that. Yes, that's why you are saying that since they're appearing already, and we will. What is the point you want? You are appearing.
Yeah, Your Lordship, I am for the respondent. I am praying before Your Lordship for 1 week adjournment, Lordship.
Why?
I have a problem in my eyes actually. I have to check it this one. 1 week, Your Lordship, please.
He'll be your eyesore for a week. Very well. On the prayer of learned counsel for the respondent, the matter is adjourned till March 23, 2026. Mr. Patra, please come prepared. Ensure that you're. Yes.
Then may I just make one request? Instead of Monday, could it March 23rd?
Yes. March 23rd is Monday. Sorry.
Yes.
March 24th. March 24th. Returnable is March 20. The paper books filed today in court be kept on record. You are filing these today. Paper books.
Yes, the supplementary.
Be kept on. Sorry, supplementary paper books filed in court today be kept on.
অন্য পেপার বুকটা আগে সার্ভ করেছো ফাইল করে দিয়েছো গ্রেট
and appear for the appellant manner. This is that matter where we are on the course of settlement before the Supreme Court. This is the final order passed under Article 1. And internal page 4, my lord will find the details.
Yes.
All settled, all done.
Thank you.
Internal page 4 is the details of the proceedings pending, including this one.
So we'll just we'll keep this on record and drop the appeal as infructuous.
Yes. That contempt may be dropped, my lord. The appeal may be disposed.
There was a contempt also.
There was a contempt since there was an order of alimony pendentility. That was challenged by them before the Supreme Court.
Contempt আছে really?
Yes, my lord. That's appearing at item number 32.
Right. Learned counsel appearing for the for the appellant.
For the appellant.
Learned counsel for the appellant as well as learned senior counsel appearing for the respondent apprise the court that the matter has been mutually settled between the parties, which is also reflected in an order dated February 23, 2026, passed in petition in the petition for special leave to appeal within bracket C bracket close number 18392/2025, a copy of which order is handed over in court today and kept on record. Full stop. From the said order, it is evident that the parties have agreed to settle all litigation pending between them, including the present appeal and the connected contempt application as well. Full stop. Hence, FA 154 of 2025 along with CAN 3 of 2025 as well as CPAN 1142 of 2025 are disposed of as infructuous without any orders to cost. Interim order, if any, stands vacated.
Grateful.
I'm grateful.
That my lord.
CAN 3.
Can 3, my lord.
That is already, that is.
Yes, yes. I'm grateful.
I'm grateful.
Thank এখন ঠিক অ্যাপ্লিকেশন দিয়েছি, রং অ্যাপ্লিকেশন পাঠিয়েছিল একদিন, রেকর্ড রয়েছে আমার। অর্ডারটা দেখুন। Application was sent on the last occasion.
Yes.
Yes, what is that?
Lord, this is my lord. My suit has been dismissed. Suit for eviction on the ground of eviction of trespasser. Lord, I filed
This is Shishir Kumar Mullik versus.
Yes, Shishir Kumar Mullik, Somir Mullik. Yes, my lord. This is my application, my lord, for expeditious hearing. There is no scope of any
Your
interim order.
eviction suit has been dismissed.
Dismissed.
Eviction suit under which?
2G, my lord, trespasser. My lord,
Why
already
dismissed?
dismissed, my lord, on the ground that we could not, my lord, give the death certificate of the original tenant. My lord, that was not given to us, my lord, third party, my lord.
Still you don't have it?
Third party document, my lord, we don't have it. My lord, this it is
Third party document, you can obtain it from the municipality or the corporation.
my lord, it is an admitted case. Earlier, the suit was filed on the ground of section 6 of the reasonable requirement default. That
But
was
you could obtain under RTI Act. You could, if not RTI Act, then normal application before the corporation. Why should we advise you? If you don't have that, you are asking for expeditious dismissal of the appeal.
no,
Not disposal, expeditious dismissal of the appeal. If you don't have that document. Without death certificate, how can we know?
Certificate turning.
But Mr. But we can appreciate this, Mr. Bhattacharya. When was the suit filed?
2006.
Did they show anything to show that he is living?
Millard, what happened, Millard? The eviction suit, Millard, under the Premises Tenancy Act, that was filed against the father. During Millard, the pendency of the suit, since 5 years have elapsed, Millard, we substituted Millard the mother and the present only mother got substituted. Now Millard, mother also expired. Now Millard, we have filed Millard this present suit against the
You withdrew that suit.
I withdrew that suit.
And
Now,
this suit.
this against the mother, Now, Millard, the court is Millard seeking the death certificate of the father.
Yes, but in the previous suit, something was produced.
The previous
Anyway, we are not advising
7-2 Millard.
Free advice now. You are sufficiently competent, Mr. Bhattacharya, to
Yes, I'll take.
So the present appeal arises out of the dismissal of the appellant suit for eviction on the ground of operation of section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997. Who's up next para? In view of the long pendency of the proceeding, which was preceded by an earlier eviction suit, this court is of the opinion that the expeditious hearing of the appeal as sought for in the present application ought to be permitted. In view of the innocuous nature of the prayer, we do not direct service of notice of the application on the respondent. CAN 1 of 2025 is accordingly disposed of by directing the trial court records to be brought by special messenger at the cost of the appellants to be deposited within a week from date. The appellant shall put in postal cost, requisite, and written up notice form for service of notice of the appeal on the respondent within a week from date. The appellant shall prepare and file the requisite number of informal paper books without comparing the records within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. No orders to cost. Thank you. Ashraf, বলছি আগের দিন সব 2025 order date at the Yes.
I beg to appeal for the respondent plus 1, 2, and 3 in the matter.
I'm late while
My opposition.
Yes. Yes.
My lord, I am led by learned advocate Kalyan Chakraborty. My lord, he is not present today. I am praying for 3 weeks accommodation for reply, my lord.
Are you enjoying an interim order?
They are.
We'll vacate the interim order. We are granted putting the matter out of the list. We have done that in the morning.
My lord, my senior is
sorry,
not present, my lord. My lord,
Why 3
kindly,
weeks?
my lord.
He will not be here for 3 weeks.
And then my lord, 2 weeks, kindly, my
No,
lord.
this is not. We are not bargaining with you, ma'am.
No, my lord.
Why is he not present in court?
No, my lord, today is not.
What is the ground for asking for 3 weeks adjournment?
My lord, actually, my learned senior said that he will take 3 weeks, so he asked me to pray for 3 weeks, my lord.
What is the nature of the interim order you are suffering?
My lord,
Mr. Jha?
there's certain amount which is lying in the bank. That is the pensionary benefit of the deceased husband. So this
Your husband?
My husband. Now there is a claim since the succession certificate was granted.
First or second, no, that. What is the nature of this stay?
My lord,
the imputed degree has been stayed. Degree is money degree.
No, it was not a decree. It was the grant of succession. The revocation was rejected.
So what sort of injunction we passed in respect of the subject property?
That's a bank account. And this is basically, if the matter is heard, it will be found as a frivolous application. Because
we'll grant them adjournment till Monday. An adjournment of 3 weeks is sought by the appellant. Full stop. Next para. However, we find that the appellant is already enjoying an interim protection and as such refused to grant such long adjournment. Full stop. Be that as it may, on the prayer of the appellant, the matter is adjourned till March 23, 2026, when it will be listed under the same heading. In the event the appellant is unrepresented or seeks further adjournment, the matter ex parte orders may be passed in the absence of the appellant. Please inform me, senior. You are filing your opposition today.
I have not been served with a copy of any reply till date.
Achha. Affidavit in opposition filed today be kept on record. Full stop. The time for filing reply is extended till the returnable date.
Much obliged.
Tell Mr. Chakraborty that you have extended the time for reply till Monday. But you have to give a copy to Mr. Jhaz, either of them. Yes. Yes. Next. Ma'am, give your appearance, please. Your appearance, not Mr. Chakraborty. Yes. What is the matter?
Lordship,
for the respondent.
for the appellant suit for the partition lawsuit.
Preliminary degree.
Preliminary degree.
Appearing for the first time, this application?
First and second time lawsuit.
So we have granted an interim order.
Interim order is there, my lord, usual interim, but my lord, here in the instance case, my lord, there is no challenge to the share, declaration of share.
What is the ground for appeal?
Grounds, Lordship, that the 1/5 share is declared the trial court, but not considered the registered deed.
You are the plaintiff.
I am for the plaintiff and appellant lawsuit.
So your 1/5 share has been declared?
1/5 share declared, but 1906 of 1995 have been executed and registered deed by Priyanath Hadar in favor of the defendant number 2, did not consider the trial court lawsuit.
No, you challenge that deed.
They challenge the deed. They claim that the one probate case is pending, one probate case is going.
So you are admitting the share 1/5.
Yes, 1/5 share is admitted lawsuit, but
if the deed is cancelled, your
deed
share
is
will
cancelled.
increase.
2 did
Increase.
in case lawsuit.
If it increases, why are you admitting the share?
1/5 share.
Yes, Mr. Chatterjee.
Now what happened, my lord? The court has held 1/5 share. There is no admission on that. 1/5 each. Now, my lord, only problem is that our predecessor, my lord, at the time when he was alive, my lord, he sold out a portion of the property demarcated fashion to defendant number 2. So the trial court has.
He could not demarcated, but
He
that
was the
share
absolute owner. So, my lord, absolute owner, my lord, demarcated way sold the portion to defendant number 2.
You are 2.
My lord, I am for all now, my lord. Now, my lord, what happens, my lord, the court says he challenges that deed in the prayer, my lord, not in exact manner, but there was a challenge, my lord, I take it. Now, my lord, court says since that challenge was not upheld, now court allowed that sale and court declared 1/5 share. Now, my lord, his appeal, my lord, is based on the ground, the challenge which he has thrown to the deed, court has wrongly held that sale deed was correctly done. Now, my lord, in that, my lord, court has said even if that sale deed is there, so court has
intersay the defendants.
Intersay the defendants. Now, my lord, that portion if curled out, the remaining can be partitioned. My lord, today, if to that 1/5 is there is no dispute. My lord, total property is 1.3.
So one of your predecessor,
my lord, we have same predecessor. My lord, only that defendant number 2 is outsider to whom the property has been sold.
Defendant number 2. No, you are appearing for the outsider also.
Yes, my lord, because its interest remains the same because we are.
You are not challenging that.
No, I am not challenging. We are other brothers, my lord, who accent to the sale which was confirmed by our father. Now, my lord, even if
the appeal.
yes, my lord, but my lord, with the portion, my lord, with the if my lord sees the impugned order in the preliminary decree, court has said that portion of the sale can be separated. So, my lord, if that is separated, the remaining portion there is no challenge.
No, Mr. Chatterjee, that will be an awkward proposition because suppose that is the best portion, suppose, or that is one of the portions. The share might be different, the allocation might be different if that is taken in. Suppose that comprises of say 50 square feet or 5 acre or whatever.
18 shotak is the
18 shotak. So if that 18 shotak is taken into consideration, then the shares of each one may be different. I mean, the entire conglomerate has to be taken for considering the.
Because that's a portion of a ground floor absolutely separate from my lord.
No,
Our
the
portion.
usual order will be passed. Partition commissioner will hold whatever, but no final degree. That is out. So in any event, that will be done. We'll proceed up to that stage. That is the usual order we pass. Affidavit of service filed to be kept on record. Full stop.
Already received the deposited the special messenger cost and the.
You have deposited.
Yes, already received all of
We have
that.
passed those directions. Very good.
আটকালে court to direction দিচ্ছে commission করবে.
Pro forma respondent. Who is the pro forma respondent?
He was the co-plaintiff. That's why pro forma respondent. But in partition suit, all are respondent, all are
Already served.
Served, this application has been served, but regarding the appeal, you have to then.
Notice of motion served.
Isn't she with you now? She was a plaintiff with you. Why? She's not with you?
Everybody is accepting the sale. Miller is accepting him. All heirs are accepting their father's sale.
Then you have
He
to
was
serve
not-
notice on the pro forma respondent. Partition suit all have to be served. For that reason, it will be delayed.
Served the lordship the register post and already served.
Oh, service of notice of the appeal through the
Notice
court.
of service, the proponent respondent served. Direct.
What has been served? What has been served on the pro forma respondent? Notice of appeal.
No, lordship.
That is what we are saying repeatedly.
Yes, lordship.
You are saying served. Better not to say. Let's pass over. Thank you. Now you are appealing up to 5.
I'm appealing up to 5. Miller accepting the pro forma one.
Very good. Can one of the present
But Miller,
appeal analysis-
only one thing, Miller, one has died.
Who?
Miller, 3 probably, but the death certificate is not with me. So Miller.
Then we cannot take up anything.
Yes.
No, nothing in the name of death.
Miller, but Miller, he is on instruction. Miller, he has taken instruction on phone that 3 has died. But I have sought for the death certificate. Without that, even I cannot apprise them of
Give you
taking
a
the
week's time.
substitution.
I will give you a week's time to furnish the details.
Details, yes. একবার জিজ্ঞেস করেন
Affidavit of service filed to be kept on record. Full stop. Learned counsel for the respondent submits respondent numbers 1 to 4, 1 to 5 submits as per instruction that respondent number 3 has died in the meantime. Full stop. Accordingly, the learned advocate on record for the respondent shall furnish the date of death and the particulars of the heirs and legal representatives of the said deceased to the learned advocate for the appellant to enable the latter to take steps for substitution of the heirs and legal representatives of the deceased respondent. Full stop. Next para. Accordingly, let the matter be listed next in the monthly list of April 2026 under the same heading. Full stop. In the event any substitution application is filed in the meantime, liberty is given to the appellant to mention the same for inclusion in the list along with the present applications. Mr. Chatterjee, do that quickly so that it can be expedited. And wherever you file that application, substitution application, please just indicate that the main matter is directed to appear in the monthly list. So let it appear along with that. In your mentioning slip, please write the name of the main matter also. Right. Next.
Miller, only instead of 3, it should be 4. Prionath Haldar died.
Ageta 4.
But in this matter, I am for the defendant appellant. Well, kindly give me 10 days more time to get this service return. In the first service, my lord, was there, when the postal article has come back with endorsement, my lord, not claimed, unclaimed. Last occasion, my lord, directed since it was coming back, it was not with me, my lord. since it was in coming back, therefore they have given a fresh
It has
direction.
come back as unclaimed.
Yes, it has come.
Was it an
and
they obtained a decree, they are the plaintiff.
no. My the counter claim has been dismissed. Suit is pending.
Acha, their suit is pending.
Their suit is
Their suit is also for divorce, yours is also for divorce.
No,
Counter claim is for
yes,
divorce.
I prefer my lord restitution of conjugal rights.
That has been dismissed. So no, then you must have served at their address as given in their plate.
I shall serve the advocate and
You must have already served on the address.
Yes.
Address
No,
as given by them in the plaint.
Yes.
So insufficient address.
Unclaimed.
Unclaimed is good service. You'll accept that. Why don't you prepare an affidavit of service?
Well, can you take it up tomorrow, my lord?
Tomorrow we'll take up. You ask Mr. I prepare an affidavit. You do it today. Your usual format.
No, but my lord, after this, another order was there. Last occasion, my lord directed me to give a fresh service.
So why did you
that has not been complied. My lord, on that day, my lord, I heard that the matter will be listed on April, a monthly list of April. But subsequently,
learned counsel for the appellant, at the time of call, apprises the court that due to some communication gap, fresh service has not been effected on the learned advocate appearing for the respondent in the trial court. Full stop. However, there has been a change of circumstance in the meantime, inasmuch as the postal article sent to the respondent by the appellant, which was in the process of being returned to the sender at the juncture when we passed our previous order dated March 5, 2026, has now arrived at its destination, that is returned back to the appellant. First up, it transpires therefrom that the service could not be effected due to what is the exact
unclaimed. It is unclaimed. First to endorsement door lock, then my lord next date. It is 2nd of March. It is unclaimed.
The postal article returned with the endorsement could not be served. Postal article returned with the endorsements. Double inverted door lock.
This is the first
inverted close and double inverted intimation was served. Double inverted close. Full stop. A third endorsement within double inverted unclaimed is also found on the postal envelope. Full stop. Accordingly, since the service was sought to be effected at the very address from which the plaintiff stroke respondent is contesting, is prosecuting the main suit, it is deemed that the respondent is deliberately avoiding service and sufficient compliance of the direction by this court to serve on the respondent has been done by the appellant. Full stop. Thus, no further service need be effected on the learned advocate appearing for the respondent in the trial court, and we treat the present service as good service. Full stop. However, due to lack of a formal affidavit of service, the appellant is granted leave to file such affidavit of service, annexing the envelope returned from the respondent tomorrow, when the matter shall next be listed under the same head. Tomorrow we'll dispose of this application and pass the usual. কাল থাকবে লিস্টে।
37, I am for the petitioner, my lord.
Yes, Mr. Chatterjee.
Copy has been served your lordships as per your lordships direction against preliminary decree. Usual order, but
copy has been served.
Copy has been served, but my lord, there is a defect. That is, it is my fault. To opposite party number 1, my lord, instead of his wife, because he already died, my lord, the service was made upon the dead person.
He has received. Thank God. No, your learned junior has the capacity to have it received by the.
Just now it is detected, my lord. So therefore, just give me 1 or 2 days time, my lord. I will again serve upon the opposite party number 1. So far, the others are concerned, my lord, it has been served.
Learned counsel for the appellants fairly submits that although good service has been effected on the other respondents, thus there is some defect in respect of service on the respondent number 1. Accordingly, on the prayer of learned counsel, the appellants are directed to serve afresh on the respondent number 1, indicating that the application shall be listed under the same heading on March 30, 2026, when a fresh affidavit of service shall be filed by the appellants. Full stop. The affidavit of service filed today be kept on record. Yes, Mr. Shanal.
Expeditious disposal of the first appeal, Lordship, for preparation of the paper book and
This is against what, Mr. Shanal?
declare suit for Lordship, declaration of tenancy right where the Lordship landlord defendant. Now suit was decreed.
Declaration of tenancy right was decreed.
Against that
An
Lordship,
injunction.
Injunction.
The present appeal has been preferred by the landlord against a decree passed in a suit filed by the respondents for declaration of the tenancy rights and permanent injunction and consequential permanent injunction. So next para. In view of the very nature of the appeal, the prayer for expeditious disposal as made in Can 3 of 2025 is justified. Puts up in view of the innocuous nature of the prayer, we do not direct prior service of a copy of the application on the respondents. Full stop. Next para. Can 3 of 2025 is disposed of by directing the trial court records to be brought by special messenger, costs of which shall be deposited, by the appellant within a week from date. Stop. Next para. The appellant shall put in due requisites for service of notice, requisites, postal costs, and written up notice form for service of notice of the appeal on the plaintiff stroke respond numbers 1 and 2 at all their addresses, several deposits at all their addresses as mentioned in the cause title of the memorandum of appeal, also within a week from date. First up, should we dispense with service on the others?
Yes, sir.
Service on the defendant numbers 1 to 4 and 5 to 13 stroke pro forma respondents is dispensed with for the present in view of no relief having been sought against them in the appeal. For sub next para, the appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to file, mention the appeal for enlistment as and when the same is ready for hearing.
Okay.
No rest to cost. Thank you.
My lord, in this
Mr.
matter,
Shanal, please give your appearances in the previous matter.
my lord, in this matter, Mr. Suri Sawant is appearing for the appellant, my lord, and today due to some compulsion is out of station, my lord.
The last occasion,
So-
they also asked for adjournment the same count.
No. Are they enjoying an interim order, Mr. Banerjee?
No, it's a question of will. Father executed the will, holograph will. All the sons and daughters, they sign. Then my lord, at the time of, naturally take probate of the will, all the parties were there, daughters. Now, one daughter, other daughters said, no, we are not interested. We have signed, we have seen everything. One daughter, she is contesting, she lost.
She did not get anything in the will.
For obvious reasons, my lord, because they have got the enough fortune from the father. And it is a holograph will, she may have. Handwriting is so clear. There is no problem to understand what is playing in his mind.
We have not passed an interim order.
No.
This goes out of the list.
My lord, it will delay the
my lord
matter.
keeps it, my
Can
lord,
you
next
see?
week, my lord, due
Every
to some
time we have-
compulsion, my lord,
even that-
I have
Compulsion. On the last occasion, what was the compulsion? Every occasion you have compulsion. We are not bound by your compulsion. Sorry. As a matter of right, you are asking for some compulsion. What compulsion, sir? This is appearing before a court of law. No. On March 5th, you have asked for time. Today we are on March 17.
My lord, due to some unavoidable circumstances.
You are there, sir. You are competent. You are aged enough. Please move the matter. What unavoidable circumstance? You are there. You move the matter.
My lord, kindly grants one.
No.
Only one vote.
No, sorry. You move the matter, please.
My lord,
As if a matter of right you have got.
No, my lord, I am not.
How dare you?
like
I mean, please move the matter.
I
If you
not-
don't even have the brief, don't ask for time, sir. Are you in the matter? Are you briefed in the matter?
No, my lord,
Are you the advocate on record?
I don't think so. I am
You
not-
don't think so?
No, my lord, I don't think so because I have not seen the matter. I was
Great.
just told suddenly in the morning.
An adjournment is sought by the appellant. First up, we find from the records that an adjournment was sought on March 5, 2026, when the matter was last called on for hearing, although the respondent number 1 is represented through counsel on both the occasions. First up, next para. Since the appellant is consistently absent when the matter is called on for hearing, let the matter go out of the list for the present. There is no interim order, Mr. this is against what you said? Probate.
Yes.
একটা line add করে দাও. The pendency of this appeal or the application shall not preclude the respondents in any manner from proceeding on the basis of the impugned decree.
As a lordship.
This will help you. Yes. Next.
May I leave, my lord?
Yes. Thank you.
আমার নাম অশোক কুমার ব্যানার্জি।
Yes.
I'm for the response.
Yes.
MAP suit, Lordship, kindly consider the last date order.
Well, this is the affidavit in opposition, my lord, we have served it upon them. They have not given.
Certified copy of the decree has been
Yes,
filed.
decree, Lordship, I have applied, but till date it has not been delivered.
Without the decree, you cannot pass any order, Mr. Mukherjee. It's a defective appeal. What is this, Mr. Basu?
Well, the affidavit in opposition which you are directed to file.
Have you filed any? Are you filing any reply against this?
Lordship, because Lordship, the marriage
is the
which
reply?
is they are alleging.
You have to file a reply against this. Do you want to?
Yes, I will.
Do it.
I will file a reply against this, Lordship. But Lordship, the
You have
kindly.
given a copy of this. So file it now. Reply.
We have served it upon them on 12th of February 2020.
1st of February. What is the reply?
Lordship,
We'll proceed without the reply. What is the application for? Without the decree, did you pass any? What is the appropriate order you are asking, Mr. Mukherjee?
restrain them from marrying, Lordship, till the disposal of the appeal.
Well, that marriage is already done.
Now they are claiming that.
You have disclosed that here.
Yes.
Then
now they are claiming that they have, or the husband has already married. Lordship, kindly come.
Yes.
The,
so why didn't you prefer file a reply, Mr.
Lordship, kindly give
You
me
should
a
have
1 week
explained
time.
yes. If you say it's an invalid marriage, you should say that.
Because yes, Lordship, this is.
Did you grant any injunction?
No.
Subject to.
Now, last occasion, your Lordship's granted it.
Granted, subject to there being. Yes, you were not there, probably.
I was not there. Injunction?
Yes, last
Yes.
occasion injunction.
Yes, we passed something. Because you had to file your
He
opposition.
is not married, I think, and we have already married.
No, not that,
No,
not
the
that.
opposition.
Because initially we had refused to grant any interim order on the ground that you had claimed marriage.
Yes.
But we had to file opposition disclosing that.
Yes, we have
Since
disclosed.
no opposition was filed on the last occasion, which is on 24th of February,
My lord.
we had recorded an order that you will be restrained from contracting remarriage if not already contracted in accordance with law. We put that in because they said that there is no valid marriage. So where we will continue with that order, you will give you 1 week's time to file reply. Despite affidavit in opposition filed to be kept on record, despite service of the opposition having already been effected on the learned advocate for the appellant long back, no reply is filed in court today. As a last chance to the appellant to file affidavit in reply to Can 1 of 2025, such time is extended for a week from date. Next para. The matter shall next be listed on March 24, 2026, when the application shall be taken up for hearing. On that date, we will pass. Mr. Basu, you have not annexed any, only photographs. You are satisfied that this is a well.
There is a document. I
Document is
Mandir. Receipt of the Mandir.
Where Ram Mandir? Other Mandirs we do not recognize. Has to be a good Mandir, Mandir of solidity. Yes, Mr. Basu, you want photographs? We are not convinced. And that is their precise ground. Mr. Mukherjee took on the last occasion that there is no valid marriage in the no valid Hindu marriage or any marriage in the eye of law.
কি দিয়েছো তুমি?
He was invited also.
This is the receipt.
Well, there is this Mata Shiva Samiti, this receipt.
What
from
Mata Shiva Samiti? What is Mata?
They have given
what
a
day?
receipt marriage. This is I will not.
Mata Shiva Samiti?
This has been annexed, Lords.
This has been
This
annexed?
document has been annexed.
In the opposition?
In the opposition.
Which page? No. Oh, yes, it has been. This is the receipt for Pranami. Tishri Mauliksha Mata Seva Samiti in Jharkhand. That has given a receipt without mentioning the amount. Oh, 300 rupee as Pranami. So this is dawar or something. Was it a muta marriage? Hindu muta marriage? Hindu counterpart of muta marriage?
Must be a Shia marriage.
What is this, Mr. Basu?
I know. We'll come up with the
Be
supplementary.
careful for this. The Ides of March.
Yes. And today is
The Ides of March.
Ides of
Because we are putting it. Today was actually near
15th
about
was
the Ides of
day,
March.
15th.
Very well. We'll take it up on after we cross the Ides.
Yes, brother. Grateful.
Thank you. এখানে নেই রকম না ওটা একটা মাঝখানে অদ্ভুত জায়গা আছে দেখুন আমারটা কষ্ট করে খুঁজে পেতে হচ্ছে দেখুন হঠাৎ করে দেখবেন ডকুমেন্টটা ছিল
Before the photo.
দেখবেন হঠাৎ করে ও এটা দেয়নি
পেজ নাম্বার দে
আপনাকে বেশি
দেখেছেন এগুলো পড়ো 6 7 8
Yes, my learned brother's copy is not complete, Mr. Basu. Where is he? Yes, Mr. Basu.
Complete na?
No, that document is not there. Pronami document is not there.
So we'll take it back to the put it up.
But we have recorded, you have filed. একটা লাইন অ্যাড করে দাও আসলে হতে এটা করে দিন the honorable second judge's copy of the affidavit in opposition shall be filed on the returnable date. Please just correct it.
On the next
Returnable date, yes. He'll file it on the returnable.
Grateful. Extremely grateful.
Yes.
I crave to file the review application without the certified copy.
Why? Why at this hour first and why without certified copy? We come back tomorrow morning. We'll consider.
Grateful.
চেয়ার পেছনে গিয়ে পিছিয়ে যাওয়া শুরু হলো। Yes.
Well, there was, my lord, a direction, my lord, to file a supplementary, my lord.
To the section 5?
To the section 5, my lord.
No explanation.
No explanation, my lord. That was, my lord.
The appeal is directed against, just remind us, Sir Banerjee.
My lord, preliminary decree and a partition suit.
Cause of delay?
Cause of delay, my lord, have tried to brief table.
Paragraph 5
Of the original
of
application.
the original application, Lord, as per him, the learned advocate's clerk informed him after 1 year of the passing of the judgment that the judgment has been delivered. তাই তো দেখলাম।
That is the only ground in the original application.
No, my lord, it's not drafted
Original
so
application?
poorly, my lord. Not drafted so poorly, my lord.
Page 4, paragraph 5.
Yes.
Subject to correction, my lord.
What is the any other explanation in the original?
My lord, your lordship was dissatisfied, my lord, with
Yes.
the period of, my lord, from December to October, from, my lord, August to October. August to October of my supplementary affidavit, my lord, your lordship was dissatisfied. Of my section 5 application, your lordship was my lord, may I, my lord, indicate, my lord, in paragraph 5, my lord, page 5, my lord. My lord,
Yes.
my honest senior friend is talking about, my lord, the 5th April 2025. Inadvertently, my lord, it has been made 25. My lord, the next paragraph would, my lord, corroborate that, my lord. It should have been, my lord, 24.
All right. All right. Applied on. No, you have to mention. Very well. Then what is the explanation? You have given the explanation after that.
After that, my lord, kindly considers, my lord.
July, you got the certified copy.
July got the certified copy. After that, my lord, came to Calcutta. Your lordship was dissatisfied with paragraph number 9. In the month of August 2024, the petitioners visited the chamber of the learned advocate for the honorable court, preferring the instrument learned advocate over
Yes,
going
yes,
to
yes.
entire. That was, my lord.
After that, but the appeal was preferred much after that.
My lord, my ground is, my lord, that.
Yes.
My lord, the petitioner number 1, my lord, kindly sees, my lord, I, my lord, tried to, my lord, supplement, my lord, my cause, my lord, that
When was the appeal filed as a checkup? 13th of February 2026.
The lordship was dissatisfied as such, my lord, for the period of.
Between this period, August to
December.
Long delay.
August to December, my lord.
Why December? Appeal was filed in February next year. So from August 2024 till August 2025 is 1 year, and you waited for 6 months even after that, 1.5 years. From August, there is no explanation because the appeal we find from the memorandum itself.
But after that, my lord, there is an explanation, my lord.
What is that?
Kindly, my lord, takes up, my lord, paragraph number 11 onwards, my lord.
Acha, yes.
11-12.
File misplaced, acha.
Misplaced by me, my lord, my chamber.
All right. Very well. And what is the explanation between August and that?
My lord, I have written, my lord, here in the main application, my lord, indisposed. Your lordship, my lord, wanted, my lord, to supplement, my lord, some sort of copies, my lord, so that, my lord, I could, my lord, establish this ground. My lord, kindly take some, my lord, paragraph, page number, my lord, the first annexure, my lord, it's page 4 of, my lord, the supplementary. My lord, this particular person was, my lord, kindly sees the date. Date is 17th of October 2024. This particular person was, my lord, suffering from, my lord, the glucose level was, my lord, high blood sugar, could not come to Calcutta alone. Well, subsequently, my lord, treatment is going on for, my lord, diabetes. My lord, after that, he could subsequently, my lord, come to Calcutta to affirm this affidavit subsequently.
What is the chain of events? August, you visited the chamber. He visited the chamber.
He could not come to Calcutta during this 4 months period.
After that, for 4 months.
After that, my lord, the file was misplaced on myself. On, my lord, my.
When you came back, you misplaced the file.
Well,
very convenient. Misplaced for 1.5 years. No, not that.
In the meantime, my lord, there was a shifting of chamber, my lord. That is, my lord, the actual event.
Was it actually lost from your chamber?
Actual event, my lord, I shifted.
Yes, Mr. Mukherjee.
But I will come, Lord, first, Lord, regarding Can 4, because there is one person died that according to Mr. Banerjee, my lord, he has taken out an application. The original plaintiff died and he has filed the present application stating that he died prior to, my lord, the preliminary decree is being passed before the trial court.
Can 4.
My lord, in my copy, it's can 2 na 4.
Can 4 is not. Nahi to list hai?
Then can 2. My lord, in my copy, my lord, which has been sent by Mr. Banerjee, it's written 2 and both 4.
Not addition of party. The
That is
application
can
for-
3.
Can 3.
But can 3, if your lordship takes up that, kindly takes up paragraph 8 and 9.
Addition of party. এটা সরি।
This is from preliminary decree of partition.
Partition suit. My lord, perhaps my lord, Mr. Banerjee was not, my lord, properly instructed what happened. This person, my lord, this original plaintiff, during his lifetime, has executed one deed in my favor. My lord, that is the son. So, during the continuation of the suit,
You means who?
my lord, I am the Jahangir, my lord, who now, my lord, wants to add as a, my lord, respondent in the appeal. So, my lord, according to Mr. Banerjee, my lord, as per the application suggests that this, my lord, original plaintiff died on 9th of November 2022. That is much prior to the preliminary decree.
So your deed was produced in the trial court and all
Order
this is-
22 Rule 10 application filed, allowed, everything was done. So this is not correct that the
No,
decree
the
has been
original
passed.
respondent number 1 was also there and you were added.
No,
Is
I have been stepped into the
substituting
shoes. Yes, yes.
2210.
That's why, my lord. So, my lord, this
let us-
averments, yes, this averments is, my lord, not correct.
Record that. We'll
Yes,
record.
2210 application filed and that was allowed.
So in any event, Jahangir has to come in
Yes,
place.
that's why in the decree, my lord, the name of mine is there.
Oh, acha, acha. Very good.
So that regarding can 4.
And what about this section 5?
Section 5, my lord, since Mr. Banerjee's chamber, my lord, is being,
Not that, but
my lord,
some
I
explanation has been given.
But it's, yes,
The present appeal, achana, we first we allow this can 3, otherwise the entire thing will be defective. Can 3 of 2026 is an application for addition of one Jahangir Khan, commas, the son of respondent number 1, namely Abdul Alim Khan, on the alleged demise of the said Abdul Alim Khan, who's of next parallel counsel appearing for the respondents, comma, however, comma, submit.
I'm only for Jahangir. I'm
Acha.
representing only Jahangir.
Oh, then how did you appear on the last occasion?
My lord,
You had not appeared.
I'm appearing today itself.
Oh,
for the
yes,
first
you
time.
had not appeared. No. The counsel appearing for the said proposed added party submits that the said party, namely Jahangir Khan, was already impleaded in the trial court and his name finds place in the impugned decree, comma, in view of a transfer deed having been executed during pendency of the suit by the original respondent number 1 in his favor. Full-stop thus, comma, since Jahangir Khan was already impleaded under Order 22 Rule 10 of the Code of Civil Procedure in the suit itself, comma, the premise on which the addition of party application has been made is disputed by the proposed added party. Full-stop next para, be that as it may, comma, either way, comma, it is evident that Jahangir Khan is a necessary party, full-stop, since he was already impleaded in the trial court, comma, it is all the more so that the said Jahangir Khan ought to be brought on record as a respondent, full-stop, even otherwise, comma, on the death of the respondent 1, comma, the said Jahangir Khan would have been a necessary party to the suit. Full-stop, accordingly, can 3 of 2026 is allowed, thereby directing the name of the respondent number 1, Abdul Alim Khan, to be deleted, stroke expunged, and the name and Jahangir Khan, comma, to be impleaded in his place and stead as the respondent number 1. Full-stop next para, the necessary consequential correction to the cause title of the memorandum of appeal shall be carried out by the learned advocate on record for the appellants during the course of the day. Full-stop. Next para, can 2 of 2025 is an application for condonation of delay of about 365 days in preferring the appeal. Full-stop next para, In terms of leave granted by this court, comma, a supplemented affidavit to the same is filed by the appellants. For the next para, upon hearing learned counsel for the parties, comma, we find that initially a certified copy of the impugned judgment and decree dated
28th March 2020.
Yes, March 28, 2024 was applied for full-stop. The same was made available to the appellant stroke petitioner on July 19, 2024. Full-stop. Thereafter, in August 2024, comma, the petitioners visited the chamber of the learned advocate appearing for them now in the present appeal. Full-stop. However, comma, since the petitioner number 1, comma, who was conducting the matter on behalf of the appellants, comma, became indisposed, comma, medical documents relating to which have been annexed to the supplemented affidavit. Full-stop. Next para. Thereafter, comma, the papers necessary for filing the preferring the appeal were misplaced in the chamber of the learned advocate for the appellants. Full-stop. Upon the papers being placed out, comma, the appeal was filed immediately thereafter. Full-stop. Although such contentions are controverted by learned counsel for the respondents, respondent number 1, added respondent number 1, comma, in our view, comma, sufficient and substantial explanation for the delay has been furnished. Full-stop. Accordingly, can 2 of 2025 is allowed on contest, thereby condoning the delay and preferring FAT 413 of 2025. Full-stop. Accordingly, the appeal is deemed to stand admitted and registered and admitted. There will be no orders to costs. Now, what about the other respondents? Then you have to serve.
My lord, already served, my lord. Also served. Also
Others have been served.
Yes, also served, my lord, on the learned advocate appearing for the other respondent.
Very good. So then we'll. There is no any can. What is can 1?
And 1 is, my lord, for staying.
Stay.
Stay.
Preliminary degree against parents. So usual order.
Usual order.
But I just join an issue.
Yes.
But Mr. Banerjee should at least prima facie show where is the defect. Look, there is admitted share.
What is the ground of
Yes,
challenge?
at least to prima facie.
Yes, right.
Appeal does.
Otherwise, the appeal gets disposed of. Right.
This
Usual,
can be
usual
done.
practice.
My lord, I was under the impression, my lord, that the supplementary affidavit, your lordship directed me to serve a copy. That was not, my lord, reflected, not served. I was under the impression that I'll serve a copy of the
Was not
supplementary
served,
and
but
come
I
back.
accepted.
We're not ready on this.
On the
prayer of learned counsel for the appellant, can 1 of 2025 is adjourned for the day.
I'll come
Get
back
prepared tonight.
Yes.
Yes. Can take Calcutta. Want. Thank you. Kal list শুধু can want একটু দেখো। Yes.
May please your lordship. I'm appearing for the appellant petitioner.
Right.
This is my affidavit in reply.
Opposition.
Lordship, oppositions have been filed, your lordship. One reply, lordship, there are 5 matters.
There are 6 matters.
May I just say, today 5 matters are appearing. Lordship had directed for affidavits to be filed in 5 matters. In 1 matter, we have not yet received the reply.
My lord, reply is prepared, but during this period of Roja, my lord, Roja running, the client is Mohammed, my lord. He could not come here, and that is not necessary. All the matters are the same. My lord, let it be, my lord, dealt with other affidavit in opposition are the same also. Affidavit in reply also will be the same. So let it be heard, my lord, today.
So we are hearing can 2 in all the matters.
Yes, your
Can 2. My lord, this is a suit for preemption under section 231, 232 of Mohammedan Principles Law on Preemption. My lord, the plaintiff.
232 of Mullah.
Mullah's Principles Law on Preemption under Mohammedan law.
Yes.
Under the plaintiff, here the adjoining landholder, he is the owner of adjoining land, plot number 724 and 726, which is just adjacent to the lands, plots of lands sold to the third party strangers without offering sale, as per section 236 of the Mohammedan law, Mullah's Principles of Law on Preemption. My lord, on that basis, my lord, the plaintiff appellant could come to know about the sale near about after 6 months. As per Article 97 of the Limitation Act, my lord, he has sought to impeach the, my lord, sale and from the date of taking possession. I have stated, my lord, in the plaint in paragraph number 7.
কি মোহামেডান ল দিচ্ছ হ্যাঁ এখানটা রেখে দাও সরি yes please carry on.
He can just indicate which FMAT is he referring to, the plaint in which.
No,
FMAT
why so many appeals? Why so many?
Because, Lordship, there are 6 parcels of land, Your Lordship, 6 suits, 6 orders.
Kindly take
But
your
the
seat.
app-
I will
no,
clear
you
all the
should
things.
not take a seat. We have asked her a question. You take your seat. Yes. The plaintiffs are different.
Lordship,
Different
the-
adjacent owners.
No, Your Lordship, the plaintiffs are the same.
So 5 different transfers.
6 different transfers, Your Lordship.
One is not appearing.
Lordship, one is not appearing. FMAT 197.
That was appearing on the last occasion.
No, Your Lordship, it has not been appearing for quite some
Past
time.
whatever order in this matter that is when you sorry, we come back to you.
Great.
Article 97.
Article 97.
Physical possession was taken here.
No, my lord, kindly come to the paragraph number 10 at page 35 of the plaint.
But this is very clear. Limitation starts from registration.
My lord, kindly that your plaintiff, humble plaintiff, has come to know that for the first time about the existence of the B schedule, impugned sale deed sought for preemption. Kindly come to the page 35 of this appeal. The plaint, the amendments of the plaintiffs, the pleadings of the plaintiffs. Page 35,
Date of
can 2.
Date of knowledge is not the relevant date. Please come to Article 97 since you are relying on Article 9. Please come to that. When were the sale deeds registered? Mr.
Sale
Adhikari?
deed finally registered on Monday 13 March 2023 in this my lord appeal. In this my lord plaint. This is my lord the
But you filed the suit when?
other my lord, other 2 applications, 3 applications. My lord, other 3 plaints. My lord, there are 6 plaint against the self-same plot of land and self-same my lord defendants, and also
Sale deeds are not of the same date.
no, not on the same day.
When was the sale deed executed?
Sale deed, this in this my lord appeal, the sale deed is executed on 13th.
This appeal means you are referring to which appeal? Appeal
This
number?
is can 2 FMAT.
Can 2 in all the appeals. Which FMAT?
FMAT 4 to 5.
4 to 5. Very well. Yes.
4 to 5. My lord, the sale deed is my lord complete registration. My lord, on my lord 13th March 2023.
13th.
13th. 1-3.
23. And you filed the suit on?
Kindly, I have filed the suit on 18th January 2025.
So that is beyond 1 year.
Beyond 1 year. My lord, I am coming on this one that my lord, so far as he had no knowledge and no offering of sale as per Mohammedan law.
First, you please come to Article 97.
Article 97, my lord, kindly.
Please read out the right hand column. Time from which period begins to run. It was dismissed only on the ground of limitation.
No, kindly come to the page 62.
It was dismissed only on the ground of limitation.
No, kindly come to the page 62. The order passed by the learned civil judge senior division second court. Page 62. My lord, he was satisfied that the suit may go for the trial and therefore there is no urgency. Yes, my lord, kindly come to the page 62. That is the order passed by the refusal of interim order.
quasi order. নিচে prima facie case আছে তাও দিল না। জটিল। So why are you addressing us? Limitation is yes, it stares at the face. Why did you start with limitation? They took a point of limitation.
No, this is not point of limitation. My lord, limitation here, my lord,
Why did
court
you
has the
start
power to,
why did you start arguing on limitation? That is what we are asking.
because of my lord, I
This
have
may come in your
stated that the possession has not been taken within the my lord period.
so very well.
The
You say under 97 you come because this is a property of which physical possession is capable of being taken but has not yet been taken. So limitation in fact has not started as per.
Yes.
Very well.
My lord, on that point, my lord, the honorable court's judgment, my lord, honorable
Court
High
has not
Court's
found anything on limitation in the impugned order.
No. Kindly come to the page 62.
We have seen that the court has held that you have got prima facie case.
Yes.
But still refuses because the other side is
I'm
required to
grateful
have.
to you. Therefore,
What sort
my
of
lord,
injunction did you want, Mr. Adhikari? What injunction did you ask for?
Well, only for status quo and not to change the nature and character of the suit property. Lordship was pleased to pass at the time of admission the interim order of status quo and not to change the nature and character. So, my lord, I am praying till the disposal of the suit, let there be an interim order of status quo to be maintained by the party and not to change the nature and character of the suit property and not to dispose of the property.
Injunction application is still pending in the trial court.
Yes. Injunction.
Can at best be the best order in your favor could be status quo or injunction till
Status quo
disposal of
injunction.
that injunction application in the trial. Well, let us hear your others. Yes, Ms. Ali, what is
My lord, in this point, my lord, I am relying on one judgment. That
On-
is
on-
my lord, Nurul Islam versus
on
SL
section 5, on section 3, limitation.
On that point, my lord, that the court has the power, my lord, to my lord, accept to pass the injunction order, my lord, kindly to Neeraj Dorbari case.
No, what is the proposition?
Proposition, my lord, kindly grant the interim order of injunction during the pendency of this.
What is the proposition on which this judgment you are
Kindly see paragraph 15.
Give her a copy or the citation. Mr. Udhikari, give your other side.
So far as my lord, there is, my lord, the learned judge was satisfied to the point that balance of convenience is in the favor of
This is of the Madhya Pradesh High Court.
Yes, it is money relying on in Shankarlal Devi Prasad Rathod.
Which
Kindly
paragraph?
come-
Which paragraph?
Paragraph 15
Yes, 15. Yes.
versus the state of MP and others. 1970 MPLJ 409. It has been observed as below. Although it is often said that the plaintiff must show a prima facie case in support of the right claimed by him in the suit before he can grant a temporary
It's very
injunction.
well settled in law college, you know this.
Great.
You are citing a judgment that to a learned single judge of the MP High Court you have to rely on for this proposition. Couldn't you find anything better? Our High Court has numerous judgments on this.
As
That
your
you need
lordship
not-
desire, kindly pass the word.
You need not yes, plaintiff is not required to make out a clear legal title but has to satisfy as to legal right. And tribal issue and all those things, that is settled. Why cite a judgment?
I am grateful to you.
Not yet. Let us hear Ms. Ali. Yes. Yes, Ms. Ali. Take your seat, Ms. Avdegari.
Lordship, there are 6 separate suits.
Forget those 6 suits. The point is identical, orders are identical.
Lordship, the only thing, your Lordship, until and unless we bring the entire, all the 6 parcels
But at
of
the
land-
ad interim stage, the trial court had to go by their plaint. And their plaint clearly discloses the cause of action.
Lordship, but-
Court held that there is a prima facie case, but without hearing the other side, court did not find confidence.
Lordship, but on
We
the-
have that confidence because we are hearing you.
Lordship,
I mean,
on
this
the-
is a
Lordship, on the face of it, at least 3 suits are
Huh.
barred by limitation. Lordship, kindly takes my affidavit in opposition in FMAT 425. Your
Achha, why do you say? Let us understand the proposition first.
Lordship,
Then we'll look into it.
in 3 suits, the deeds have been executed on 3rd of March 2023. Lordship, the Khotian has been opened in the month of April 2023 and May 2023. I have annexed all
Well,
those
let us proceed on
documents.
the premise that
Therefore,
those are correct.
possession clearly is in 2023, deeds executed in 2023.
No, you have taken possession.
Yes, Your Lordship, I've taken. Khotian has been opened in my
It's an
name.
arguable question. On their plaint, it cannot be decided. You have to file a written objection, go and file a written objection, and we will keep these points open. At
Lordship,
this
but
stage,
it
we
is-
don't find, because see, Vizali, now 97 is very clear.
Yes, Your
If it is
Lordship.
capable of taking possession, then the date of
On the
the
date of
possession.
possession.
Yes. So position here is you are raising this point for the first time. They have filed the plaint on the premise that there is no possession. You say that you have possession. Definitely, you understand that. But that can be decided once you produce the documents before the court to show that there was possession. At the ad interim stage, court had
Lordship,
no
I
business
bow
to
down to Your Lordship. In fact, the point of limitation.
take this point in the
Lordship,
written objection.
if Lordship takes their plaint in all the 6 matters, they're identical cases, that limitation should start running from the date of knowledge.
That is apparent. That was a tenor of. Have they stated that possession was taken by you?
Lordship kindly comes to their plaint, Your Lordship.
Yes, yes. If there is an inkling of possession having been taken by you, then we can consider that. Mr. Adhikari, read it sitting down.
Lordship kindly comes to FMAT 425 I am placing before Your Lordship.
Yes, yes, yes.
Lordship kindly comes to page 26 of that.
Yes,
That's a part of the plaint.
Yes.
Lordship, paragraph 7. Lordship, if I may be allowed to place it.
Please.
That in such a situation, the defendant number 1, along with his associates, suddenly on 16/12/2024, trespassed into the suit land and started to clear up the bushes and rubbishes by breaking the padlock of the boundary gate and demolishing the tin shed Chalaghar, started to take possession over the suit land, and seeing the same, your humble plaintiff immediately came upon the suit land, and being asked, the defendant number 1 disclosed that he, along with his brother, one Ashfaq Khan, have purchased the entire 7.60 decimal of the scheduled property, including the present A1 scheduled suit land from Najmur Rasul and Obedur Rasul. And immediately, your humble plaintiff asked the defendant number 1 and declared upon the suit land that he wanted to purchase the suit land as adjoining landowner, but the defendant number 1 did not pay any heed and flatly refused to sell out the suit land in favor of your humble plaintiff. Thereafter, your humble plaintiff searched the registry office on 13/1/2025, obtained the certified copy of the impugned sale deed, and after perusing the same, your humble plaintiff has come to know that the defendant number 1, without informing your humble plaintiff, purchased the suit land from the defendant number 2, and since purchased, the defendant number 1 did not disclose as regards of his purchase of the A1 scheduled property for avoidance of preemption by the plaintiff as adjoining landowner. So therefore, Lordship, his limitation according to him starts running from 16 December 2024, when he for the first time, he came to learn about the existence of the impugned sale deed. Lordship kindly also sees paragraph 11 at page 28.
Yes, we saw that. Sought for preemption. Well, anyway, you argue your case.
So in these circumstances, your Lordship, at least in 3 matters, the suit is barred by limitation on the face of it, your Lordship.
They have not stated that you have taken possession.
No, your Lordship, that they have not.
If they have not stated that, then if you take the right-hand column of Article 97,
Yes,
Mr.
your
Ali,
Lordship.
then it can be twofold. I mean, 2 options are given. If it is not capable, the property is not being capable of taking possession of, then something else. Then the date of the registration, which is not applicable here, it is capable of taking. If it is, then date of possession is the starting point of limitation.
Yes,
Whatever they say, they plead to be the starting point of limitation. That is a question of law. we need not proceed on that. We have to proceed on the basis of the averments in the plaint, the facts, whether a clear cause of action leading to the case has been disclosed, which has been disclosed, and whether it is otherwise barred by any law on the face of it. So we are not considering his plaint on his pleading that starting point of limitation should be date of knowledge. No, you are right on that. That's a wrong thrust, we may say. So that's a wrong pivot for their limitation pleading. But yet, from the pleadings we find, if we apply independently Article 97 on their pleadings, if we superimpose the two, we can't find that the limitation has categorically been stated to have, the possession has been taken. If that be so, even if we apply, we are applying Article 97, you are right on that. But even applying that, since there is no categorical admission that you have taken possession, at the ad interim stage, court had no option but to grant at least injunction restraining. We are not saying regarding possession. He does not have possession also. But you cannot create, change the nature, character, or create third party. Third party interest they have not asked, so we are not widening the scope of their injunction in the court.
Lordship,
We are only granting nature, character.
Lordship, may I just take a minute here, Lordship? Lordship, in that case, Lordship, may I just make one prayer, your Lordship? If Lordship can make the proceeding, at least the hearing of the injunction application, a time bound.
Without asking. That we do in every case. We will dispose of the appeal instead of continuing this injunction and keeping the appeal pending, which will not inure to either party's their benefit, not your benefit. So we'll dispose of the appeal. We'll say that on consent of parties, we take up the appeal and the application for hearing. We'll give our reasons, the reasons which we told you, and we'll perpetuate this. We'll perpetuate a limited injunction so that you may not change the nature and character, because that is all that they have asked in the trial court. Till disposal of the temporary injunction application in the trial court, you will file your written objection. Have you filed your written objection?
No,
Probably no.
Lordship, I have not.
It is generally not filed. So we'll give you 2 weeks time to do that, and we'll request the trial court to dispose of the injunction application itself within, say, 2 weeks after that.
Lordship, one more prayer, Lordship. If this is possible, if Lordship can record our undertaking instead of...
Don't rely so much on your client. Tomorrow you will be hauled up for contempt along with your client.
I'm grateful, your Lordship.
We are disposing of Mr. Adhikari. We are granting only that injunction nature, because that is your prayer in the trial. The present appeal arises on consent of both parties, the appeal is taken up along with the hearing of the interlocutory applications by keeping on record the affidavits in opposition, keeping on record the affidavits in reply filed today in some of the matters. So, next para. All the appeals arise between the same parties, the genesis being suits for preemption filed by the plaintiff appellant under the Mohammedan law. Next para, the plaintiff / appellant claims to be an adjacent owner of the subject plots, which were transferred by the deeds sought to be preempted. In such suits, upon applications for temporary and ad interim injunction being filed by the plaintiff, the learned trial judge refused the ad interim injunction, despite observing that a prima facie case has been made out, on the premise that the defendants ought to be heard before passing any order to that effect. Next para, learned counsel for the appellant cites a judgment of a learned single judge of the Madhya Pradesh High Court in the matter of Neeraj Darbari versus Manoj Rameshwar Shukla, reported at 2001-2 MPLJ 213 for the proposition that in order to obtain an order of injunction, the plaintiff need not make out a clear legal title, but has to satisfy the court that he has a fair question to raise as to the legal right claimed by him in the suit. It is not the function of the court, it was held, at that stage, to resolve disputed questions of fact or difficult questions of law, which should be left to be decided at the conclusion of the trial. Next para, learned counsel for the appellant, for abundant caution, also addresses the court, please take your seats, both of you, also addresses the court on the issue of limitation and submits that although the suits were filed more than 1 year after the registration of the sale deeds, comma, the filings took place within 1 year from the date of knowledge of such sale on the part of the plaintiff stroke appellant. Full stop. Next para. Learned counsel appearing for the you are for
The respondent, Your Lordship.
oh, acha, very well.
Respondent number
Principal
one.
respondent. Very well.
Lordship, may I just interfere once more, Your Lordship? Lordship, since Lordship is recording my my submissions, if Lordship may also record this, that our point is that he is not even an adjacent landholder, and that point has been specifically taken in the
Very well. Very
affidavit.
well. Learned counsel appearing for the principal defendant stroke respondent number 1 controverts the contentions of the appellant and submits that the suits are barred under Article 97 of the Schedule to the Limitation Act, inasmuch as documents pertaining to recording of the names of the said respondent stroke purchaser have been in the records of rights, comma, have been disclosed in the affidavits in opposition filed in this court. For sub next para, by pointing out to the date of commencement of limitation as contemplated under Article 97, comma, it is reiterated that the suits were filed more than 1 year after the date of possession and, comma, as such, comma, were palpably time barred. For sub next para, even otherwise, comma, learned counsel for the principal defendant stroke respondent number 1 disputes that the appellant is an adjacent owner of the subject properties. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we now arekta line add kora upon hearing age. Learned counsel for the respondent number 1 further points out that the premise of the pleadings in the plaint regarding limitation was as if the date of commencement of limitation is the date of knowledge of the plaintiff of the sale, comma, which is an erroneous premise under Article 97 of the Limitation Act. For sub next para, learned counsel upon hearing learned counsel for the parties, comma, we find that the ratio laid down in the judgment side in the decision cited by the appellant is quite well settled. Full stop. It is right law that at the stage of grant of temporary stroke ad interim injunction, comma, the court is merely to see whether a prima facie case and a triable issue has been made out, and it is not for the plaintiff at that inchoate stage to prove his title to the hilt. Full stop. Next para. Hence, comma, we proceed by applying the said test in the present matter. Full stop. It catches the eye at the first blush that the finding of the learned trial judge in the impugned orders in each of the matters are contradictory to the extent that the learned trial judge, comma, despite finding that a prima facie case has been made out by the plaintiff stroke appellant, comma, refused to grant ad interim injunction on the flimsy pretext of requirement to hear the defendant. Full stop. Next para. Next, coming to the question of limitation, comma, Article 97 of the Schedule to the Limitation Act 1963 clearly stipulates that the starting point of limitation is, comma, when the purchaser takes under the sale sought to be impeached, comma, physical possession of the whole or part of the property sold, comma, or, comma, where the subject matter of the sale does not admit of physical possession of the whole or part of the property, comma, when the instrument of sale is registered. Full stop. Next para. In the present case, comma, it is nobody's contention that the subject property of the sales, comma, which are immovable properties, comma, are incapable of physical possession being taken. Full stop. Thus, comma, it is the first limb of Article 97 which is applicable in the present case. Full stop. Next para. However, comma, it is equally well settled proposition of law that at the stage of consideration of ad interim prayer for injunction, comma, it is the averments and materials produced before the court by way of the plaint and the interim injunction injunction application, which are to be taken prima facie as sacrosanct, comma, in the absence of anything else at that stage to rebut the same. Full stop. Next para. It is well settled that it is also well settled that at that stage, comma, the court only has to see whether, comma, on the basis of the case made out in the plaint and the injunction application, comma, sufficient cause of action has been disclosed and materials have been pleaded and produced to raise a prima facie case, a prima facie triable case to go for trial. Full stop. Next para. Seen thus, comma, from the pleadings of the plaint as well as the temporary injunction application of the plaintiff stroke appellant in the trial court, comma, it has we do not find any clear averment as to when or at all possession has been taken in respect of the subject properties by the principal defendant stroke respondent stroke purchaser. Full stop. The plaintiff has alleged in the plaints of all the suits that attempts to take possession and make construction were being made by the principal defendant stroke respondent number 1 without, comma, however, comma, specifically admitting that the respondent number 1 has actually taken possession. For some next para, in the event the allegation of the respondent number 1 of having taken possession of the property is to be looked into, comma, further materials, comma, which are not before the trial court at the stage of consideration of ad interim injunction, comma, has to be looked into, comma, which are disputed questions of fact and cannot be gone into at this stage. Full stop. Next para. Needless to say, comma, the considerations at this stage are limited to the tests applicable to the ad interim stage, and it will be open to the defendant stroke respondent number 1 not only to argue on all issues, but also to produce all materials in support of its case that the suit is barred by limitation due to possession having been taken beyond the time when beyond the limitation period prior to the filing of the suit. Full stop. Next para. However, comma, since the same is a mixed question of fact and law and cannot be deciphered at the first glance of the plaint and the injunction, comma, the court cannot proceed on the basis of such allegations of the defendant at this stage. Full stop. Next para. In view of the above, comma, we are of the opinion that that since the learned trial judge already found that a prima facie case has been made out, comma, an ad interim injunction as sought by the plaintiff stroke appellant ought to have been granted. Full stop. Next para. Hence, comma, FMAT shopkota the dates of the impugned orders are same.
No. Another is impugned order are the same, but three matters within the period of 1 year.
Date of impugned orders are the same in all the matters. Date of impugned orders. আচ্ছা very good. তাহলে এইভাবে করো না। Accordingly, we dispose of the appeals in the following manner. কোলন দিয়ে নিচে ওই FMAT প্রত্যেকটা দিয়ে such and such is allowed on contest, comma, thereby setting aside the impugned order dated such and such passed by the judge.
Learned additional district judge, second court and first court.
The judges, the learned trial courts are also different.
Oh,
second court and
passed by Omuk in title suit number such and such. And granting ad interim injunction restraining the defendant stroke respondent from changing the nature and character of the property which is the subject matter of the deeds sought to be preempted. Full stop. এটা রোমান 1-2 করে এই পাঁচটা অ্যাপিলই দিতে হবে সিমিলার, একটু দেখে মেমোটা দেখে। Full stop. Next para. We however there are connected applications also. Can 2 of 2026 Now, the applications, bearing can 2 of 2026 filed in connection with all the appeals are also disposed of accordingly. Full stop. Next para. We make it abundantly clear that
can to 2025.
Acha, 2025 করে দাও 2025 we make it abundantly clear that this court has not conclusively decided any of the issues involved in the temporary injunction application or the suit, and it will be open to both parties to argue all points. First of the learned trial judge, while deciding the temporary injunction application as well as the suit, shall not be unnecessarily swayed in any manner by any of the observations made above, but independently decide the said application and suit on its own merits upon giving adequate opportunity of hearing and production of materials to both parties. Full stop. Next para. The respondent, the principal defendant stroke respondent number 1 shall file his or her his written objection to the injunction to the temporary injunction application pending in the trial court in each of the matters within a fortnight.
Lordship, 7 days.
Within a week from date. Full stop. We request the learned trial judge to dispose of all the injunction applications in the aforesaid suit as expeditiously thereafter as possible, positively within 3 weeks from the date of filing of the written objection by the principal defendant stroke respondent number 1. Full stop. No orders to cause urgency.
One thing, 3 deeds of sale are within the period of 1 year. Therefore, 3 plaints has been filed within the time
Make all your arguments when the matters.
Grateful.
Extremely grateful.
We have proceeded only on the basis of a claim. On the basis of
reply, affidavit and reply in 3. 4 to 6, 4 to 7 and 4 to 8.
Grateful. FMAT 197, which is not
we cannot, order cannot govern that. So you can mention that and get a copy of this, and we can pass a similar order in that.
Gratefully.
বলে দিচ্ছি তো এটা একটা রিপ্লাই নেই
One cases there is no reply.
হ্যাঁ তো বলে
We have kept it vague. In our order, we have kept it vague. Whatever reply filed, we have kept.
Grateful.
Yes, 47. Yes, Mr. Banerjee, you were there.
Lord Plaintiff, Lord, preferred an application. This is an application for direction upon the police authority to implement the order of injunction. Now, Lord, this is the affidavit of.
Can 1 is the injunction application?
Injunction application that has been disposed of.
Oh, disposed of. Can tell one
This is the disposal of the appeal, including your lordship was pleased to direct to bring the records, original records, and all necessary steps.
Mr. Banerjee, have you served a copy of Can 3 on
Yes,
the other side?
that is I am filing. All of them are served.
What is the endorsement? In
Lord, endorsement served. Out of them, my lord, respondent number 1 has already entered appearance.
1 is refused, so that is good service.
On the other day,
No.
1 and 6, my lord, appeared.
Entered appearance is different, but you have. What about service of Can 3?
Lord, practically, I have prayed for violation by dependent respondent number 1. As against the other respondents, Lord, I did not raise any objection to that because they are obeying the court's order.
Respondent 1, all the respondents were represented on the last occasion, 1 to 6.
The 1 and 6.
1 and 6, right?
1 and 6. 24,
so your allegation is against 1?
Allegation against 1. Lord, that is paragraph 10, my lord.
This is Can 3.
Can 3, my lord. Specifically, we mentioned it, my lord, in paragraph 10 of this application.
How are they disturbing, Mr. Banerjee,
Lord,
according to you?
they are disturbed. They raised, my lord, 50 feet. Already approximate length and height 5 feet. Lord, walls by violating the court's order. Your lordship's order was not to change the nature and character of the property. Now, Lord, they have already raised construction. Now they are making preparation further to raise construction on that property. Lord, that is why we have lodged a complaint before the police authority. Lord, in page if your lordship come to that page, because we have page 125. When we intimated the police, my lord, police refused to take the information. Then, my lord, we sent by registered post with AD, registered post, a speed post, and my lord, page 129, it was served on them, so that, my lord, they comply with the order. But, my lord, police did not take any steps, my lord, for the purpose of preventing them. But, my lord, due to some benevolent well-wisher, we could be able to resist, but we could not be able in long time. That is our case made out, my lord, not only in paragraph 10, paragraph 11 also. And we gave leave to file an application that is already made ready for the purpose of mandatory injunction for demolition of that construction.
Despite affidavit of service filed to be kept on record, despite service, none appears for the respondents at the time of call. Full stop. By an order, when did you pass that in?
Lord, your lordship passed an order, Lord,
Yes.
dated, Lord, 76, my lord, your lordship order. This is the first order. And then, my lord, your lordship extended from time to time.
No, the injunction application is also pending.
No, that thereafter it has been disposed of till disposal.
When?
That is, my lord, that order dated.
During pendency of the injunction application is the last order.
My lord, that has been allowed till the disposal of the appeal.
On which date? You can find that order?
দেখো না, দেখো না, অর্ডার গুলো তো দেবে, অর্ডার গুলো কোথায় গেল?
Can 2 allow করেছে, হ্যাঁ, হ্যাঁ, হ্যাঁ।
অর্ডার গুলো গেল?
Yes.
অর্ডার গুলো আছে।
So then why don't you seek implementation of the final last order also?
Last order also.
Should have sought implementation of that.
Yes, last order, because by doctrine of merger.
Yes, but you have not sought for implementation of that.
Yes, Lord, that may
Oh,
be.
no, that order was passed after you filed this application.
Lordship.
That's right.
Lordship, that is why.
Well, by an order dated December 1, 2025, which was extended further on January 5, 2026, and made absolute on February 4, 2026, this court had directed, this court had restrained the defendants to respondents from transferring, alienating, encumbering, alienating, and or creating any third-party interest in respect of the suit property, as well as from changing the nature and character thereof, and or making any construction on the suit property till disposal of the appeal, and had directed the parties to maintain status quo as regards their respective position in respect of the suit property during the pendency of the appeal. Full stop. Next para. The petitioner, the appellant stroke petitioner alleges in Can 3 of 2026 that in blatant violation of the said status quo order, the respondent number 1 has been making construction on the suit property in an unabashed manner. Full stop. Next para. Learned senior counsel appearing for the appellant places reliance on the annexures to the application to show that despite intimation to the police authorities, no steps are being taken by the concerned police station for implementation of the order of this court. What is the police station?
Lord, police station, my lord. Islampur police
Islampur
station.
police
Officer
station.
in charge of Islampur police station.
Yes. Who's up next para? But the cost of the police help, Mr. Banerjee, your client will have to bear the cost of the police help.
In the event of posting, posting is not necessary. They are to restrain them. In the event, my lord, posting is there, certainly we have to do that.
It is pointed out further that, have you annexed any photograph of the construction?
Yes, my lord, photographs I have.
It is also, where is the construction?
Photographs, my lord, page 116, 17, 18, 19, 18. 114 to, my lord, 18. 18.
The vacant property, where is the construction?
The vacant property,
Where is the construction?
my lord, that is after this construction, my lord, this line, my lord, or bottom line. Bottom line construction is made up to 50 feet.
কি বললাম ওখানে? That certain photographs have been annexed to the application to show that a part of the construction has already been made by way of a boundary wall. This is a boundary wall.
Lord, according to them, this is their boundary. According to us,
No, this is the wall.
property. Wall.
By construction of a wall. Full stop. Next para. Thus, comma, it appears from the materials on record that the respondent number 1 has been attempting that there is prima facie evidence to show that the respondent number 1 is attempting to violate the status quo order passed by this court by raising construction on the suit property. Full stop. Accordingly, can 3 of 2026 is allowed, comma, thereby directing the officer in charge of the Islampur police station to ensure that the order dated December 1, 2025, comma, as extended on January 5, 2026 and made absolute on February 4, 2026 by this court in connection with FA number 433 of 2025 is implemented by restraining the respondent number 1 and or his men and agents from raising any construction on the suit property and or changing the nature and character thereof in any manner whatsoever. Full stop. Next para. For such purpose, comma, the officer in charge of the Islampur police station shall act on a server copy of this order, comma, coupled with the written communication of the learned advocate on record for the appellant for the purpose of compliance, comma, without insisting upon prior production of any certified copy of the order. Full stop. Next para. In the event any police posting is required for such purpose, comma, the costs of the same shall be intimated by the officer in charge of the Islampur police station to the appellant and shall be borne by the appellant upon the necessary intimation being given in that regard. Full stop. No address to cost. Urgent certificate.
Lord, I'm debated.
Thank you. Affidavit of service যদি না বলে থাকে
Affidavit of service filed today is kept to
প্রথমে
the deputy record.
Thank you.
Need to appear on behalf of the respondent, Lordship. Mediation failed.
Yes,
mediation
failed.
Only quantum of alimony disputed. Lordship, kindly recollect the fact.
You could not agree to that.
Both parties sought for divorce. Lordship sent for mediation.
They agree to the quantum of alimony.
Yes,
there is a child.
20 lakhs they sought for.
But the only
20 lakh.
The learned district judge of Alipur granted 4 lakhs.
4 lakhs, without following the guidelines as framed by the NEHA.
What is your claim? 20 lakh.
But at least reasonable 4 lakh has been awarded, man.
What
permanent?
To what extent did you go?
Lordship, on the last occasion in the mediation center, it was 12.5, and they sought for 14, and we sought for 10 months time so that we can sell out the property and we can gather. That can be accommodated 8 months or 6 months. This is the problem. This is the problem.
12.5 they'll give you right now.
No, but
within 8 months.
Within 8
months. 8 months.
Lordship, I have to sell out the properties. And this is not very easy. And the span of the matrimonial life.
Can they not press the appeal on the assurance that you pay after 8 months?
Lordship, let it be kept alive. That can be if done, subject to correction, Lordship.
No, we'll kill it. We'll not keep it alive. What is the challenge? I mean, what is the ground of challenge? Divorce granted.
Divorce granted, counterclaims or divorce. So divorce granted. Quantum 4 lakhs. That has been challenged.
But the learned court did not consider the but the affidavit of assets and liabilities.
So therefore, the suit was decreed, your counterclaim was also decreed.
Dismissed. My counterclaim was dismissed.
So your allegations were not accepted,
Not
their
accepted.
allegations were accepted.
Your lordship.
But nothing has been recorded with regard to my
Take it.
but the counterclaim, my lord, nothing has been recorded. And my lord, the in the case of my lord, the Rajneesh versus Neha, my lord, the Honorable Supreme Court has laid down the law, my lord, the affidavit of assets and liabilities ought to have been considered by the learned judge, my lord.
But interim, now what application? Injunction?
But the from injunction from remarrying, my lord.
That has been refused by your lordship on the earlier occasion.
No,
I have praised lordship.
nothing has
kindly-
been recorded.
It has been recorded and lordship.
Why did you refuse?
Lordship said that.
Why did you refuse?
Lordship, it has been refused on that. The lordship kindly see your 18th November's order. That will speak. And lordship dictated the order, and the order subsequently it was. I
So
said
that
that my client is waiting for remarrying. Lordship laughed at that, and it was struck down. And actually, my client, upon my instruction thereafter, remarried on 21st.
Why are you being so surreptitious about it?
I've got the certificate. I can produce. Because if the appeal is pending, I cannot play hide and seek before your lordship. So that order was they are suppressing the facts.
What?
They know because they were present in that order was passed and your lordship struck down that order. That
We struck down the order, need not repeat that time and again.
The peculiar
If you have
case.
struck down the order, then that is not on record. So
lordship,
even we don't remember.
lordship, kindly see the fifth and
Let us
sixth
see the order. Let us give the time. You are continuously speaking. How can you look into the order? This recording was only for the purpose of sending to mediation since it has irritated broken law.
And kindly says the
You have remarried.
Lordship.
Have you gotten evidence of that?
Lordship.
When did you remarry?
Lordship, 21st February, subject to correction, give me the marriage certificate.
During the mediation period?
No, after that. Lordship, kindly see.
This is one of the situations that will be privileged to have two wives if you set aside the divorce decree. Only situation where a Hindu can marry twice.
Lordship, on the earlier occasion.
Not thrice, because
This Lordship, subject to correction, they sought.
this will not be bigamy because at that point of time you are not married. But if you set aside the divorce decree, then
we do
you
not want to leave.
your marriage will revive. So you live with two wives, no difficulty. You have taken the risk, you will suffer.
Lordship, if the wife is ready and willing, she does not. Ask them. And that is the cause. There is a quantum of money. Kindly see your 18th November order, Lordship, kindly.
18th November order is not any conclusive finding.
Lordship.
That was only for the purpose of prima facie finding that it is a fit case for mediation.
Lordship.
So you cannot rely on any finding there. We prima facie found that it has irretrievably broken down because both parties are seeking marriage only on that divorce on that premise only.
Lordship.
But the allegations are different. If we sustain the impugned order, then your allegations against her remain. She made allegations against you and sought divorce. You had made allegations against her and sought divorce.
Lordship.
Hers were not sustained, yours were sustained.
Lordship.
So therefore, you have to look into whether your allegations were established by you. If your allegations were not established by you, but her allegations were established, then we may sustain divorce, but we'll change the grounds that it was your fault for which divorce is granted. We may do that in the appeal also.
That can be done. Lordship.
Are we clear to you?
Yeah,
So
yes,
that may also, the paradigm may shift.
Paradigm is.
There may be a divorce all the same,
Lordship.
but it will be allegations against you. Maybe. Theoretically, it may be.
Lordship.
And the permanent alimony also you have to consider then. Why Rajneesh versus Neha?
Lordship, we have
In permanent alimony, you can also look into your assets,
with the hardship,
including that house of yours.
Increase, Lordship, to 12.5, Lordship. My client is not present, but I have taken instruction, Lordship, from 4 to.
But not at a time, my lord.
8 months after, what will you give her now?
That may be checked. I can seek.
What was your current offer? Immediately, what would you pay to her?
8 months for 12.5.
Immediately, what would you pay to her? She'll wait for 8 months for you to pay.
I can talk 3 to 4 lakhs.
Go on, talk.
Within 1 month. 3 to 4 lakhs and remain by 2 and 2 lakhs.
Yes, you disclose this by your affidavit.
Lordship.
both learned counsel for the both parties apprise us that the attempts at mediation failed, primarily due to lack of consensus ad idem between the parties regarding the quantum and time, the quantum of permanent alimony payable and the time within which the same has to be paid. Full stop. Next para. Accordingly, we take up Can 1 of 2025 for hearing. Full stop. Next para. At this juncture, tar age, the present appeal arises out of a suit filed by the respondent husband for divorce against the wife. Full stop. In the self-same suit, the wife also filed a counterclaim for divorce, which was dismissed and the husband's suit allowed. Full stop. Your claim for permanent alimony was totally refused.
It's my lord, only I have claimed 20 lakhs, only 4 lakhs has been granted, my lord.
The claim of 20 lakhs, the claim of the wife of 20 lakhs as permanent alimony was partially granted to the tune of rupees 4 lakh by the learned trial judge. Full stop. Next para. At this juncture, learned counsel for the respondent husband submits that the respondent husband has remarried in the meantime. Full stop. Next para. Accordingly, there is no scope for grant of any interim injunction at this stage, restraining the husband from remarrying. Full stop. However, in order to bring on record the relevant circumstances and the proof of such remarriage, the respondent shall file an affidavit in opposition to Can 1 of 2025. We have the document, so within a week from date. Full stop. Reply, if any, shall be filed within a week thereafter. The application shall be listed next for hearing on April 7, 2026. April 7, 2026. Pass orders on that date. If those marriage certificate is brought, that marriage certificate is brought on record, we'll just expedite the hearing of the appeal.
May I mention Can 2 and 3? I have not yet been served.
Serve all the applications. Whatever application is pending, please serve. Please check up for the if not served, then serve. Deep level. Thank you.
Item number 49.
Yes, Lord, this is my.
Yes, Mr. Senator. Appeal arises out of what?
Arising from the eviction decree, my lord.
Eviction under 97 Act.
Under, my lord, yes, under 97 Act.
I'm appearing for the respondent number 1.
So now it's for occupation charges.
Now is for occupational charges, my lord.
Affidavit in opposition.
Affidavit of opposition. At the outset, my lord, I submit that there is some sort of typographical error.
In the opposition?
No, in the order, my lord, last order, paragraph 7. It says that, my lord, the question of imposition of occupation charges as condition for grant of stay is kept open for being decided at the final hearing of the appeal.
Should be appealed. We will correct that right now. Right. At the outset, it is rightly pointed out by learned counsel for the respondents that in paragraph number 7 of the order dated February 3, 2026, it was erroneously recorded that the question of imposition of occupation charges as a condition for grant of stay was kept open for being decided at the final hearing of the double inverted appeal, double inverted clause, instead of double inverted application. Full stop. The obvious tenor of the rest of the order indicates that the question is to be decided at the time of hearing of the application and not the appeal. Full stop. Hence, the order dated February 3, 2026 is deemed to stand corrected accordingly by reading the expression double inverted appeal in paragraph number 7 thereof as application. Full stop. Next para, affidavits of service, opposition and reply filed today be kept on record. Yes, Mr. Sinara, you're.
Yes, my lord, from their affidavit.
Could we hear them first because they have pleaded on this?
Yes.
Because you are arguing this occupation charges. Yes. Let us hear you, then we'll hear his reply.
The question, my lord, that short question arises the occupation charges. Now that the location is very relevant here.
Let us see that.
In paragraph 5, I have stated, my lord,
yes,
that it is Beniatola Lane. That is, my lord, 5 minutes walking distance from College Street prime location. From Boipara, my lord. Other, my lord, Medical College, Sondonia Kalibari Presidency University,
yes,
Rabindranath, that everything is 5 minutes distance. There are 2 rooms, my lord. These rooms are in high demand right now.
College Street is not such a posh area, but it's in a central Calcutta, undoubtedly.
It is, my lord, high demand is there.
Prime area, undoubtedly, yes.
But heart of College Street.
Police station Amherst Street.
Yes, my lord.
Yes, that's true. What is the extent of the property?
My lord, paragraph 6.
450.
400, that is my saying, but they have said some another. They are saying 334 square feet. That is their word against mine. That I cannot.
So very well, let us take an average of the two. I mean,
Yes, but what my lord, my preliminary
Mr.
objection.
Sinara, take your
Yes,
seat.
my lord,
Take your seat. Take your seat.
Yes.
Take your seat. Mr. Sinara's junior, please remove the microphone from his mouth. Remove this side. You also remain seated till we ask you to. You also remain seated. Yes, please complete.
My lord, but the preliminary objection that I'm raising, my lord, that in their reply they have stated that the rate for rent is, my lord, 10 rupees per square feet. That is, my lord, absolutely not 10.
What was the original previous rate? I mean,
previous 227 only.
This on the-
That is also I have not received. I have
this on the ground of reasonable requirement. What on what
no,
ground?
no, trespasser. That the applicant is purely trespasser. There are no rent receipt in his name.
Not under 97 Act.
No.
Not
No,
under
not
27.
specifically defect. That is, my lord, just trespasser simply.
How are they using that property?
Residential.
According to you, what should be the rent?
That I have stated, my lord, at least 20 to 30,000. Because that kindly sees, my lord, page 9 of my opposition. I have annexed the query of that property. That is, my lord, coming 33,58,000.
That is the
That is the
sale
value of
price.
that is. But my lord,
That is for sale.
that yes, my lord. But still, my lord. And
No, have you produced any any other rent receipt of the
I have kindly sees page 11.
page 11? Yes.
That is, my lord, that internet from information that I have gathered in.
Not reliable. AI may say anything. It's written AI overview.
Yes.
AI has its own presence with its imagination. So
From the time, my lord, the respondent number 1 plaintiff, my lord, bought the suit property, not a single paisa has been given as rent.
no,
That is
now
the-
we can only by way of condition for stay, we can only direct him to pay from the date of the impunity.
My lord,
You know that.
Yes.
So you have asked for
My prayer is
20
for
to
20 to 30.
20 to 30.
And there, if I see
let us
that
see.
from 10 rupees per square feet, that is 330. Even if I have taken their argument, my lord,
10 rupees
that
is
is
3,000.
3,000. My lord, very less.
Let us hear
Very
that.
much.
Yes, please take it. What is your full name, please?
Orho Mollik.
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 Mr. Mollik, please take your seat. Yes, Mr. Senat. Have your heart's content.
Yes. No, my lord. There is
10,
a very,
10 rupees per square feet.
that was my instruction. That
What is the
my-
English of Changrami?
No, that is the
10
instruction.
rupees per square feet.
No, that is the instruction, my lord. I have received from the.
Instruction. Have you ever been to College Street or you
No, I
roam
have-
about in other areas?
I have not.
Not been to College Street ever?
I have gone various time for purchasing books and all, my lord.
So, Mr. Sinara, 10 rupees per square feet, forget that. 3,000, they say 20,000. What is the average of the two?
My lord, first of all, my lord, this,
At least say 15,000.
my lord, this is a 150 years old building,
All right.
and in their query, it was said that it is a 60 years old building, but it is.
We are not going by their query, Mr. Shinara. We are being very candid because that is
And the building is in dilapidated condition.
for the purchase price. I mean, we are not going by that.
Building is in dilapidated condition, my lord.
You repair it, you are staying there.
If it is so, my lord, if your lordship's direct.
You repair it so that the market value will increase. If you keep it in a state of disrepair, you cannot take advantage of that. You could have filed an application before. No, you are not a tenant, so you cannot ask for that also.
No.
You have been held to be a trespasser. Right now, you are not a tenant.
Yes. Right now.
Might have claimed that, but till if you win the appeal and unless you win the appeal, you are a trespasser. So therefore, I mean, you can repair your own house. Dilapidated, it's still standing. Otherwise, you leave it. You leave it, they'll break it and make it something else.
No, no.
But
I beg your lordship's pardon.
It's so dilapidated, don't live there. But Mr. Shinara, 15,000 is
My lord,
quite.
kindly make it 10,000, my lord. 10,000.
Acha, make it 14.9. No,
Humble prayer is 10,000, my lord, because he's a 62 years old, my lord.
who is 62 years?
The appellant.
Don't say 62 before judges. It's a bad analogy.
No, no.
We remember something else then. Yes, 62. কত দেবেন আপনি ঠিক করে 10 থেকে 15 মাঝে মাঝে কিছু অ্যাটলিস্ট 15 You never paid anything, so you don't know actually.
No, I have paid, my lord. I have
What
paid
rate?
in a rent control.
Rent
my lord.
control.
Rent control, trespass.
Rent
Very.
control.
How much? 10 rupees.
225 per month through the rent control, my lord.
No commission was ever held. My lord, 150 years old, that is, my lord, cannot be.
You know, that is apparent from the decree.
400 into যদি ধরি আমি 30 যদি হয় তাহলে 12 হয়ে যাবে 12 হবে দিন 12,000.
My lord, LBS report, it appears from the LBS report, my lord, this is far
It's
off
a part of your reply.
Yes.
LBS report says what?
My lord, this is far off from
34, they
the
are saying 330.
Far off from?
far off from the Ama Street, my lord.
Far off means exactly how far off?
My lord, this is, my lord, Annexure X.
ছবি দিয়েছে
Ama Street, then there is it's a by lane and below the just blind lane.
No,
Not-
no, you
Not
know,
from the
just my lord, 5 minutes from the proper area. My
No, 5 minutes maybe, but if it's in a blind lane and
This is my lord, the
3 years old,
no, that cannot be taken, my lord, because no commission was ever held. That did not come into evidence. 150
is
years.
apparent
I
from
can
the
say
decree.
250 years old, my lord.
It is
That does not make it
apparent-
250
It
years.
is apparent from the decree. From the plain case, in fact.
12,000 30 টাকা করে পার স্কয়ার ফিট হচ্ছে তাই তো 30 করে 400 যদি ধরি আমরা দুজনের মধ্যে ঠিক আছে we are fixing 12,000. Third, learned counsel for the parties. Full stop, next para. Learned counsel for the respondent, plaintiff stroke respondent alleges that the defendant stroke appellant has been declared to be a trespasser and eviction has been granted by the learned trial judge. Full stop, it is argued that the suit property is comprised of about 415 square feet carpet area within bracket 522.9 square feet super built up area and 435.75 square feet covered area containing 2 rooms, common bath and privy on the first floor at premises number 36/4/1, Beniatola Lane, Tola Lane, Police Station Amherst Street, Kolkata 7,09,000, and that the market value of the suit property would be around rupees 33,68,647. Full stop, it is submitted that the rent, that the market rent for the property in the locality at the going rates would be somewhere between rupees 20,000 to 30,000 per month for 2 BHK apartments, as would appear from the query dated February 24, 2026, issued by the government of West Bengal and a website relied on by the respondent. Full stop, next para. However, the market rate for the market value of the property might have been relevant for the purpose of sale of the property, but not for ascertaining the rent which could be fetched from the same. Full stop, also, we find from the annexure regarding the website output, it is seen that the same is an outcome of a search by dint of artificial intelligence bracket AI. So as such, we are unable to place much reliance on the same per se. Full stop. Next para. Per se, in the absence of anything else. Full stop. Be that as it may, from the location map annexed to the affidavit in reply of the appellant, as well as the averments made in the affidavit in opposition of the respondent, we find that the location of the suit property is not very far off from the main thoroughfare of the College Street area, which is pat in the center of the metropolitan city of Kolkata. Full stop, next para. The proximity of the said location from several important landmarks such as the Medical College and Hospital and several universities and colleges of repute, also enhance the valuation of the same. For some next para, on the other hand, comma, the appellant alleges that the building housing the said property is 150 years old, which is disputed by learned counsel for the respondent. Full stop, be that as it may, comma, there cannot be any doubt that the building is not new. Full stop. Moreover, comma, although near to the primary thoroughfare of College Street, comma, the suit property is situated somewhat in the interior of an alley, ALLEY. 8 feet wide. Comma, however, comma, having an 8 feet wide road on one side. Full stop. Taking even taking an average of the allegations of the parties, comma, the suit premises should be comprised of around 350-400 square feet. Full stop. Next para. Thus, comma, on a rough guesstimate, single the guesstimate, comma, since both parties have come up with different versions of the market rent, comma, we are of the opinion that an amount of rupees 12,000 per month would be a fair occupation charge for as a condition for extension of the order of stay granted earlier. Full stop. Accordingly, comma, can 1 of 2025 is disposed of by granting stay of all further proceedings in title execution case number 98 of 98 of 2025 pending before the 10th bench City Civil Court at Calcutta till disposal of FA 460 of 2025, subject to the appellant going on paying occupation charges at the rate of rupees 12,000 per month to the respondents at the by way of online payments at the bank account, particulars of which shall be furnished in writing by the learned advocate in record for the respondents to his counterpart appearing for the appellant by the end of this week. Full stop. Next para. The first of such installments, first of the current installments of occupation charges, comma, for the month of April 2026, comma, shall be paid by April 15, 2026 and thereafter by the 15th day of each succeeding current month. Full stop. The arrears of occupation charges at the above rate, comma, from the month of the decree impugned in the appeal till March 2026, comma, shall be paid by 4 equal monthly installments, comma, the first of which shall be paid by April 15, 2026 and the next 3 installments by the 15th day of each succeeding month. Full stop. Next para. It is made clear that in the event of default of any of the above payments, comma, the order of stay shall stand automatically vacated without further reference to the court. Full stop. Next para. No orders to cost. Will you prepare the paperbooks or they will prepare? Very good. The trial court record shall be brought by special messenger at the cost of the appellant, comma, to be deposited within a week from date, within a fortnight from date. Full stop. Next para. In view of the appearance of the pure for all the respondents.
Only one. Respondent number 1 print.
In view of the appearance of the plaintiff stroke respondent number 1 through his learned advocate, comma, service of notice on the said respondent is dispensed with. What about pro forma respondents? Who are they?
Brothers. Brother and
They're co-owners. Who are they?
co-owners.
Yes, they are the brothers and co-owners.
But they have not filed the suit.
No.
No,
My client has filed.
In view of the pro forma respondents having not filed the suit in the trial court, comma, nor having preferred any appeal, comma, service of notice of the appeal on the said pro forma respondents 2 and 3 is dispensed with. Full stop. The appeal be treated to be ready as regards service. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the Appellant puts up liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you.
Item number 50.
Yes, Mr. Mukherjee.
But on the last occasion, your lordship, my lord, we just got this limited time. Your lordship directed us to file an affidavit as a summary of this. My lord, where your lordship will find.
What is the matter arising out of Mr. Mukherjee? Please be
The
reminded.
matter is arising, my lord. We have preferred an appeal. And
you are for the other side.
And all corporation and all these are parties, they obtain a degree in the court below. That
What was the suit for? What sort of degree did they?
Suit for that, so that we cannot make any construction. We can within 4 feet, 4 feet, the partition wall, as enumerated in the deed so far, and that was agreed. We also subsequently we made an application before your lordship, paper an appeal, and made
there is a partition between you two originally.
Originally declared suit. Yes, there was a partition.
Previously, there was a partition between you.
Yes, yes, that is the my lord.
The allegation is you are building a wall within 4 feet or construction within
yes,
4 feet.
we never disputed on this, but we might not file an application before your lordship that.
No, what was the decree passed?
Degree passed that I shall not make any
Only permanent injunction decree, no declaration.
But declaration, and but that I shall, and I also agreed that within 4 feet we shall not make any construction.
Then why did you prefer the appeal?
Yes, we preferred an appeal, my lord, for the intervention of your lordships, that since the partition wall is, my lord, this is what the building is very dilapidated, nobody is staying at our side.
But the mic is hearing your sleeve more than your voice.
All right. Now, now, my lord, we filed an application, can one before your lordship. And this in this application, we wanted, my lord, that let an engineer be appointed at our cost, so that the demolition and all these things can be done. We have
by leaving aside that.
Yes, because otherwise this is
in terms of the decree.
Yes, in terms so that, my lord, no, our right and their right cannot be affected by any means. Your lordship
that can dispose of the main appeal as well as the application.
No, not that, my lord. Your lordship, my lord, gave time, appointed from the list of the High Court list of the engineer.
Mr. Mukherjee, we are asking you, what is the ground of your appeal then? If you agree to that, the decree.
No, my lord, ground of appeal, my lord, kindly, if your lordship kindly turn to your lordship's order. I think it will.
Forget our order. Why have you preferred this appeal? If you said at the inception that you agree to that decree.
We agree. We had no objection to, my lord, make any construction within the plinth of the 4th.
That is the scope of the suit.
That's,
decree.
yes, yes.
So then what is the ground of appeal? What
actually, but the construction of the building and the partition wall is in such a manner, because the partition was done.
Please remove the microphone.
Oh, my lord.
Grasping. Yeah.
I'm sorry. The partition by my predecessors was done in such a way that the major portion of the construction adhered to the, my lord, partition wall.
If you say the trial court's judgment was correct, then you should make an application before the trial court for whatever.
No, my lord, we had made it and your lordship accepted. I'm just for this, my lord, we are coming, because your lordship already passed an order by appointing a, my lord, engineer from the court panel list, and we also paid for that. Your lordship also gave a time bound so that this can be cleared out, so that it will not affect to, my lord, giving violation of any of the parties as regards to the degree or the terms of the partition. But the, my lord, out of 4 or 5 visits, and the, my lord, he submitted report. Both photographs was taken by both the parties. We already made investment by repairing all the partition wall and all these things. By clearing the jungles, we took photographs in their presence, and he submitted a report what should be done by us. We also provided, my lord, masons and materials to raise structure. We have given photographs, colored photograph for your understanding, and to prepare this boundary wall, the partition wall, so that it may not break down, because it is a very old building. But and
partition that engineer, he took money from you,
my lord.
Engineer took money from you.
Yes, yes, that is, my lord, by the sanction, by your lordship, by sanction, my lord, and so that, my lord,
we sanctioned some amount.
Sanction
his fees.
My lord, kindly, your lordship.
By which order? Which order?
My lord, that is why I am placing.
July 2nd, 2025.
Page 112 of it is
This was
Can 1 of
appointment or the
2025. The inspection report.
No, we did not fix remuneration. We said the appellant shall pay the charges in terms of bills raised by structural engineer.
Yes, naturally.
So raised bills you paid him also.
We have all annexed to this, my lord.
So, but he did not do the work, or he went there and did
No,
some.
my lord, I am reading it. Such construction, demolition, they had no objection to that. They did not, even the report, they did not raise any.
Then why are you before us? I mean,
that is why, my lord, such construction, demolition work shall be made strictly in accordance with the bullet points enumerated in the inspection report. Your lordship had the occasion to, my lord, inspect the authored by Mr. Devasi Sengupta, civil engineering consultant. My lord,
where are you reading from?
My lord, page 113, next page.
Can application 2.
112 to Annex D. I am reading, my lord, in whole so that it can be, but page 112. Learned counsel for the respondent number 1, the opposite party, submits that in principle the respondent number 1 does not have any objection to the demolition work being sought for to be carried by the appellant, subject, however, to the appellant strictly adhering to the suggestion given in the inspection report.
For the engineer gave a report.
Yes,
there were
yes.
bullet points in that.
Yes,
he did
yes.
work up to a stage.
Yes.
So now you have to then
No, my lord, suddenly he took up.
Then you have to engage someone else.
Someone else. Now the problem is, my lord, he has already formed an opinion. On the basis of opinion, some of the structure.
Maybe if he does not want to continue, then we cannot compel.
But your lordship, my lord, gave it that at least eight visit will suffice for the amount which has been, my lord, given to them. He visited at least only 4. Neither returned the money.
Should we give a notice to him, ask him to explain?
Kindly, I am reading it because they did not raise any objection. By that is.
So what is your prayer now, Mr. Mukherjee?
Prayer now, my lord,
want us to want him to return his money?
No. I want to get it done by him.
He's not unwilling. We cannot compel someone to have the work done.
He's
not subject to a jurisdiction otherwise. He's a panel.
He just says, for my health.
Yes, if it doesn't work, we cannot compel him. How can we compel him? Under which law can we compel him?
There may be difficulty.
We may appoint someone else. We cannot compel someone to do the work.
Difficulty in one way. First of all, he has formed an opinion that has a submitted report.
Mr. Mukherjee, we cannot compel any engineer to do the work for you.
I am not saying, my lord.
If you don't say that, then what are you saying? Suggest an alternative. Either we appoint someone else, or we want, or we can direct him to pay back the money, or ask for a report from him.
Both. Because money he has, my lord.
An allegation is made by learned counsel for the appellant. Yes. An allegation is made by learned counsel for the appellants to the effect that although an impaneled civil engineer, namely Mr. Devashish Sengupta, was appointed in terms of the orders of this court, by placing specific reliance on the order dated July 2, 2025, where it was indicated that payment shall be made to the said engineer as per bills raised by him, and if the visits exceed 8, it will be open to the structural engineer to raise further bills, the said engineer, after receiving the amount in terms of the bill raised by him, did not complete 8 supervisory visits, but midway, gave out that due to his health conditions, he would not be able to continue with the work. Full stop. Next para. In view of such allegation, this court is of the opinion that a report is required to be sought from the said structural engineer disclosing the heads under which he took the amount of money from the appellants and as to how far he has justified such payments.
And it
Full
is
stop.
expected that the entire work shall be concluded within 4 months from date.
Next para, we also take note of the fact that since a timeline was given by us regarding the completion of the work, the said engineer is required to explain as to what prevented him from continuing with the work, particularly since the work had progressed quite a bit under his aegis. Full stop. Next para. Accordingly, Mr. Devashish Sengupta, the said empanel engineer is directed to furnish a report explaining his withdrawal from the matter and also clearly enumerating as to under what heads he took the amount in question from the appellants and how much of such work has actually been done by him. Full stop. Next para. Such reports shall be filed by way of an affidavit by Mr. Sengupta, the said engineer. Full stop. The said civil engineer shall act on the basis of the written communication of the learned advocate for the appellants, coupled with a server copy of this order for the purpose of compliance, without insisting upon prior production of a certified copy. Full stop. Next para. Such report shall be furnished within 4 weeks from the date of within 3 weeks from the date of communication of this order to him. Full stop. Next para. Let the matter be listed next in the monthly list of May 2026 under the same heading. Full stop. Next para. The appellant shall communicate the gist of this order along with a server copy of the order and a forwarding letter to Mr. Devashish Sengupta, the said civil engineer, at the earliest. And file a receipt in that regard on the returnable date. Affidavit in opposition filed by the respondent be kept on record. Yes. As well as affidavit in opposition filed by the respondent as well as a supplementary affidavit filed by the appellant be kept on record.
My lord, may I take one indulgence?
Yes, Mr. Mukherjee.
Because your lordship has gone through the entire, can it be made part?
No.
This is
So the application is not informed till now. The
Why?
names are, the spellings are, there are mistakes. The parties which are to be incorporated, they have not been incorporated in spite of the leave granted by my lordship.
Well,
we point out at the time of filing, otherwise we'll dismiss it if it is not done.
Well,
We gave a leave.
Yes, lordship.
Please check up.
That has been done, everything. And in the
give a corrected copy to them.
He is well disputing in the
Give a corrected copy to them.
But
Otherwise,
he can't be leave to correct this copy. Because in the application copy,
you serve them a corrected copy.
Right.
Yes, next.
And my lord, in this application there was a mistake.
Yes, next.
I give you a correct copy. Yeah.
Now respondent. Lord, I appear for the respondents 1, 2, 3. Lord, it was adjourned on the last occasion. Mr. Banerjee to take instructions whether he would proceed with the appeal or not. Lord.
What did you say to him?
That appeal, Lord, that where the possession was taken through Kolkata Corporation and he took an injunction. Lord, let him place his case. Whether if they want to proceed with, let them proceed. Lord, please. The guy should not. Lord,
I'm fairly intimidated.
I am too weak to intimidate anybody, Lord, and too incompetent. So let him place it, Lord.
My lords, were kind enough to hear us.
Battle between beard and non-beard. Yes.
This was substantially hard, but
Yes, yes.
long time has passed.
So many matters have been substantially hard.
So, may I just recapitulate, very
Please,
briefly,
please,
very
please do that.
briefly. I purchased the property. My lord did not look at the records as of now. I purchased the property in surface auction. When the property was sold, the possession could not be handed over by bank because the property was sealed by Kolkata Municipal Corporation. Let's come back to my lord.
So what is the you are coming up against what? Injunction?
Yes. I want a better order. I wanted.
Oh, yes, yes.
Which my learned friend was trying to really indicate. Now, so far as my learned friend is concerned, the defaulting borrower, once the property has been put on sale, following Bafra mottos and so many decisions, he has no voice today. No voice today. Affidavits in opposition, have come. Interestingly, in the affidavits in opposition, it has been indicated that the property was allegedly sublet to a third party. They never say that with the consent of the bank. When the property was mortgaged, at the time of sanction and disbursement of the loan, Kotak Mahindra Bank was in possession of the property as a tenant. So a tripartite agreement was executed between bank, borrower, and the tenant, saying that the tenant would pay. And it was also stipulated in the agreement that everything would be done as the bank would approve with regard to the tenancy. Then when Kotak handed over possession, if at all Kotak has surrendered the tenancy or not, nothing was informed to the bank because to that effect there is no averment, no document, nothing. Now a third party is being projected saying that he has been let or sublet the property. This alleged sublessee has instituted a suit allegedly against the previous owner who had defaulted in making payment of rent loan and obtained an interim order from the learned city civil court without making me a party.
Mr. Chakravarti is for the borrower. He was the original owner.
Yes.
So the suit was filed by the subtenant, alleged subtenant against him.
Yes, by my learned friend's client.
You are the subtenant.
Subsequent alleged subsequent lessee. But post mortgage, so again those line of decisions of the Honorable Supreme Court that this has got nothing to do with the bank. Now nobody was in possession of the property. It was taken possession of by putting a seal by the Kolkata Municipal Corporation because property tax was due.
Corporation is also a party here.
No, corporation is not a party. So I just paid the KMC dues because they had the first statutory charge over the property going by the Kolkata Municipal Corporation Act itself.
Yes.
My learned friends have filed opposition. From the opposition, it surfaces that something had happened beyond the knowledge of the bank, which could have not bound the bank under any circumstances. Now, a surface application has also been taken out, which is not there in the record today, which we come to learn very recently, where the borrower has said that he is not in possession. Nobody is in possession of the property on his behalf or for him. On the last occasion, an argument was advanced that since the lessee, alleged subsequent lessee, is allegedly in possession of the property, so that is the possession of the borrower, the landlord. So today, by reason of the statements made before DRT on oath, it is clear that that was an incorrect statement made before this honorable court. My learned friend, Mr. Chakravarti, Mr. Chakravarti's argument on the last occasion was that I was not given lawful possession of the property by KMC. KMC could not have done this. This is firstly neither here nor there.
So you never got possession from the borrower, or either the bank or you did not get possession from the.
I got possession from.
That is their case.
Yes, that is their
from
case.
KMC, who is a third party.
Correct. So, the possession is not proper.
And they also took a point, it was as is where is basis in your deed.
Yes.
That was a point taken by them.
Yes. Milord, as is where is means, Milord, the property was then, Milord, sealed by corporation. Milord, it was me, Milord, who paid the dues, lakhs of rupees. Milord, I paid. The property was then, Milord, released from attachment, and Milord were made over to the owner of the property. By the time, Milord, the property was released from attachment, I had become the owner because of, Milord, registration of the sale certificate and sale deed in my favor.
There was a distraint order, and under that it was.
Milord, the distraint order with regard to, Milord, I can show, Milord, the provisions of the Kolkata Municipal Corporation Act. Milord, it has, Milord, two separate, Milord, procedures, Milord, prescribed under that particular act. One, Milord, with regard to the movable assets.
Yes.
Yes, Milord, this distraint order is with regard to movable assets. Milord, if there is no movable asset to be found, Milord, which can take care of the property tax which has fallen due, then, Milord, the immovable property will be caught hold of, Milord, by the corporation. What the corporation has exactly done. My learned friend was trying to impress upon your lordships that, Milord, distraint order could not have entitled Calcutta Municipal Corporation to seal the property or to deseal it and give it to me. Milord, those are neither here nor there.
Suppose they could seal it, but whether they could give it to someone else than from whom they took.
Yes. Milord, corporation is to give it to the owner.
Corporation won't adjudicate title.
Absolutely.
So corporation passes a distraint order against somebody and takes over the possession.
I tell you, Lordship, Milord,
Can
why,
it give
Milord,
it to someone else?
it was not given to someone else. It was given to the property owner recorded. Because, Milord,
was that?
It's me. I tell you, Lordship, why? Milord, the property after sale.
Distraint order was passed against whom?
Distraint
The
order.
previous owner.
Correct. But after that, Milord, the property was sold in, Milord, surface auction. Title deed was registered. I applied for mutation. Mutation was not allowed because, Milord, property tax was lying due. The moment, Milord, the property tax was, Milord, paid, Milord, there is no, Milord, embargo, no impediment
You
for the.
say you have a valid title in the property, but Mr. Banerjee, can the corporation do it in principle? Because why we are saying this, then it will be on the corporation to decide who is the current owner.
Milord, before
in
this
your
was-
case, you have a better case. You have a courts at the surface is sale and all.
And property was
But
mutated
then
in my name.
that will mean that KMC may pass a distraint order against me, take away seal the property, my property, but give it back to my learned brothers because they are satisfied that he has good title in the meantime.
After the property, Milord, has been mutated, Milord, in favor of, Milord, Milord, alleged third party. Milord, when the property was given up, Milord, given over, Milord, possession of to me.
No, you say the KMC Act permits them to do that.
Absolutely.
Shows that provision. KMC
Milord,
Act
it's not, Milord, there in so many words. The tenor of the, Milord, statute, Milord, says so.
See the tenor
But,
of
Milord,
the-
yes. But, Milord, before that, Milord, now, Milord, the Honorable Apex Court in the interregnum has come, Milord, to our, Milord, aid. Milord, a similar matter, Milord.
Apex Court knew about your case.
Milord, it seems so. Milord, it seems so. A similar matter, Milord, traveled up to the Honorable Apex Court in February 20. Yes, Milord, God is graceful.
not up to that extent. Destiny a bit below that.
Kindly, Milord, have a look at this judgment.
These are this 214, 220, 220 on this regime, these sections.
No, Milord, here there was a money decree.
No, in your case,
yes,
distraint provisions are 214, 220.
The distraint order was, yes, where the sections would be 219, 220,
that range, very
232,
well.
Milord, those sections.
What happened here?
Yes.
Let us-
Here, Milord, before Milord looks into the Milord reported decision, there was a money decree passed.
No, we won't look into the reported decision right now. We'll look at something
very,
else. Yeah.
very. Milord is looking at the reported decision. No?
A part of it, yes.
What? Milord, in the reported decision, a money decree was passed. Milord, execution proceedings started. Milord, property was sold. Then, Milord, the judgment data came and said, Milord, the possession was not properly, Milord, handed over to, Milord, the purchaser, auction purchaser, Milord, who purchased the property in execution. Milord, the Honorable Supreme Court has said, Milord, after the property is sold in auction, you are nobody to say that whether the property was lawfully handed over or not. You cannot raise this point. Can you, Milord, have a look at, Milord, paragraphs 4 first, paragraph 4. Can you take paragraph 3, Milord? Two suits seeking permanent prohibitory injunction in respect of same property were instituted. Original suit was instituted by such and such against such and such, whereas original suit number such and such was instituted by the first respondent against the present appellant.
Mr. Banerjee, should you release the other matters? We have 40 minutes about what.
But Milord, I think I should Milord also show your lordship Milord the DRT avaments. The
Then
avaments.
we won't release the other matter.
Kindly do
Should
not.
we release the other matter?
DRT kagozta এনেছিস তো? Kindly release, sir. Kindly release.
Other matters are released. Everyone treat Mr. Banerjee to a cup of coffee. Yes. Yes, Mr. Banerjee.
Paragraph 4, there is no dispute that the suit schedule property was owned by Ganapati. Ganapati suffered a money decree in execution of which the suit property was sold through court-conducted auction on 3rd May 1991 to Ramashami. Ramashami, white sale deed dated such and such, sold it to the present appellant. On the other hand, the first respondent who instituted original suit number 371 claimed that though original owner of the suit property was Ganapati, he died in an accident. Prior to his death, he had executed registered will. As a result, first respondent is the owner of the suit property. Interestingly, both sides claim that they are in possession of the suit property. Like Milord, in our case, they had been claiming that, but Milord, now they have taken Milord an alternative stand. The other side is causing unlawful interference in their possession. Trial court decreed the suit. Agreed by the decree passed by the trial court, 2 appeals were preferred. My lord, kindly skip over Milord 2-3 paragraphs. Kindly then come to Milord paragraph 10. Thereafter, the High Court proceeded to hold that though title to the suit property vested in the appellant, consequent to sale deed executed by the auction purchaser being in his favor, there is no documentary evidence on record to indicate that the possession of the suit property was lawfully taken by the predecessor in interest of the appellant. Like Milord, in our case. Based on above, the High Court partly allowed the appeals and dismissed both suits by observing that the plaintiff had failed to prove his lawful possession on the date of institution of the suit. Agreed by the decision of High Court, appeals have been preferred. Milord, may skip over Milord the arguments advanced. Kindly Milord take paragraph 17. 13 14 Milord, my learned junior Milord wants Milord to show paragraphs 13, 14, 15 also. Paragraph 13, Milord, coming back to paragraph 13. Additionally, it was argued that to obtain relief of injunction, the plaintiff must prove his title and possession on the date of institution of the suit. Once title is with the plaintiff and he establishes his possession over the suit property, Milord, pausing here for a moment. In our case, Milord, we have established our possession by Milord electricity bill and other documents, which are on record. On the date of the institution, he establishes his possession over the suit property on the date of the institution of the suit. He cannot be denied injunction, particularly against a person with no title merely because such possession was obtained by private negotiation or other means. It is contended that the appellant had brought evidence on record to indicate that though initially there was resistance in handing over possession of the suit property, a decision was taken in a panchayat to hand over possession to the appellant, and based on it, possession was taken over. And the documentary evidence indicated that the possession of the suit property was with the appellant on the date of institution of the suit. It has also been submitted that the second appellate court's jurisdiction under section 100 is limited and findings of fact can be interfered with only where there is a finding. These are not required for our case. Then paragraph 14. Based on the above submissions, it has been prayed that the order passed by High Court be set aside and decree passed by the first appellate court is restored. Then kindly turn to paragraph 17. We have, may I, Milord? We have accorded due consideration to the rival submissions and have carefully perused the materials available on record. Before we address the vexed issue of possession, we may notice that the suit property was subjected to auction in execution of a money decree, and the said sale was confirmed in favor of the predecessor in interest of the appellant. It is trite law that title in immovable property vests in the auction purchaser on confirmation of sale. That has happened in our case also. No doubt Order 21 Rule 95 provides for the procedure to take possession by an auction purchaser. But if the auction purchaser gets possession and is in possession on the date of institution of the suit, in our view, he cannot be denied injunction against a non-title holder seeking to interfere with his possession. Today, Milord, none of my learned friends is a title holder. Therefore, the question of possession on the date of institution of the suit was important for deciding the suit in question. Surprisingly, it appears a specific issue on possession was Surprisingly, it appears a specific issue on possession was not framed. However, where parties go to trial with knowledge that a particular question is in issue, though no specific issue has been framed thereon and adduce evidence relating thereto, they cannot claim prejudice for the issue being not specifically framed. In the instant case, it appears that the parties went to trial fully aware that the issue of possession is central to the suits. A perusal of the lower court judgment would indicate that they had taken notice of the documentary evidence which disclosed that there was a running factory and some documents pertaining to the factory reflected the name of the current appellant. In our case, there are electricity bills and other documents to show our possession. Besides, the first appellate court in paragraph 19 of its judgment has referred to various documentary evidence available on record to indicate the possession of the present appellant over the property. It is well settled that where a finding is written by a court and the same is assailed before an appellate court, the appellate court, if it is a court of fact, I do not trouble your lordship with those things. Then kindly turn to paragraph 24. In the present case, the second appellate court, that is High Court, has not at all adverted to the documentary evidence relied by the first appellate court in support of its order affirming the trial court decree. In fact, the second appellate court has not even framed a question of law, much less a substantial question of law, to test the finding of the first appellate court.
This is also
Yes. Then, 25, in such circumstances, where the matter is remanded back. So, the question which is
two things have been highlighted here. You have to show that you were in possession on the date when the
institution of the suit
or injunction was asked, at least.
Yes.
And that they don't have any right. A non-owner cannot dispute the question of
that the property has been sold to me is not in dispute. So today, Mr. Chakraborty's client cannot claim to remain an owner of the property. He cannot even challenge the sale, because of Bafna Motors and all. And my learned friends, on the left-hand side of Mr. Chakraborty, are not even projecting themselves as title holders. They are saying they are lessees or sub-lessees.
Chakraborty. They are claiming through Mr. Chakraborty.
Mr. Chakraborty has lost title to the property.
That is what you are saying. That
yes. And it's they
are lessees under Mr. Chakraborty's client.
They are claiming to be so. Post-mortgage, of course.
But the question of possession will be a disputed issue here. So
now,
whether you are in possession, you establish
can also be prima facie can be
clearly it has to be shown. Establishes possession, that is
can
very
take my reply, my affidavit in reply.
Have they shown any proof of possession? Their possession?
No.
That is what we are asking also.
Not a single document.
Because we have to balance the two.
Yes. Not a single document. Kindly take my reply, My reply to opposition of respondent number 5. Page 17.
The one where the photographs of the nervous, poor nervous security guards are there.
Oh, yes.
That one.
Oh, yeah, Shobi.
They are your security guards.
Yes.
Not very well paid. Will impose costs on it. Yes. Do they get this amount at page 9? Actually, inquire from your client. We have our doubts.
Yeah, these are documents, which clients had made over to us. I am not on annexure P1 even. I am on annexure P2 at page 17. Kindly have a look at the date of this document. Bill date, kindly have a look at 27th November 2025. And the status, the order which is impugned before your lordships today was passed on 1st December 2025. Can kindly see Milord. Let us kindly got the date.
Yes, energy charges 0.
Yes, after that demand charges is 141.
Demand charges is fixed.
Oh, meter, etc.
So you are not using that only for the purpose of showing possession.
I could not because of the resistance, which is why I filed the suit, because my ingress and egress to.
So then how can this prove your possession?
Meter has been installed in my name. The meter could not have been installed in my name without a field inquiry and without seeing that I am there in possession. So meter has been issued in my name, electricity meter, in November 2025, and repairing work, etc., was undergoing. When this resistance came and I filed the suit. The property was sold to me, in August 2025 only. And then this disturbance started. So I am yet to start using the property commercially.
August 25 sale.
August, yes, the sale took place.
And you took possession when?
I took possession. It's September 2025.
September, very good.
September 2025, page 81 of my stay application, when the desealing happened. Page 81.
Right. Very good.
Then the meter was installed, and kindly turn to the next page.
Yes.
The meter reading is same. The previous reading and the present reading is same. It's same. 139, 139.
Meter reading. Where do you go?
Previous reading and present reading at page 18 is same. Shows that there's no consumption.
Zero consumption.
Yes. Because I could not consume, I am yet to start exploiting the property commercially.
This does not show your position then.
The installation of meter shows my position. I am on that.
CSC installs the meter wherever they can.
Not in my
You leave
name.
your property for
I
5 minutes,
cannot
you'll find
have
a meter there.
meter installed in my
You
name
took
at my
electricity
learned
after.
friend's house. That I can't do.
If you keep standing and arguing for sufficiently long, you may find a meter on your chair. CSC does that. All these distribution companies. So wherever they find some space,
My
they
lord,
put a
will
meter
kindly
and-
call upon my learned friends at least to show a single
That
document
is what we
showing their
asked you also.
semblance of
That is
position.
very important.
Their semblance of position.
Very good.
Accepting the purported deed of lease, which I would
Meter is
immediately.
not always constructed within the house as such. Maybe constructed in a passage or some common space. We are not sure that
Milord,
merely
in
by
this-
virtue of this zero bill, you are in possession. In the absence of anything else.
The meter would not be installed assigning a particular premises number unless CSC is satisfied that
CSC is not an authority which has the
we
legal
often speak
authority
of
to decide
settled.
possession.
We often speak of settled possession when we
No,
do
that
not
is
get
for the purpose of the
electricity.
Electricity Act only.
Yes.
Mr. Banerjee, that ends there. That presumption ends there.
So I become
We are not
entitled
looking
to.
at an Electricity Act scenario.
No.
That is a prima facie possession.
Subject to correction.
That is always prima facie. That cannot substitute the
We
civil
were
document.
at the prima facie stage only before the learned code below. This is from an interim order. What I today want is that my ingress and egress is not restricted. My lord will kindly qualify.
Meter was not there in the property before you came.
I'm sorry, Milord.
Wasn't there a meter before you took possession? Must have been a meter there.
But then that meter is
Then it was transferred in your name.
Might be so, Milord, that is not known to me. But I see that.
So, because, Mr. Banerjee, we are telling you this. If that was in possession of somebody at some point of time, it was in their possession.
Yes.
After that, also in somebody's possession. So there must have been an electric meter there.
There has to be an electricity meter.
And Mr. Banerjee, we are telling you another second electric meter won't be put there, installed there.
No.
Unless the previous one is removed or
Yes.
new meter is installed or
The name is changed.
transferred.
The meter
Here,
is
obviously, since you obtained whatever changes from the KMC also, mutation, must have been the existing meter's name you have changed.
There is a procedure.
Which does not establish your position. I can have a change, I can have a mutation, I can have a prima facie, yes, but yeah, although we are at the prima facie stage, that you can say.
Yes, that is
we are
what
putting
I
the
was
worst
trying to
case
milord.
against you.
Yes,
I mean, otherwise we have a prima facie sufficient case, this meter mutation, but we are, because it is seriously disputed.
And Milord, these documents pitted against any document placed.
Also that they cannot, the Supreme Court judgment, that they are not in a position to challenge your.
They cannot say that, Milord, I have been, and Milord, what they were trying to say is, I was given, Milord, possession of the property unlawfully.
In an oblique manner, through the corporation.
So, Milord, they admit that, Milord, it's me who is in possession.
That's an alternative argument, Mr. Banerjee. Obviously, if possession was given, it
and
was
now
given.
before, Milord, DRT, they have said so.
Oh.
Before DRT, they have asked for restoration of possession. That document is today not there before your lordships.
Very good.
So they have asked for, my lord, restoration of
Electricity
possession.
bill 1, second your.
Now kindly have a look at page
What is-
81 of, my lord, my application,
Yes.
which was,
So
my lord,
these photographs you won't rely on these security
we
guard.
are. But, my lord, looking at my lord's, my lord, facial expression, my lord, I could
No,
not
poor
have the
people, I
courage.
mean, you look at their facial expression once. Please come to page 12 at our request.
Yes.
Please come to page 12 once.
My lord, facial expression of the persons, my lord, who are there in the
Who are there in the
photographs,
photograph.
and my lord's facial
No, no,
expression.
it's a direct.
My lord, I can make out nothing, my lord, out of my copy.
এটা দেখতে হবে।
দেখতে পারল না?
See their experience. They must have gone through whatever they must have gone through before.
Seems, my lord, they are troubled by them.
By them, by their own employers. Because the receipt is annexed at the previous pay. Their payment previous.
Oh, আচ্ছা, টাকা দেওয়াটা তো poorly paid. Poorly.
Yes, but they are still there. There's some proof. You have taken the photographs and they're there. And added with whatever you are saying, I mean, if they have made that such sort of an application there.
Now, my lord, kindly have a look at my stay application,
81.
page 81.
All right. 81.
My lord, I have shown, my lord, an electricity bill of November.
Hmm.
My lord, I have also submitted that, my lord, the property was sold to me in August. But, my lord, I could not get possession. Sale certificate at page 49 was on 21st of August.
Hmm.
Then, my lord, comes, my lord, page 81 from KMC. Kindly see, my lord, who is the addressee of this now.
Page 49 is the sale certificate.
49, my lord, is the sale certificate.
No, not of this.
Of, my lord, this document, this application only. But I may be wrong. I'll just
Oh, sorry. I was seeing, looking at the agreement.
the application. This is the registered instrument.
Page 59.
49. Deed of sale
Said
certificate.
deed.
My lord, the
Deed of sale certificate. The sale certificate is at page 59. Who? Whose phone? কে আমাদের কেউ? I'm asking. Yes, which page? 81.
page, my lord, 49, the sale certificate.
That is a deed.
My lord, they caption it as, my lord, deed of sale certificate.
And sale certificate, if you please come to page 59.
59.
What is that? That is a sale certificate.
Yes. My lord, this is not registered document. My lord, 49 is the
Yes.
registered document.
Yes, page
And my lord, page 54, once,
54,
my lord, with,
alright.
my lord, internal page 5 of the document starting at page 49. Which, my lord, my learned.
As is where is.
Yes. And, my lord, to possess, own and enjoy. So from banks.
TO2.
Yes. So, my lord, till such time, I was not in possession. I am not, my lord, shying away.
No, you are saying that. That is also your case.
Yes.
You're not
Then,
saying
my
that
lord,
simultaneously with this you got possession.
correct. Then, my
Your
lord,
specific case is to KMC.
after 80, page
Yes,
81, I got it. Then, my lord, page 81.
81.
My lord, this is addressed to me in September. My lord, this is addressed to me. Subject is desealing, and it says with reference to above, addressed to the assessor collector for desealing office premises. The caption premises undersigned has been directed to inform you, my lord, the appellant before your lordship, that municipal commissioner video order approval concurred upon honorable mayor has been pleased to accord kind approval for desealing of the office space under ward number such and such. Since officials of the department has an objection permission to take necessary measures for complying with the order of KMC, you are requested accordingly to make it convenient to remain present in the subject premises as per the given schedule. Kindly acknowledge in writing after the subject property is decided. So, my lord, the KMC has called upon me, has given over, my lord, the possession of the property.
Shouldn't they have given a notice to the person against whom the
My lord, then we are on legality of this document.
distant order was
My lord,
passed?
possibly
We have
Honorable
some
Supreme
form
Court.
on this.
Supreme Court says that, my lord, is not for them, my lord, to
Supreme Court situation was not exactly similar. I mean, this
even
sort of
worse.
in an oblique manner,
But we
possession
have a
was not
better
given.
case. We have a better case than the case, Milord, which was placed before.
There,
They
Supreme
are,
Court
Milord,
said,
through a panchayat, Milord,
no, there
settlement.
Supreme Court said that there was no issue regarding the how the possession was handed over.
Yeah.
There, the issue was that the person in your place had shown clearly that they were in possession when the suit
Through a
for
panchayat settlement.
when the injunction suit was filed.
Through a panchayat settlement.
Through a panchayat settlement, maybe.
And
Yes, through a panchayat settlement is different because there, panchayat settlement, that party was a party to the panchayat settlement. Here, there was no settlement with them. They did not come in the picture. The possession was taken. It's like the CWC taking custody of a child from the mother and giving it to the father. That was happening in the meantime, some days back. Instead of filing a custody petition, you get the CWC to take custody of the child from the mother or the father and give it to the other more affluent party. That was happening. Several writ petitions came to me in residuary. Yes. So we are not sure about these things.
But today that I am in possession is not in dispute because of the statement made in DRT, because of.
But that is not before us till now. That is not on record also. That's
not on record.
Unless Mr. Chakraborty, you also take instruction. You can't dispute if it's actually there because it's a pleading.
We'll do that.
You take instruction.
Even the documents annexed in the reply were not there
Oh,
before the trial court.
It's not there.
We
there
could
before
not
the
bring
trial.
the records because the matter is
There's
going
no
on
pleading.
today before DRT.
Today it's going. So take instruction from your client whether they actually filed that application, and if it,
Once 17 is filed, whether the statement is made or not, I'll personally check and come back. But none of them were before the trial court. None of them. In the reply, electricity bill,
you
nothing. No
understand.
pleading.
And now, Milord,
that is always available to you.
Milord, may I show the pleading also? Kindly have a look at the plaint once. Printed page tab also. Milord, 23 of my application.
This annexed to the application?
Yes, Milord.
Yes,
Page 23, Milord, the plaint starts. Kindly turn to Milord, page 26.
Yes.
Milord, paragraph 8 of the plaint. Owing to such default in payment of loan amounts despite receipt of the notice, issued notice taking symbolic possession, consequently filed an application under section 14 of SAFESI Act, thereby seeking physical possession. The said application under section 14 was allowed, and Milord, the secured creditor was permitted to take physical possession of the suit property with police help. So, Milord, section 14 order was there. Secured creditor could not take physical possession because of, Milord, the attachment by KMC. So, Milord, if I may, Milord,
must have been stated here that
that is not, Milord.
Because it's the plaint we have to look at. The Supreme Court looked at the plaint and said that
then, Milord, kindly take paragraph 11.
KMC chapter is not there in your plaint.
No, but kindly take paragraph 11. KMC কথাটা বলা আছে তারপরে. Yes, আসছে. Paragraph 11 at the foot of that particular page only. Plaintiff states plaintiff participated in auction, was declared successful bidder, sale transfer was confirmed.
Yes,
with
yes.
a date number. Then
Para
Milord,
14 mentions.
then 12 also, Milord. 12,
12
13,
also.
yes, 14.
Yes. 12 attach the entire procedure.
I say 13, Milord, mutation takes place. I
Right,
become
right.
the owner, then the property is, Milord,
Right.
made over to me. That is,
Stated,
Milord, my
stated.
case.
Whatever you are saying now,
Yes.
clearly stated in.
Yes. And Milord, this was from the ad interim stage. So, Milord, the plaint is what is, Milord, to be looked into. That, Milord, I am in possession. That is my case. So, Milord, having that case in hand, whether, Milord, the Honorable, the learned court below, or to have, Milord, confined the order only to, Milord, status quo, or should have granted me, Milord, a specific, Milord, order of injunction restraining them from, Milord, having my access to the property, free ingress and egress.
How is status quo adversely affecting you?
Milord,
Because I mean, it's not clearly defined who is in possession.
No.
Then how is it affecting you?
Milord, kindly have a look at the impugned order once.
You must have a cause of action for preferring a challenge, even if the entire order was not granted.
Yes. Kindly, Milord, have a look at the memo of appeal or, Milord, page 102 of the application.
Otherwise, status quo is in the nature of injunction.
Kindly see, Milord, this.
Yes,
Milord,
102.
Milord, findings returned.
Right.
Milord, before the concluding paragraph, kindly take last few lines of, Milord, the paragraph that started with, this is a suit for declaration and injunction. Last, Milord, 8-10 lines. The plaintiff purchased the suit property through auction sale as the highest bidder and paid all the dues. At present, the defendants are disturbing the plaintiff in its possession of the suit property. At present, the defendants are disturbing in its peaceful possession again, Milord, of the suit property, and they are trying to trespass illegally into the suit property. The defendants are also trying
This is your case. Your
yes,
case
yes,
has been
yes, 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 yes. This is my case, of course, my case.
started with the learned
Yes,
advocate
yes.
for that.
The plaintiff, therefore, by filing this petition, has prayed for an order of ad interim injunction in order to restrain the defendants. The plaintiff, in order to prove its prima facie case, has filed publication of the notice of e-auction sale, sale certificate, mutation certificate, receipt of complaint. Considering the above, I am of the opinion that the plaintiff has been able to make out a prima facie case in its favor. When the moment the learned court says this, when the learned court refers to the case made out by me as recorded in the preceding paragraph. So, Milord, now this becomes a prima facie case that I am in possession. Considering the urgency, both are directed to maintain status quo.
Obviously, there were these findings. Otherwise, no status quo.
Status quo, Milord, would have meant nothing then.
Yes.
Now,
How are you
kind-
aggrieved by this?
I'm
How are you aggrieved by this? We are also to be satisfied on that.
Milord,
We don't interfere at the drop of a hat just because it's
Milord,
a better order, a cosmetically better order.
Milord,
The language should have been better.
Kindly, Milord, see what I prayed for.
What is your grievance against this?
Milord, kindly see what I prayed for in the injunction application. I applied for, Milord, a specific, Milord, ad interim order of
Restraining
injunction.
them from doing what? Disturbing your possession?
From, yes, interfering with my possession, Milord, my injunction application.
Yes, restraining them from illegally trespassing into the suit property.
Correct.
So status quo covers that.
Kindly say so.
And particularly on the finding that
My lord, kindly
you are
say-
in possession.
My lord, kindly say so.
Why should you say so?
Kindly say so because below the status quo order is
Mr.
being
Banerjee, we are telling
yes.
you. Here it is categorically mentioned that plaintiff, in order to prove its prima facie case, has filed publication of notice. All these pertain to your prima facie case.
Yes.
And I am of the opinion that plaintiff have been able to make out a prima facie case has to be on your pleadings.
Yes.
So if you have pleaded possession, it's so you are saying
And that I have been able to prima facie satisfy me of the concerns of the learned
so
court
you
below
want
also.
clarity from the court that you are in possession and they are trying to trespass you. At least they cannot trespass you.
Yes.
If you are in possession is
prima facie established.
If that is prima facie established, in
Yes.
that context,
Then
if
Milord, they
status quo
must be
has been
restrained
granted,
from Milord trespassing into the
status quo
property.
covers that. That is what we are saying. Why do you require a
Status-
modification of that?
Milord, not modifications.
If I say you are in possession and parties shall maintain, not even parties. Yes, parties shall maintain status. You may be aggrieved with you being injuncted by a status. So that you
Status
may
quo,
say.
Milord, the order also does not
You
say.
won't be able to deal with the property. That you may say.
No, Milord, I'm not saying that. I'm not
You're
saying
not
that.
saying
As of
that.
now, but I do not
Mr.
want to
Mohoday is
deal with
saying
the
that. Take instruction.
बेचते चाहिए.
You won't be able to do anything with the
Oh,
property.
Milord, I want to Milord use the property, commercially exploit the property.
That you won't be able to do.
And
That may be a
state
grievance.
injunction a pay তারপর হবে. Status quo, it says Milord, status quo as regards possession, that is also not set.
So if we say that you are in possession, this means that you are in possession. That will suffice according to
Yes.
you. Let us hear Mr. Chakravarti. Yes.
And Milord, should I show Milord their opposition once? Milord,
For
what they have made out, Milord, as regards their possession in the
You
property.
tell us, I mean,
There's no document. Milord, only a
For
list
that.
it and Milord a title suit. Milord, which is between them, Milord inter se. I was not made a
that is
party.
their consistent case.
Yes. These are Milord my humble submissions. And Milord, the status quo, Milord, in a way stands in the way of Milord, my Milord user of the property in future also.
Not future till disposal of the injunction.
Yes. So, Milord, I am also, Milord, somehow injuncted, Milord, from
That
enjoying
is
the
what we are
property.
telling you.
That
That may be a valid grievance, but otherwise,
Lord, I personally, Lord, with greatest of respect, Lord, subject
to whom?
correction to Mr. Banerjee and subject to correction by your
we
lordship,
abuse
Lord.
him to your heart.
Subject to correction by your lordship, Lord. That Lord, the order records status quo, index for nature and character, possession and suit and of the suit property. Nature and character, possession of the suit property.
Nature and character
Unless
portion is what Milord
they
is.
say that they want to redevelop, reconstruct the property, it doesn't stop them from making any business.
They
If
may
a-
have a point, Mr. Chakraborty, in
Yes.
their application,
they
without
wanted
any
an
prayer from
injunction.
you, why should they be
They
restricted?
wanted an injunction. My lord, they wanted an injunction on the case made out on the plaint. Now, my lord, if my lord sees the plaint case, I have placed it on the last occasion, I want to place it again. But just 2-3 paragraphs, not more than that.
No, your paragraphs you have marked.
Kindly have a look at that, not for my satisfaction. If my lord kindly takes that once, my lord.
Tell us when you are satisfied. We can tell you that you have marked paras 7, 8, 10, 11, second portion, and 14. If you have something else for us to satisfy, you
No,
go
not
ahead
just-
with this portion.
Just to not explain what I'm trying to say, just give me 2 minutes time only. But para 7, they are saying that we failed to pay the requisite taxes and continuous non-payment, municipal authority proceeded to attach the suit property.
Attach is rounded.
Attach.
Attach is circled and seal the premises is circled.
Yes, now sealing the premises, I'll come to that,
That
not
has also
from
been
the
circled,
document.
yes.
Bus now. Now, para 8, they are saying 13.2, 13.4, and my lord, on the last
Right,
sentence.
your trust was on the last sentence and particularly was permitted to take physical possession.
Yes.
Was permitted
to
was
take
valid.
physical possession.
Yes.
So they got an order. I presume they got an order under 14. That's their pleading. The bank, the secured creditor, yes, the said application under section 14 was allowed.
Need not. Was permitted to take.
Allowed,
physical
was allowed, was allowed.
Permitted does not necessarily mean that they were given possession. By,
Permitted.
By
So
dint of
the
14.
secured creditor got an order under section 14. That is
Yes,
not the
yes,
last
yes,
sentence.
yes.
Now, then the next paragraph, 1 to 4 made an unsuccessful attempt. It's about us that we failed to challenge that order. Then 10, RARCL took further steps in observation of SURFACE and published e-auction. Then 11, he said plaintiff states the plaintiff participant said e-auction and declared successful. Kindly turn the page, Milord. Child certificate on August 21, 2025, registered office one. So then kindly see, thus plaintiff came to be absolutely seized and possessed. So on August 21, 2025, his case is he was in possession. If this is taken to be true at this stage, then the question of coming into possession through KMC or any third party agency doesn't come into the picture. 21st September 2025, August 2025, that's his case, positive case. He annexed the registered sale deed, sale certificate to show that he was in absolute possession. Then, Lord, and free from all encumbrances. So I was not there. I was out of the picture. So no question of any injunction, anything. If he was there on that day and his plain case, I'll show you, Lordship, when the cause of action has arisen. Then kindly take 12. Upon execution of the deed of sale certificate, plaintiff discovered that substantial property tax dues were outstanding in respect to suit property with Kolkata Corporation, and such basis concerned authority had attached the suit property. The plaintiff also paid such property tax dues pending against the property. Plaintiff states that plaintiff has got its name mutated in the name of records pertaining to the property, Kolkata Corporation. The plaintiff states that later dated 19 September, citing payment of already made towards property tax dues by an order dated September 2025, not within 1 month, August 21 he came, September 22, KMC desealed, deattached the property and delivered vacant possession.
This has to be read into paragraph 11 also, where they say that absolutely seized and possessed. Now, possessed could not
Free
be
from all encumbrances.
seized, free from all encumbrances, yes. But
Possessed,
yes,
so
right.
he is
But
running
in
a...
the same plaint, in the next paragraph, we have to read the whole together,
Yes.
harmonious, then all those
Yes, madam.
principles.
Yes. Now, in
Admit that subsequently they got physical possession through KMC.
they claim, I don't admit anything, they claim.
They admit in the sense that they admit that they subsequently got
Yes,
physical
not on 21st August. Not on
taking a cue
21st
from
August.
your argument.
Yes, not on 21st August.
Yes, that is
So-
their admission on their part.
Yes,
that they did not.
they are saying that on 22nd September, they got possession through KMC, delivered possession. Now, my lord,
So you are saying that they never got possession.
but
You don't.
I say that the
You are still in
KMC
possession
could
through
not have, I am in possession through my lessee, and KMC could have never given them possession. This is unknown to law, what is being read in the
So
plaint.
why do you say that?
Lord, I'll show your lordship the provisions. I have kindly take
It's
the KMC.
counterintuitive, yes. You take possession from someone and give it to someone else. But is there any bar in law to
Lord,
give it
there
to
is no provision. It is a statutory authority. They have to act within the four corners.
Yes, that
If
shows
they
the
are
four
not
corners.
kindly see, if they are not permitted, how can they take possession? They are not even permitted to do that. Lord, kindly take first note 214. My lords of the yes.
Yes, yes.
Lord, 214 talks about manner of recovery of taxes.
Hmm.
This chapter deals with payment and recovery of taxes, chapter 16. Now kindly see by save otherwise provided in the act, tax levied under this act may be recovered in accordance with the following procedure: by presenting a bill, serving a notice, by distraint and sale of defaulters movable property. Now kindly mark this. We are concerned with movable property, not with immovable property at all. I'll show that document on which he is relying. C, by attachment and sale of defaulters immovable property. D, then E, in case of property tax on lands and buildings, attachment due rent, but it doesn't apply by certificate under the public demand recovery.
There was never any attachment and sale of
The
a.
plain doesn't say that. Document annexed with the plain doesn't say that. Not
The distraint order could only pertain to the movable.
yes. Not I at this stage, not I. Your lordship would only look into the plain and the document annex there. Now kindly take my lord 215.
Hmm.
My lord may skip 215 manner. Then 216 talks about presentation of bill. Now, Lord, kindly take a situation. I failed to pay the tax. KMC 215 is the time how I should pay. 16 they will give me a bill. Now failure comes after I receive the bill. Then that is 217. Kindly takes 217. Notice of demand, notice, fee, interest and penalty. Save as otherwise provided in this act, if the amount of tax for which the bill has been presented under 216 is not paid within 30 days from the presentation thereof, or if the amount of quarterly installment property tax shown in the comprehensive bill presented under subsection 2 of section 196 is not paid after it has become due, or if tax on professions, trades and callings or the tax on advertisement is not paid after it has become due, the municipal commissioner may cause to be served upon the person liable to payment of the same a notice of demand in such form as may be specified. 2. For every notice of demand which the municipal commissioner causes to be served on any person under this section, a fee of such amount not exceeding ₹25 as the commissioner may determine by regulation shall be payable by the said person shall include. Then 3, on the amount of bill or portion thereof remain unpaid after 30 days. Now that's the point where I fail. 217.3. Fail 30 days of possession of the bill under presentation of the bill under 2016 or after the expiry of the date of payment as shown in the comprehensive bill presented under subsection 2 of 196. Simple interest at the rate of 3% above the prime lending rate of SBI as presented in the first day of January, particular calendar year, by the annual valuation of the less than rupees 1 lakh, 6% above such prime lending rates, so and so to be presented first quarter. Then we kindly turn the 4 person liable for payment of any tax fails to pay within the quarter of which the bill is presented on 216. In case of payment of property tax fails to pay the amount quarterly installment of such as shown in the comprehensive bill, such sum on not exceeding 15% of the so and so. Then we'll kindly take 219. Recovery of tax. Now I failed under 216. I could not pay under 217. Then 219. If any person liable to pay tax does not within 30 days of the service of notice of demand under 217 pay the amount due of such sum together with all cost, interest due and penalty may be recovered under a warrant issued in such form as may be specified by the corporation by regulations by distress and sale of movable property. Every warrant issued under this section shall be signed by the municipal commissioner or any officer under this. 220 distress. Here the notice is 219. It refers about 219. I'll take your lordship 219.1. It refers the notice annexed. Then kindly see 220. It shall be lawful for any officer or other employee of the corporation to whom a warrant is issued under this chapter is addressed to distrain wherever it may be found in any place in Kolkata, any movable property belonging to the person subject to the following conditions, exception, example. But A, B are the exceptions which should not be under distraint. Then 2, the person charged with the execution of the warrant in the presence of 2 witnesses forthwith make an inventory of the property which he seizes under such
It is
warrant.
entirely on movable property because distraint refers to movable.
Not only that, here there are modalities given. 220 subsection 2 talks about, my lord, seizure of movable property. 220 subsection 3 talks about, my lord, the commissioner may take out the seized property to the KMC office. And
Yeah, obviously,
204 talks about
the
may
moment you say
enter.
distinct, it
Now,
is
there is one
refers
provision.
back to
There is one provision. 220 subsection 4 says an officer or the other employee of the corporation charged with the execution of warrant, if he has reason to believe that the building contains property liable to be distant, may exercise his power to entry into the building.
that is for the purpose of seizing those.
Yes,
immovable property.
546. He will give me a notice.
That is not regarding the immovable property itself.
There has never been anything. Not after this act. 221A talks about, my lord, 221 talks about disposal of the distant.
Attachment and sale.
When you attach my movable property under 221, after selling the movable property, you could not secure the entire amount. Then you go to immovable. Here, the notice under page 69, but I'll stop here
The
for a
plaint
moment.
says about distraint, and the notice also says about distraint.
But here, kindly have a look at that. Page 69 top, distress warrant under section 219(1), where from he gets into the immovable property. But we are before a court of equity. দেখাবো পরে দিন এখন 4:30 বাজে।
Very well, very well. Since we have substantially heard both of you, please come prepared with a brief written note.
Yes, I'll
on the
come.
next.
But
We'll conclude and take it.
Today, they would have, otherwise I would have come ready.
You
But
make a draft of that, even if you can't file it on the next day because if something is added by the other side.
Yes.
It applies to both of you. Then we'll take it within 1 or 2 days thereafter.
Before my lords rise, my lord, may I just show one thing? I'll definitely show it to my learned friend also. My lord, he's he says that KMC has taken possession of the immovable property.
We are in an appeal against an ad interim order. Pleadings not made in the plain.
And that, my lord, there was no movable asset pursuant to the restraint order, which is why, my lord, the immovable property was caught hold of. My lord, he is the person who is concealing the document.
Mr. Banerjee is arguing, my lord, from his knowledge gathered from the client, not from the plaint. It's not stated in the plaint that they went to KMC, bank failed to obtain possession. Then they
if you speak of equity,
where is that?
Speak of the conduct also.
Where is that in the plaint?
This is what Mr. Chakraborty's client has said.
We are entering
on the next day.
We are entering in a very
copies for them also.
Yes, I have handed over
very dangerous territory. Tomorrow, what I'll do is, he's my tenant, not staying. I'll stop paying tax. KMC will come at us. I'll sell it to someone else. He will take the possession. This will become the trend.
That was what we were wondering also, because you take it from someone, you should return to that person, or unless there is something like a foreclosure sort of concept in mortgage. There may be a foreclosure by someone else.
Absolutely.
So we'll consider that on that.
But next Monday, maybe it will.
Yes. Hard in part for list the matter for further hearing on March.
Maybe Monday week, my learned junior would not be there on next Monday. I would be totally handicapped.
Yes, we will keep it on 30th. List the matter for further hearing on March 30, 2026.
We'll remind your lordship the moment the matter is taken up. On 30th. On 30th, we'll come with the written notes and we'll give it to your lordship.
Yes. Do that.
Grateful to your lordship.
Grateful.